Section 32 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 22. Gentlemen, allow me to contrast for a moment with these considerations, affecting how far you must judge the credibility of Mr. Littlefield concerning the conduct of Dr. Webster, some other facts. Would Dr. Webster, gentlemen of the jury, do you think, have done all that has been found to be done at that building, if he had been the perpetrator of this crime? Do you think he would have multiplied proof and made proclamations to invite suspicions upon him? That is unnatural. He would not have done what he never did before. Gentlemen, is it likely he would have scattered these remains in order that they might have been most readily found? That he would have made a fire so as necessarily to attract attention? Why, you find improbability starting upon the testimony of Mr. Littlefield. You find corresponding improbabilities in the conduct of Dr. Webster. And let me approach, gentlemen, those considerations which have the strongest presumptive tendency to manifest the innocence of Dr. Webster. First, gentlemen, where are the traces of crime? Where are the marks of blood in this laboratory? The physicians have told you the quantity of blood in the human body. Has blood been found? A half a dozen spots on the left side of the pantaloons, and 2 or 3 upon the slippers, which have been in that room for years. The medical gentlemen say they cannot tell how long those spots have been there. That is all you can find. These clothes have been where blood is sometimes used, as Professor Horsford testifies, and half a dozen spots are found, and that is all. Do you think they came from Dr. George Parkman? And except these traces, which might have been there before, there is not to be found the slightest mark of violence there. Now, gentlemen, there is no mark of violence, either of blood, of stain, or of instrument. Nothing. The knife which is found is untarnished. The Turkish knife contains no blood. The floor is not marked with blood. There is no indication of violence. And yet it is said that at noonday 2 muscular men met, muscular and strong though advanced in life. Dr. Parkman, a vigorous man and somewhat powerful. Dr. Webster, such as he was. That this mortal struggle occurred, that a mortal blow was given, and no blood was found, though the pavement was taken up, though the walls were searched, though the garments were ransacked, and no blood found, save what has been mentioned, what might have been there years before. The overalls were carried away, Littlefield says, and yet Horsford testifies he found them there after he came. The policemen used them for pillows. I do not believe they rested their heads on blood. Professor Horsford has examined them and he finds no blood. Is it possible that this crime can have been committed by Dr. Webster? Again, if it is done, is it possible that he has done it without preparation? He is a chemist. He understands this power of his over the human muscle and the human bone. If he had meditated this murder, he would have dissolved to liquid every inch of Dr. Parkman's body and bones, in proper vessels, cut up as it was in much less time than he had. And if he had contemplated this murder, would not the most effectual means have occurred to him? Would a man like Dr. Webster have been hacking and mutilating the remains of a mangled victim he had murdered, when he had by his side the means of destroying the identity in a few brief hours, or when he might have taken the key from the side of the dissecting room vault, cut up his body to pieces, opened the trapdoor and put it down where it would be unsuspected? There cannot be an improbability in my judgment greater than this supposition, that he could have committed the murder without destroying all traces of the body. It overcomes theories and hypotheses and conclusions and deductions from these surrounding and, as the government think, overwhelming masses of circumstantial evidence, which are met by the fact that there are no marks of violence, no proofs of crime, and a total absence of all means of destruction which he could have used, while on the other hand, the imperfect, incomplete, insufficient effort to destroy a part of this body by putting potash upon it and holding it over the fire, showing the work of an unskillful man, proves that it must have been an unknown, inexplicable being who did the work, which the government are now seeking to impose upon my unhappy client. Nay, more, gentlemen, nay, more. These improbabilities that Dr. Webster could have done this thing grow stronger and stronger. The more evidence is presented for your examination. At every turn you take, at every movement of advancement, these improbabilities are multiplied. Follow Dr. Webster from that place. See him with his family that evening. The first part of it is spent as usual with his wife and children. Then see him accompanying those children to a neighbor's family hearth, then going by himself to Professor Treadwell's and spending 2 or 3 hours in social conversation. Not absent-minded, not full of fits and starts, not frightened at the sound he has made, but self-possessed, calm, social as usual. Were ever human nerves made that could do this? I pray you, Mr. Foreman, I pray you answer me. When life is jostled, even when some little event occurs in our daily walk, a disappointment in our affairs, the treachery, it may be, of a friend, the outbreak of some calamity falling upon us, our families, when we return to the fireside, note that something has happened, will not the tender and observing wife say to her partner, "What now? What cloud upon your brow? What fever in the brain? What anguish at the heart?" Do the children, loving and devoted children, watch and note the first variation in the parent's smile, in the parent's cheerfulness? And can it be that Dr. Webster should have committed this daring, atrocious, unspeakably great crime, and have then been with his wife and children and friends unmoved, unaffected by the issue which has been charged against him? To be so, he was more or less than man, but, like you and me, he was a man. I pray you, gentlemen, weigh this, weigh that, when you are considering these circumstances. The next day, in the morning, he was about to visit the family of Dr. Parkman, because the night before he had seen in the public papers, which I might produce here, but the fact is too well known. It is unnecessary. He had read in them that George Parkman was missed, having had an appointment with an unknown individual, so that Dr. Webster knew that the friends, the family, and the community did not know where Dr. Parkman was. He had but to keep silence if he had committed this crime, and he had every reason to believe that universal darkness would rest upon it. And yet, gentlemen, with that full knowledge, but with the conviction that the crime had nothing to do with him, he comes to Boston for the express purpose of making known that he was the man. He saw Dr. Blake first and told him. He saw Dr. Francis Parkman and his family shortly afterwards and told them. Yet, gentlemen, all these communications are now to some extent turned against him. Mr. Blake has represented that Dr. Webster exhibited something of agitation. Dr. Francis Parkman has, on the contrary, represented something of over-coldness. With one whom he held by the hand, he seemed too warm. With the other, oppressed with affliction himself, not at the moment in the best state of mind for observation, too cold and formal. And both the warmth with one friend and the formality with the other are now circumstances brought against him, under which Dr. Webster is in danger of suffering, unless that danger be avoided by the calm and sober reflections of the jury. That is to say, they are to judge upon a new case in the affairs of men. How to treat relatives in such a sense, I think no man can tell. Dr. Webster came to tell his story, and he told it as well as he could. And I submit that no prejudice is to come to him now, because Mr. Blake thought him too warm, or Dr. Francis Parkman deemed him too cold. go with him further, and you find that he called on the city clerk at East Cambridge and found that the mortgage was not cancelled, went to his study, was found there by the police, went home, and was lecturing to his class on Tuesday, while these bleeding monuments of crime were just, as it were, by the side of him. Can it be so? From day to day, gentlemen, his avocations show him receiving his friends, visiting his friends, occupying himself at home, calling at Fuller's and writing the check, and speaking of Dr. Parkman, being at the apothecary's where he is told the story of the cab, at the Tin Man's where the box is ordered, and where he speaks of the story of which he has been told everywhere, entirely easy and unaffected, and all this time, as they say, this forlorn man, if he be the villain they say he is as calm and quiet as his brethren of the profession, and as clear in his mind, and regular in his actions as the sun in the morning. Gentlemen, it is not possible. On Friday, the 30th of November, he was with his family. In the evening came the officers and ministers of the law. They came, indeed, without authority, perhaps without authority which could wholly vindicate them, but in the belief that they had the right to make the arrest, acting doubtless in perfect good faith. The ministers of the law, Clapp, Starkweather, and Fuller, went to Dr. Webster's house to make the arrest, on the discovery of the remains in the vault. Dr. Webster is found tranquil. Mr. Clapp, who knows him, addresses him, and tells him that further searches are to be made at the medical college for Dr. Parkman, and he is required to aid. Very well, said he, I will go, as candid as you or I could be. Let me step in and put on an outer garment. As they were entering the carriage, he said, Stop a moment. I have left my keys. I will get them. No matter, says Clapp. We can get in very well. They enter the carriage. A free and easy conversation takes place. They speak of Dr. Parkman. Dr. Webster speaks freely on that subject. The conversation changes. They converse on other topics, the railroads, and so past Mrs. Bent's. Her place is spoken of. They keep up a calm and quiet conversation all the way to Boston, and this on a representation that these officers had made, that they were going to search the medical college. Now, suppose that Dr. Webster knew that he had committed this crime. If he had committed it, he knew it. His rooms have been twice searched. He finds 3 officers come late in the evening to search again at that time of night. If he had been guilty, do you think, gentlemen, that his nerves would have outborne him then? I know not the man that has the power of resistance under such circumstances. Innocence could have carried him through. Guilt would have prostrated him, because guilt would have assured him that he should be carried to the exposure of his guilt. And yet he moved as calmly and as tranquilly as when he gathered his family around his daily table. Allusion was made in the conversation which we have mentioned to the discovery of part of the garments of Dr. Parkman. They passed the second street leading from Cambridge Street. Dr. Webster says, You are going wrong. You are past the street to the college. Mr. Clapp says, The driver is a green fellow, but I guess he will bring us up right at last. Dr. Webster is still calm. They reach the jail. Mr. Clapp alights and asks the gentleman to descend for a moment. They enter the jailer's apartment. Mr. Clapp enters the inner apartment. They all enter, and then Dr. Webster looks round in the dim darkness of the jailer's inner room and asks, What does this mean? Mr. Clapp replies, It is no longer of any use to impose on us. The body of Dr. Parkman has been found. We have been sounding round the medical college. We shall search no more, and you are arrested as his murderer. Dr. Webster started back with a simple exclamation. What, me? Yes, you. His voice sank as his heart did. He attempted, said Mr. Clapp, to articulate. He began to speak to me something about the crime, and I told him not to speak to me of that. He waited a little while and asked that his friends, most respectable Mr. Dexter and Mr. Prescott, should be sent for, And I said, they cannot see you tonight. Here is the man deceived. He knew he was deceived. They told him one thing and meant another. No matter that it was for good and honest purposes, it did deceive him. And when he spoke, Mr. Clapp stopped him and said, don't speak to me of your crime. Then said Dr. Webster, let my friends speak for me. No, replied Clapp, you cannot see them tonight. And he became as a child at its mother's breast, helpless, hopeless, and he exclaimed, my children, what will they think of me? Not, how shall I escape, but, my children, my children. He was left in this condition. A minimus was put into the hands of the officer, and he was alone, in faintness of body and feebleness, bowed and overcome as he was by the deception which had been used upon him. His faculties disordered, his mind broken and shattered by the shock which I know not how any man could bear. He spoke to Starkweather, who responded, don't ask me, it isn't proper for me to tell you. And he sank back in his chair, scarcely able to sustain himself, while a few short ejaculations fell from his lips, which instantaneously were put down on paper, and the very words he uttered in that state, awful, overwhelming, cruel state of mind, are brought here by that officer in detail to you, to work out his conviction, closing with this most significant language. No person has access but the porter who makes the fires. In answer to the question put to him, then he exclaimed, oh, I am a ruined man. Language put into his heart and understanding, and almost into his lips. This police officer calls his attention to the man who had access to his room, and Dr. Webster, under this affliction, overwhelming and ruinous, was pointed to the janitor by the police officer, who did not tell him that he was wrong when he asked him, who has access to your rooms? And the exclamation followed, I am a ruined man. As if he had said, here I am under arrest. They will not suffer me to speak. They will not suffer me to see my friends. There is a charge upon me. I not know on what it rests. I have been deceived. Oh, my children, what would become of them? It occurs to his mind on the question put to him by the police officer, who has access to your room. I am a ruined man. Is that confession? After such a conversation as that and under such circumstances? Will you say that the government have the right to consider such a confession possible? Go with him one step further. Mr. Parker comes to see him. The prisoner, careless of his position, weeps for his children. Mr. Parker says to him, another family have been in distress for a week past, and silence only follows. Silence, only with some slight exclamations from the prisoner. Yet he willingly accompanies the officer to visit the scene of the alleged murder. His rooms are broken open, and I call your attention to one great fact. He was helpless nearly all the time, from the moment that this great charge was made, but from all the witnesses who have it in testimony that, if he became calm for a moment, it was not in the inner but upper laboratory. Remember, gentlemen, the occasion when he became calm. Remember that at that time the remains had not been exposed to Professor Webster. He had not been told where they were or where they were to come from. But then he was most composed. And when was that? It was at the time, gentlemen, that they were asking for the key of the privy. Professor Webster did not know that any hole was dug, if conscious of guilt. When they asked for the key of the place where he had secreted these remains, would he have been calm almost at that moment alone? A wrong key was tried and brought back to him. He then said, that is the key of my dressing room. There, gentlemen, was a moment of calmness. That was at the very place and time when, according to the theory of the government, they were to go to the identical spot where Dr. Webster had deposited these remains. Yet he was calm, comparatively. He went below, and the fit was on him. And, gentlemen, from that state and condition in which he was, he did not recover again. He said no more. He was overcome. He was a victim of circumstances. He was unmanned. It would be as unjust to take the falling word from his lips at that time as it would be to go to the houses of the insane and ask for the ravings of the maniac and carry them to the courthouse, that the victim might be sent off to an ignominious execution. He was carried to the carriage and fainted. Mr. Andrews said a kind word. I felt that it was so when the witness was upon the stand, and I thanked the sheriff for having a keeper with so much feeling. He spoke a kind word to this suffering prisoner, but he was scarcely conscious of it. A few broken sentences escaped him. You pity me. What for? Because of your excitement, was the reply. Oh, that is all. And he subsided again, and said not another word. His night was cheerless, his cell solitary. It was but an indifferent place to a man whose mind was so harassed and his feelings quenched. The next morning he was found in the same overwhelming prostration. A few hours partially changed him. He awoke to new life, and, with the little strength that he had in the first moment of dawning reason, from this night of darkness and agony and shame and mortification and distress, with the first dawning light of reason, he uttered in simple but expressive language the whole of his defense. I do not believe, said he, to a man whom he was, for the first time in 60 years, to call his jailer. I do not think that these are the remains of Dr. Parkman, but I am sure I don't know how in the world they came there. Gentlemen, that is his defense. He cannot tell you how they came there. He asks you, gentlemen, to give care and scrutiny to those surrounding and pressing circumstances. He asks for leave, under the aegis of the law of his country, to present himself with that reputation which 60 years of life has given him. He brings the community around him, from the president of the university to the mechanic at his bench. All classes cluster around him and tell you what he has done. And gentlemen, it is the rule of law that in cases of doubt, where evidence is complicated, where it is uncertain what conclusion shall be drawn from these mystifying masses of circumstantial proof, it is then that the toil and the virtue of life come as a protecting shield, to say that he who in life has embalmed virtue shall at the last be saved by it. His character is here. He brings it and lays it before you, and with it he brings all that he has done within and around and near, these awful remains of death and of mutilation of the human form. He implores you to weigh them well, and he asks only that your consciences, when your last day's work in this court shall be done, shall be pure and free, that you shall have given way to all his objections to the evidence of the government, that you shall look to this alibi, which appears overwhelming in its accuracy and positiveness, that you shall save him in the hour of his affliction, to return to the world again, and yet arrive to that humble home, of which no voice can adequately tell the sorrows that now sit there, or the joy that may yet be imparted to it. God grant him in this day of peril a good deliverance, and may he grant it to you also, that you shall never reflect upon your final determination here, but with inward peace and inward satisfaction that shall sustain your life and crown you at the last in death. End of section 32. Section 33 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 23. The Attorney General's Closing Argument, March 30th. Mr. Clifford, in a cause, gentlemen, of the magnitude and the interest of the one now before us, I expected, and doubtless you expected, that everything which human power could bring to bear upon it, in order to exonerate this defendant from the charge which the grand jury of this county had preferred against him, would be done. That all that professional fidelity, all that professional skill and adroitness, all that human eloquence and ingenuity could possibly advance in his favor would be done. And gentlemen, in that expectation I have not been disappointed. The transcendent ability which characterized the closing argument in his behalf yesterday shows that whatever conclusion the evidence in this case may compel you to come to, there has been nothing left unsaid or undone, which consistently with the truth could have been said or could have been done for this prisoner. But gentlemen, I had, for not another expectation, at least another hope. I expressed it to you when I opened this case a fortnight nearly ago, that when the evidence which the government had to array here before you against this unhappy man should have been all presented, I did hope that he could furnish some explanation of the terrible circumstances which had weaved round him a web that seemed to be then irresistibly contracting to his doom. I expressed that hope, gentlemen, I may say, with the sincerity of a compassionate heart. I expressed it as a citizen of this commonwealth of ours, who feels an interest in the great interests which are represented by him. And I grieve to say to you that after all that has been done and all that has been said, that hope has been utterly disappointed. Why, gentlemen, I call your minds back to the statement with which this case was opened, a statement of what the government expected to prove, made, I submit to you, as I submit to the world, with a degree of moderation that indicated how sincere that hope was in my bosom. I call your minds back to the statement of the outline of the proof which I expected to put in here, and I now ask you, upon your conscience, to say whether that outline has not been entirely filled up, whether a single statement was made which has not been proved, whether the inferences which I then forbore to draw from those facts are not now pressing upon your minds with a force that cannot be resisted. I ask you, then, to consider how all that evidence has been met. We have awaited long days and weeks and months for an explanation of these facts. This prisoner, although he has been the inmate of his cell, has not, you know, gentlemen, been, in the language of his counsel, a forlorn and forsaken man, unaided and unable to prepare himself to meet the testimony of the government. No, far from it. He has not, as my friend, the opening counsel, asserted here, been compelled to sit by, the victim of prejudice in the public mind, arising out of public rumor, and waiting patiently till the day of his deliverance should come in a court of justice, by making his explanations and showing his proof. A victim of prejudice, gentlemen? I put it to you whether that statement has any foundation here. I ask you whether the very opposite state of things has not existed in a degree unprecedented in our history, whether there was ever a man against whom the prima facie proofs that had met the public eye had sunk down so deeply into the public heart, who has had such forbearance shown him. There has been, from beginning to end, a degree of reluctance that is unprecedented to admit the possibility of his guilt. Gentlemen, it is a strange and eventual history which we can now look back upon, from the time that these mutilated remains of George Parkman were found in the premises of the defendant. Aye, and under his lock and key. It was the subject of an examination before a coroner's jury, which was secret. But, gentlemen, his counsel here will do me, as the representative of the government, the justice to say, or to assent to what I say, and before this evidence, which was taken down before the coroner's jury, had been read by me, before I ever passed my eyes over its pages, it was placed in their hands for the purpose of enabling them to meet everything that was contained in it, and prepare their client for his defense. It does not, let me say to you, lay in the mouth of this prisoner or his counsel to come here and complain of any course which has been taken respecting him or his case. Never, I venture to say, was a man put upon trial for a crime that affected his life, who had received such a consideration from the government representative as he has received from me. I am not aware that there has existed a single fact that has not been fully communicated and freely exhibited to the counsel for the prisoner, to enable them to investigate, explain, and answer it, that when they came before a jury of their country, they might be enabled to say, "We have known everything that the government have to prove. We have prepared our answer. We can explain. And here is the explanation." Gentlemen, so it has stood. And when allusion was made to the fact of his being in that cell friendless and unaided, that there had been a secret inquest when he was not present, that there had been afterward a secret investigation by the grand jury where he was not represented, did it occur to you to reflect as that statement was made by the counsel, that between those two investigations there was another occasion when he was present, when he was represented by the ablest counsel that the ablest bar in New England could furnish him, that he then, either with or without their advice, chose not only to keep his own mouth shut and sealed, but to say to the government, to say to the world, "I am content not only not to offer proof in exculpation of myself, but I am content not to ask even for what proof there is against me." Gentlemen, between these two investigations, which have been the subject of almost a complaining and reproachful remark, this prisoner was brought into this building before another tribunal for a preliminary examination. And gentlemen, while there, upon the supposition that he was entirely an innocent man, intelligent as he doubtless is, what, gentlemen, would have been his course? Why, to demand of the government to show their proofs. I put it to the consciences of every one of you, if you were seized by an officer of justice and were brought up upon the most heinous and revolting charge that could be made against a man, would you not turn round, after you had had 24, yes, 48 hours of reflection, and time to recover from the first shock with which it struck you? Powerful, even as the counsel has represented, though that first shock may have been, I put it to you, whether you would not have demanded that the government should show the proofs upon which they attempted to charge you, an innocent man, with a crime like this? Would you have said, "I care not whether with the advice of counsel or without it. I am content to go into close confinement, to wait until the government shall find its convenience and its pleasure to try me, and to suffer this good name which I have been building up for 60 years, as the counsel have told you, to be blasted, and the whole civilized world to have that name upon its lips, in terms of reproach and execration, to leave my family to suffer the torture and suspense and agony which must attend a charge upon a parent and a husband, like this, remaining unexplained and without an attempted explanation? It has come to a point of consideration in this case that such a fact as that existed, and more than that, gentlemen, the time has come when that explanation was to be made, when passion was to subside, when he was to enter a court of justice and feel that, before a jury of his country, he could be secure. And now, what is that explanation? I call your attention to the fact that the evidence which he has put in here applies to but 4 propositions, and I call your attention to the further fact that upon that evidence, such as it is, have been founded 4 hypotheses, put before you by his counsel, and it is my purpose to put these 2 things together. In the first place, in answer to all the evidence which the government has produced here, he has called the witnesses to his character. That is a point that never was in controversy, namely, that he had an outside reputation. How well founded in his real character the other evidence in this case must determine, to a considerable extent. The second point has been an attempt to show, I am now speaking of the evidence he has offered here, that for him to be locked up in his laboratory is not an unusual thing. An attempt from one witness, which has entirely failed, and which has been met by other testimony, independent entirely of that which has received the harsh comments of the council. The first was the witness to the character. Second, the attempt to show that his being locked in his laboratory was not an unusual thing. One witness only to that, Mr. Eaton, the painter. The third attempt was to show his own conduct and his whereabouts during the week which intervened between the disappearance of Dr. Parkman and the finding of his remains. That is the third proposition, as offered to be supported by the proof to which the evidence applies, and this case is to be tried upon the evidence. The fourth proposition is an attempt to answer this whole case of the government by showing that after Dr. Webster and Dr. Parkman were together on the 23rd of November, Dr. Parkman left him and was seen abroad in the community after 2 o'clock of that day. This is absolutely all. Then, upon that evidence, there has been an attempt to raise certain hypotheses, which I shall have to consider in another connection, but to which, when I do come to consider them, I shall ask you to apply the evidence in the manner that I have indicated. Now, in a state of facts like these, as presented to a jury of the country, I think there is one proposition which cannot escape our notice. The Constitution and government of this Commonwealth has, as its highest object, as it is the highest object of all organized civilized society, the protection of human life, and under that Constitution and government, we have a system of law which is intended to carry out that purpose. If a case has ever arisen which is to test and try the value of that Constitution and of that system of laws, it is the case now before us. And if ever the great and high responsibility of applying that test was confided to human minds, it is now confided to you. Why? How does this case stand upon the proof? It is not all the charge attempted to be answered by the fact that Dr. Webster, this prisoner at the bar, moves in a different sphere of life, that he has been subject to a different influence, that he has had a different experience from those who are ordinarily seen in the prisoner's dock. We are now to know whether the law under which we live is or is not, like that divine justice whose character is our law's humble function, to imitate and follow, whether it is a respecter of persons, whether it is competent to hold the weak and impotent in its grasp, but is itself impotent when the high, the influential, and the powerful are charged with its violation. It is an old complaint, gentlemen. Plate sin with gold, and the strong lance of justice hurtless breaks. Clothe it in rags, a pygmy straw can pierce it. But I thank God that we have here a state of society, a system of law, a sense of justice, to which no such reproach as that can be applied. Why, is there any doubt that George Parkman, the original proposition with which I started before you, when we commenced this case, at George Parkman, a highly respected, almost universally known citizen of this metropolis of New England, a man of large affairs, a man of extensive connections and interest, has been murdered? Aye, and by a most remarkable coincidence. Is there any doubt in your minds now, after hearing all that has been said by the prisoner's counsel, whether he were the perpetrator of it or not, that Dr. Parkman was murdered in the building of an institution which owed its erection to his munificence, that in the ordinary avocations and business and intercourse of life he went out from his home to meet his sudden and fatal doom? And, gentlemen of the jury, if that fact be established, no matter who is the perpetrator, if the laws of Massachusetts are impotent to ferret out and detect and convict and punish the perpetrator, then the sense of security and of safety, which belongs to us as the members of a civilized society, is gone forever. We had better go back, as we shall certainly be driven back to the state of anarchy and of barbarism, in which every man's wrong is avenged by his own right arm. And now I come to consider the improbability that a false accusation should be made against a man like this prisoner. Thousands of eyes, gentlemen, since that fatal event, which struck into and startled the heart, not of this community alone, But if the whole civilized world had been opened, every circumstance has been weighed, every man has been watched, and the vigilance of our police, the keen eye of justice, stop here. If that be a false accusation, that of itself is another marvel and miracle, greater than any that has been presented as a mystery by the prisoner's counsel. The complaint has been here that there has been no direct evidence, strong as the counsel has admitted this mass of circumstantial proof to be. No direct evidence that the fact charged against this prisoner is true, that the act committed by him, as charged in this indictment, was witnessed by any human eye, and that that witness has come here upon the stand to say so. Gentlemen of the jury, how many murderers think you have been punished, or ever will be punished, if a jury are to wait until direct evidence of an eyewitness is to be furnished to them, in order to remove all reasonable doubt from their minds? What degree of security will there be in society? How can we go to rest upon our pillows, feeling that the law gives us any protection, if a position like that is to be maintained? When crimes like these are to be committed, you will consider that men take no witnesses with them. They avoid the sight of all eyes, but that all-seeing eye, which sees in the darkness as in the light, but which they then forget. Let us consider here for a moment what the nature of this evidence is. Having considered its nature and character, and having furnished such authority on that subject as seems to meet and control all the suggestions which have fallen from the learned counsel in relation to it, I shall then state, in a brief and I hope intelligible manner, the law is applicable to the offense itself, and to the indictment which charges it. I shall then endeavor to proceed to satisfy your mind that no other person than this prisoner could have committed the act, having in the first instance considered the evidence that the act has been committed. I shall ask your attention to the evidence which goes to fasten and fix the charge upon him. Now, gentlemen, what is the nature of the evidence upon which you are to arrive at your conclusion? It is circumstantial. So I think it must be said is almost all evidence. We are not here, gentlemen of the jury, dealing with or expecting to find absolute verities, pure, absolute truth. That, gentlemen, belongs not to fallible man, but to the omniscient and infallible God. And we are here to exercise such instrumentality as, under our system of law, and in our state of intelligence, we may be able to use for eliciting the truth. And when we have arrived at a conclusion, through whose instrumentalities and our reasonable doubts are all removed, then, our minds being satisfied, even if we err, no such terrible consequences to us can follow as have been shadowed forth in the argument of the opening counsel. What is circumstantial evidence? Is it so much less satisfactory and strong than the positive testimony of a witness? Why, gentlemen, the testimony of a witness is not dependent entirely upon his integrity and veracity. The value of it, certainly, is not entirely dependent upon these. It is in no inconsiderable degree dependent upon his intelligence, his powers of observation. But if there is a class of facts existing which, combined, lead the mind by the stern and inflexible chain of logical sequence to a necessary result, the mind must give to it its credence. Let me, in much better language than I can use, and with a wisdom which I may never hope to equal, give you the exposition of this matter, from one of the ablest and most learned judges now gracing the bench of a sister state. I propose to refer the court to the cause of the Commonwealth against Harmon, and the charge of Chief Justice Gibson in that case to the jury. It was a capital case, as this is. It was a case of great interest, of a mother for the murder of her child, and the Chief Justice of the Commonwealth of Pennsylvania, who is now an honor and an ornament to the bench, in charging the jury, addressed them upon this subject of circumstantial testimony. End of section 33. Section 34 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 24. I now come to the consideration of points of law upon which I shall address myself to the learned bench in your hearing. They were all involved in the inquiry which you are now making. The ground that we take, may you please your honors, upon the law, is established upon well-settled principles of the common law, as recognized in the case of Peter York, and subsequently affirmed by this court in the case of Washington Good, and more recently in the case of Knowlton. Unless it appears, by a preponderance of the testimony, to have been done under reasonable provocation, such as the law recognizes, malice is to be presumed. And malice being presumed, whether there is express malice shown by the proof or not, it is murder. Then, gentlemen, the distinction that was taken and very properly taken, and upon the authorities fully illustrated by the opening counsel, between express malice and implied malice, I do not intend to go over, because I entirely concur in every proposition stated to you on that subject in regard to express malice. If you find there was anything of premeditation with regard to this prisoner, that ends the inquiry of this case, that fixes it by all the authorities upon the very ground taken by the prisoner's counsel to be a case of murder. But if you should not be satisfied of that still, the law presumes, in the absence of any controlling proof, that there did exist the other species of malice, namely implied malice. Therefore, it is quite immaterial, in sustaining this charge against the prisoner, whether the jury is satisfied of any proofs of the premeditation or not, unless they are, on the other side, satisfied upon the proof that when those two men came together, there was not merely exasperating, irritating, and provoking language, but that there was, on the part of George Parkman, a provoking blow, which led to another from the prisoner, that was fatal to his adversary, because, upon this matter of implied malice, the provocation which the law recognizes cannot be a provocation of language, no matter how exasperating, how irritating it may be. Therefore, if exasperating words were used, and a sudden blow was given by the prisoner with an instrument likely to cause death, then, gentlemen, he is as much guilty of murder as if he had prepared and planned it for months before, and beguiled the party to the place, and there carried into effect his previous premeditated purpose. Hence, we take no exception to all that matter of law put into the case, and I only refer to it now to say that you must have felt, as I did, a painful disappointment when this case was opened by the defendant's counsel, that, while we were anxiously looking for an explanation of facts, we had the extraordinary spectacle of the counsel for the prisoner devoting 2 hours and 5 minutes to the discussion of the law, and 10 minutes to the presentation of the facts. All the nice subtleties and refinements of the law of homicide, about which there is no controversy, and in which I agree fully and entirely with the learned counsel, were gone into with a degree of clearness and ability which marked the accomplished lawyer, and were presented for your consideration to avoid what seemed to me the unfortunate and meager array of his store of facts being exposed to the jury. But, gentlemen, that exposition had to come. I have already adverted to the classes of facts upon which he relied. Exception has been taken, gentlemen, to this indictment, or rather, perhaps I ought not to say that. I do not know as exception is taken to the indictment, but although it is said that the government may charge in the various modes in which they have charged, in the first 3 counts, a homicide committed by the prisoner, yet they are bound to prove, in this case, to the entire satisfaction of the jury, that the homicide was committed in one or the other of those modes, and that the 4th count of this indictment in which the grand jury had charged upon this prisoner that by some means, instruments and weapons to them unknown, he did commit murder, is not such a count as can be sustained in a court of law. Gentlemen, if that were so, we ought to have been saved the long and anxious labor of this trial. If that were so, and the law were open to that reproach, I think this learned bench would require that very conclusive authority should have been produced to satisfy their minds of the imperative duty so to rule. Why, take the very illustrations of the counsel here, and I could not conceive of more cogent and effective ones. Take the illustrations which we presented in support of that monstrous proposition, that if a man is so scientific in his deeds of blood as to be able to conceal the mode or the means by which he consigns his brother man to a sudden and violent death, although the fact may be proved upon him as clear as the daylight, he cannot be punished under the laws of Massachusetts. That is a most extraordinary and monstrous proposition. It may be that this honorable court may say that this is the law, but the illustration showed us to what such a construction of the law would lead us. Why, it is suggested that the lasso might have been cast around his neck. Was there any evidence before the grand jury which could justify them in saying, upon their oaths, that this was the way in which the murder was committed? It is perfectly true that a galvanic battery might be so prepared as that, when a man is walking over the wires, he shall be prostrated and deprived of consciousness. But we must have evidence of it. The plain proposition is simply, as laid down by Hawkins, 23rd chapter, 84th section of the second book, that, in drawing an indictment for murder or any other capital offense, the pleader must set forth the nature of the facts as specially as the circumstances will admit. Now, if it was known to the grand jury how the act was done, of course they must set it forth. If they should undertake, through their accompanying officer, to charge that the homicide was committed in a way and manner to them unknown, and afterwards, when the party is put upon his trial, it should appear, and it might appear, but the jurors may be called to testify to such a point, that he was stabbed or strangled or his life destroyed in any other way, and this was known to them before the indictment was drawn, then it could not be maintained, and that is the protection of the prisoner. The nature of the facts would not have been in such a case set forth especially as the circumstances admitted. I will give you but one illustration, and I submit it to the honorable court as an evidence of the absurdity of this proposition. I derive it from the case itself. Suppose, may it please your honors, that Dr. Webster with premeditation had enticed Dr. Parkman into his laboratory, and had there, in a scientific manner, in some way to the jurors unknown, and also unknown to anybody and everybody, murdered him, and had succeeded, in the mode indicated by the counsel, in the space of 8 hours, in destroying every vestige of that body, by acids or in some other way. And suppose that 4 most respectable professors of that institution found the clothes of Dr. Parkman, he having been seen to enter and not seen to come out of Dr. Webster's room, and his pocketbook taken by the prisoner from Dr. Parkman, in the possession of this defendant, and no vestige of his body. Then Dr. Webster says, taken by surprise, I murdered him, but do not betray me. These professors thereupon take him into custody. Not another word is said. Then, when he is advised by counsel, he retracts his confession, and there is no evidence how he killed him. According to the monstrous proposition of the counsel for the defense, he might have walked the streets of this city and shown himself anywhere, free as the air, throughout this commonwealth of ours, and the law could not reach him. Now, if that is the law of this land, it is time it was altered. No, it is not so. Gentlemen, I shall maintain here before you that if you are doubtful, and I bet you may well be, whether he died by a blow on the head by a hammer or a stab from a knife, if you are doubtful how it was done, by what means or instrument, and yet if you are satisfied that Dr. Webster was the perpetrator of the homicide, that he did deprive Dr. George Parkman of life, then no matter how he did it, he cannot, under this indictment, escape the violated justice of the Commonwealth. That is to be vindicated, were he 10 times higher in social position, as much as though he were the humblest man among us. Now, in order to come to the consideration of the evidence, I start with this proposition, that the proof in this case must satisfy you beyond a reasonable doubt. And by that is meant a doubt for which you can give a satisfactory reason to your own minds, and to others if they ask it. Not a possible doubt. Not that it was possible that someone else might have done this, but a reasonable doubt that George Parkman has been killed. Proof must satisfy you beyond reasonable doubt that George Parkman has been killed by somebody. Have you a doubt of that? If you have, my labor is in vain. I may stop here, for the case stops here, and your faith, gentlemen, in anything else in this case is equally vain. Why, it is said by the learned counsel that there is no direct evidence that Dr. George Parkman is not now living, and it is gravely put to you in the face of all this proof, which we have had here, upon the testimony of Dr. W.T.G. Morton, and upon such improbabilities as the ingenuity of the counsel could invent. It is gravely put to you as a question in doubt whether Dr. George Parkman still be in full life or no. Well, gentlemen, what have we been doing here for a fortnight past? What has been done before we came here? Have the solemn rites of religion been performed over unknown bones? Has his estate been administered upon, and have others succeeded to and entered upon the large responsibilities which belong to him? And yet, is he still among the living? Oh, would to God it was so! Has there not been a search which has brought into requisition not only the vigilant police of this city, but which made every man in it a policeman, a search such as never was had before, and no tidings or trace of him living or dead have been found unless these mutilated remains and these calcined bones constituted parts of his mortal frame. Why, it is said, the times have been that when the brains were out, the man would die, and there an end. But now, under the invocation of the learned counsel, they rise again, with 20 mortal murders on their crowns, and push us from our stools. I, gentlemen, to push you from your stools which you occupy, the seats of justice and the law. But the attempt will fail. I read it in your countenances. I read it in the proof which came from that witness stand, that you have no more doubt than those were the remains of Dr. George Parkman. Then, that this which I am now uttering to you is my living voice. Upon this part of the case there is not left a particle of doubt. But we are to consider what was originally intended to be presented as leading to this conclusion, but which, upon the strength of the proof, has now been tortured into making the foundation for another hypothesis, the evidence of the alibi, so to speak, of Dr. Parkman. What was the original purpose and object of the counsel in undertaking to show here that Dr. George Parkman was seen on Friday afternoon, the 23rd of November, after 2 o'clock, and so along till 5 o'clock of that day? What was the original purpose of this evidence? Look back to the statement of the opening counsel for the defense, and you will see what it was. Did an intimation fall from the lips of my learned friend, the junior counsel, that their evidence was to satisfy you? What the senior counsel undertook to maintain as his hypothesis, that there was a separation of Dr. Parkman and Dr. Webster, which reconciles the testimony of both the government and the defense. That was for the purpose of satisfying your minds, or rather of raising a reasonable doubt whether the remains were proved to be those of Dr. Parkman. That was the object of it, for that was really the great point in the defense. Dr. Webster had started it very early in these proceedings, and under circumstances which made the declaration pregnant against him, that there was no more Dr. Parkman's body than it was his body. So they went over this community to find witnesses who could testify to having seen Dr. Parkman, and I venture to say that from the 15 or 20 whom they might have presented here, They selected the 5 whose stories most nearly agreed. Can you doubt that they might have had 15 more? But it would have placed him in so many places at the same time, it would have been impossible for the evidence to be correct, without making him ubiquitous. They have presented to you the testimony of Mrs. Hatch, Mr. Thompson, Mr. Wentworth, Mr. Cleveland, Mrs. Rhodes and her daughter, and Mrs. Greenow. I shall examine not only to show how fallacious it is with regard to his separating from Dr. Webster, but also with regard to the main proposition that those were the remains of Dr. Parkman found in the laboratory of Dr. Webster. Mrs. Hatch is the first witness. She places Dr. Parkman in Cambridge Street going up towards Court Street at about a quarter before 2 o'clock on Friday afternoon, November 23rd. This is all consistent with the statement of the government. It was sometime in the course of the afternoon she spoke of meeting Chin, as she called him. Suppose a mistake of only 5 minutes, and Dr. Parkman, being in Cambridge Street, turns upon his track while she passes on. He turns again and goes into Mr. Holland's store. But there is another answer to her testimony. I suppose it to be philosophically true, that 2 persons between whom there is a general resemblance of feature, form, and gait would not be so likely to be mistaken for each other as 2 persons who have some one peculiar and striking feature in common. Why? Because a general resemblance does not so much arrest the attention and strike the eye as a single prominent peculiarity. And you see that the only impression that Mrs. Hatch received was that she had seen a prominent chin. She had no conversation with him. She did not speak to him, nor he to her. She passed a person with a prominent chin. She spoke of it in the course of the afternoon, not as Dr. Parkman, but as Chin, showing what had arrested her notice. Take the testimony of Mr. Thompson, the biological witness. He saw him, he says, at about 15 minutes past 2 o'clock in Causeway Street. He did not speak to him. He thinks it was 15 minutes past 2 o'clock that he saw him because he looked at the clock as he came away from East Cambridge. That clock we have shown you by 2 witnesses to be an unsafe and unreliable timepiece, and especially when it was first put up last autumn. He merely saw him passing. He may have made a mistake as to the hour or the identity of the person. I do not suggest that he made a mistake as to the day, but I think he did mistake the time, or, more likely, the person. Mr. Wentworth testifies that he saw him in Court Street between 2:30 and 3 o'clock. The others saw him going at his usual gait. This witness sees him looking at the roofs of the houses. His attention is called to the fact of his disappearance the next night, and he does not think it worth his while, notwithstanding the great public excitement, notwithstanding all the rewards, notwithstanding the suspense and anguish of desponding friends, to go and communicate so important a fact as this. Neither of these witnesses, Mrs. Hatch or Mr. Wentworth, saw him so as to observe his dress. But above all, with respect to Wentworth's testimony, he declares to you that Mr. Russell was with him, a gentleman whom we put upon the stand, and who says that he was with Mr. Wentworth on an occasion when he saw Dr. Parkman. Wentworth fixes it as the only time when he was with Mr. Russell and saw Dr. Parkman. Russell says he cannot fix the day, but that it cannot be the day that Dr. Parkman disappeared, for he heard of the disappearance the next day, and is confident that it would then have come to his mind had it been on the day of his disappearance. I regard the testimony of Wentworth to be so impaired by this testimony of Russell as to be valueless. Next comes the testimony of Mr. Cleveland. That testimony, like that of Mr. Rhodes, is dependent on 2 facts of memory that are independent of each other. If Mr. Cleveland had said that he knew it was on Friday that he saw Dr. Parkman, because on Friday he met Dr. Parkman going into such a place while he was coming out, and he knows that he went into that place only on that day, and fixes it by other evidence that he was there, then he has but 1 fact in respect to the time to remember. But now he has 2 facts: the time when he went to see the Reverend Mr. Wiles, and the time that he saw Dr. Parkman. He does not fix the time except by the notes, but whether it was on that day that he saw Dr. Parkman depends entirely upon the confidence he reposed in his memory. Then there is the matter of identity. How did he see Dr. Parkman? Unquestionably, we cannot doubt that there is a person whose slender form, whose peculiar gait, so resembles those of the late Dr. George Parkman, that he is very frequently mistaken for him. Mr. Cleveland says that he has not spoken to Dr. Parkman for several years, that he did not observe his dress, that there were persons intervening, that he passed by him and did not nod, but thought it was singular to see Dr. George Parkman walking with a laboring man, whom he had first erroneously supposed was in his company. Then we have the testimony of Mrs. Rhodes and her daughter. I suppose it is a matter which may be referred to without being put expressly in evidence, that the sun set on the 23rd of November at 32 minutes past 4 o'clock. It is proved that that was a cloudy day. I saw him from 4:45 to 5 o'clock, says Mrs. Rhodes. How near dark was it? How did she see him? Approaching? No, not till she got up side by side. Then she bowed to him. She did not say he bowed first. Suppose it was the stranger resembling Dr. Parkman. Suppose he met this gracious lady bowing to him. He would naturally return the salutation, though she was a stranger. She bows and passes on in the twilight. On Sunday morning, she first hears of his disappearance. She was a parishioner of his distressed brother, and it never occurred to her through the Sabbath day, never through the Monday following, never through the Tuesday following until Tuesday night, when her daughter returned from Lexington to communicate the fact. Then came the afterthought that she had seen him on Friday afternoon as late as 5 o'clock. Then she puts in another fact, and I take the testimony of herself and daughter together, for it amounts to one. Another fact, which is pregnant with significance, that Dr. Parkman, when she met him, was in company with a gentleman wearing a dark-colored surtout, which we noticed as she passed him. Where is that gentleman? Why is he not here to tell us that he was walking in company with Dr. Parkman on that day, at that hour, and in that place? Is not that fact conclusive that Mrs. Rhodes was mistaken? She is mistaken as to the day or the person, beyond all peradventure or doubt. End of section 34. Section 35 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 25. The testimony of Mrs. Greenough I need not comment upon. It was characterized by a fairness, by a scrupulousness, which I should have been glad to have seen imitated. It was my belief, but I cannot be positive. Why, gentlemen? Because she reflects that he has never been seen in the world since, that nobody has seen him, is one of the elements to be taken into consideration in determining whether she saw him or whether she was not deceived in her impression that it was he. If we satisfy your minds that Dr. Parkman's bones were found in that furnace, his remains in that vault and in that tea chest, then that fact is just as much to be taken into consideration, to be weighed against this testimony to prove that he was seen after he entered the medical college, as this testimony, the alibi, is, against the fact of those being his remains, or the fact that he never left that building alive. And I undertake to say that all this testimony, if it were in reference to an ordinary case of alibi, where the party was still living, the testimony of 6 witnesses who swear that they passed the person in the street, did no business with him, did not speak with him, that there was a person with him at the time, who does not come forward, would be extremely unsatisfactory. If Dr. George Parkman were living, and in this courthouse today, trying an action against Dr. Webster for having stolen his notes of hand, and the only defense was founded upon this testimony of an alibi. I should maintain with confidence to a jury that the evidence was in itself weak and insufficient. But what was Dr. George Parkman doing on that day when these witnesses think they saw him? Roaming about the streets, now in Cambridge Street, then in Causeway Street, now in Washington Street, going towards Roxbury, then in Court Street examining the roofs of houses, again in Cambridge Street and afterwards in Green Street. What was he doing? Was there anything so preposterous? Consider this fact. I believe the city has made a computation of the number of persons that pass through Court Street in a certain given time during a business day. I do not remember the number, though I think I have heard a voice. 30,000. 30,000 persons in a day of 12 hours, as I am now informed. How many persons were there in the city who did not know Dr. George Parkman? Or, I might put it with more strength, how many were there who did know him? Now, if Dr. Parkman were roaming about this city, as these witnesses describe, during the whole of that Friday afternoon, I ask you to say, upon your consciences, would they not have been able to produce here, to swear to the fact, not 6 or 60 or 600 even, 6,000 rather? Do you suppose that it would have been possible for him to have wandered about the city during a whole afternoon, and no human being except these 6 persons to have seen him? Well, what is the evidence? That this great number of persons who, if he had been in the streets, must have seen him, did not see him. This is shown by the search which followed immediately. A search of the greatest extent, vigilance, closeness, and scrutiny that was ever made throughout this city. But it is not merely the passing a person in the street, or on the opposite side of the street, or on the same side of the street, or having a mere passing glance, which, if we give any weight to experience, can give us a well-grounded assurance that we are not mistaken in this matter of identity. We offer to put in evidence here that there were persons who accosted a man, believing him to be Dr. George Parkman, and found they were mistaken when they approached to converse with him. We were not allowed to put it in, and why? Because it was a matter of common experience, as the court said, and I put it to you that it is a matter of common experience, common to you and to me. I ask you how many times you have gone up to a person and spoken to him, or even attempted to take him by the hand, and then retreated with, "I beg your pardon, sir. I thought it was Mr." You may have seen the district attorney of the neighboring courts of Middlesex, Mr. Train, by my side, during one day of this trial. In the last capital trial I conducted in that county, I met upon the sidewalk near the Leverett Street jail, on my way to East Cambridge on the first morning of the trial, a police officer of this city. As I passed him, he said to me, "Mr. Train, good morning." I stopped, having this matter of the disappearance of Dr. Parkman in my mind, and turned toward him. He asked, "At what time shall I bring over the subpoenas?" "In what case?" I inquired. "The Pearson case," said he. "Oh, any time in the forenoon," I responded, and passed on. On my arrival at the courtroom, I mentioned the circumstance to Mr. Train, and at my suggestion, he met the officer with the reproach, when he came with the subpoenas, for not bringing them sooner. "Why," said the officer, "you told me I could bring them any time this forenoon." "I told you? When?" "Why, this morning when you were coming over." "I have not seen you today," replied Mr. Train. "Why, certainly I met you and talked with you." "You met me?" "Certainly I did." So confident was he of the identity, he was ready to have gone upon the stand and sworn that he did talk with Mr. Train. And when I told him that I was the person, and told him precisely what the conversation was, for a long time he honestly believed that we were playing a hoax upon him. Yet, gentlemen, The degree of resemblance between Mr. Train and myself is no greater than is found between many persons here present, and between Dr. Parkman and many persons now living. I alluded in the discussion to the court of the question that was mooted yesterday, to the celebrated case of Sherman in Middlesex. That was an instructive case upon this matter of identity. A person was arrested, charged with having committed an assault upon a little girl in Medford, and another upon another girl in Newton. One assault was committed on Saturday, and the other on Monday. A week afterwards, this man made his appearance in Newton, and was recognized by two ladies, who had seen him when he was running away from the spot where he was attempting the assault. He was arrested, and brought before the magistrate. He stated that he had never been in that place before, which was untrue. The children were sent for, and in a crowd of 100 people, they both selected him. The parties from Medford came over, and they identified him also. He was indicted by the grand jury on 2 indictments, and they were both put to the jury at the same time. The evidence of these 2 cases of witnesses, from both towns, 19 in number, was laid before the jury. They were positive, clear, and certain in their testimony that he was the person. The proof of identity was perfect and complete when the government evidence was closed. The counsel for the defense, having received from the defendant a statement of his whereabouts, then traced him, by undoubted proof, through the whole week, and particularly covering the 2 days of Saturday and Monday. He proved by most respectable witnesses, and the most undoubted corroborating circumstances and facts, that that man on Saturday rode out of Nashua on a stagecoach, and that on Monday he was at Manchester in New Hampshire. The alibi was so conclusive the government were compelled to abandon the prosecution, the learned judge saying that there never was so strong a case of identity as that made out for the government, except the case which had been proved for the defense. It was shown that there were 2 persons as like as the 2 Dromios, not only in countenance, form, and gait, but even in the accidents of dress. Now, gentlemen, to talk about a man's being satisfied by a passing glance that he saw a particular individual, who such a mass of proof as in this case tends to show was then numbered with the dead, who has never appeared since that fatal day, and to undertake to satisfy a jury of this, when all the probabilities are against the conclusion, seems to me like asking a jury to surrender everything that is proved in the case to the testimony of 3 or 4 witnesses to a fact, in which they are more likely to be mistaken than any fact to which they could testify. But beyond and above all this, however your minds may be affected by this testimony, let me now meet the proposition of the counsel for the defendant, by saying that, whether these people saw Dr. Parkman or not, as they have testified, is entirely immaterial to your verdict in this case. If you are satisfied upon the other branches of this case, that Dr. Parkman's remains were found in the premises of this prisoner, and if the evidence connects him with those remains, then what matters it whether Dr. Parkman was seen after 2 o'clock on that day or not? The court will tell you that the time when this homicide was committed is immaterial. It may have been on one day or another. It may have been at 1 hour or another. And if these witnesses did see Dr. Parkman, improbable as it is, yet if Dr. Webster, by some means and instrumentalities to us unknown, did beguile and entice him back to the college, and there obtain those notes, and did deprive him of life, then, gentlemen of the jury, it becomes entirely immaterial when it was done. But where was Dr. Webster himself that Friday afternoon? Where did he dine that day? Did the counsel answer that? Did his proofs answer that? Is the fact which the government had put in here disturbed one particle, shaken from its foundation at all? That Dr. Webster was at that laboratory, dinnerless and alone, with no lecture to prepare, at a time when the longest interval occurred between his lectures, viz., from Friday until Tuesday. Has that fact been shaken? And if he did dine anywhere, whether at home or abroad, would he not have shown it? He was arrested within a week. He had sagacious, acute, and intelligent friends about him. He lacked no legal counsel, no anxious friendship, which would seize upon such a vital fact as this, and prove it before you. And if he was locked up in that laboratory at all that afternoon, whether he enticed Dr. Parkman back there and slew him at 4 o'clock instead of 2 o'clock, what is the difference? And thus, all this testimony about the Parkman alibi, as it is called, becomes entirely immaterial to the real issue before you. But I now pass to the consideration of the identity. How is this proved, gentlemen of the jury? It is put to you as an open question. How is it proved? We have heard something said about the negative argument. I think it will be apparent, upon a little consideration and analysis of the testimony, that there is nothing negative in the argument, which I shall draw from the facts proved here, independent of the teeth. In the first place, the evidence shows, beyond all question, that the parts of a human body found in that furnace, and in that vault, and in that tea chest, constituted parts of only one human body. By the marvelous science and skills so beautifully detailed to you here by that accomplished scientific man, Dr. Wyman, and by the testimony of those other intelligent physicians who made the examination of the body, by the testimony of all of them, this fact is placed beyond the reach of doubt. In addition to that, it is evident from all the testimony that these constituted the parts of a body which was not a subject for dissection, that you can have no doubt about. The testimony of Dr. Ainsworth is that there was no subject that belonged to the college missing. He keeps a correct record, and all his subjects were accounted for. It has not been suggested that any other person was killed or missing, except Dr. Parkman. And now take these coincident facts, that here were the mutilated remains of a human body, that no subject was missing from the dissecting room, that no person had died, by violence or otherwise, whose remains were missing, no living person missing, except Dr. Parkman, and that these remains are found to bear every point of resemblance and not a single point of dissimilarity, in form, age, or size, or in the fact that he wore false teeth. I ask you, if anything can rest on human probabilities, what is the value and strength of this argument? Is it negative? Why, you might take the entire community, the community of the entire country and the world, and go through it and select from it the man who most resembled Dr. George Parkman. Let him be slain. Let that man's remains be mutilated precisely as these were mutilated, preserving no more than were preserved of these, and the chances are as millions to one. You cannot calculate the chances, that upon the remains of that person, or those portions of them corresponding to those found here, although there might be entire resemblance in most particulars, still there would, to the searching eye of friendship and of long acquaintanceship, be some one little point of dissimilarity, and one such point as would be just as fatal as if there were no resemblance at all. Yet here you find, from the testimony of the physicians, from the testimony of Mr. Shaw, of Dr. Strong, and others who examined them, and drew their conclusions that they were the remains of Dr. Parkman, before Dr. Keep had ever examined those teeth, or it was known that Dr. Keep could have identified them. I ask you whether their opinions were not justified by this state of facts. I do not say that upon this evidence alone you would have been called upon to pronounce upon this question of identity, but I do ask you to consider whether all these facts do not reasonably justify the conclusion to which his friends arrived, that those were the mortal remains of Dr. Parkman, and of no one else. Consider it for a moment. Here is a portion of a human body which has great peculiarities. There is no doubt about that. Mr. Shaw testifies to it. Dr. Strong testifies to it. There was the peculiar color, profusion, and length of hair, the peculiar shape of the jaw, with the fact of wearing false teeth, and the exact similarity in the height of the body. What are the chances that among all these points of resemblance, there should not be one single point of difference, if they were the remains of another person? These resemblances may be said to be slight. Well, if they are many, and 1,000 threads all running in one direction, and not one running counter to them, though they are as slight as the finest filaments of gossamer ever woven in the morning sunlight. Yet by their very number and direction they may be strong enough to draw us irresistibly to the conclusion to which they lead. Why, gentlemen, of what is the cable made that holds the ship to her moorings? Its separate threads may be snapped by an infant's hands, but, united, they resist the force of the tempest. I come now to the positive, the demonstrative testimony, upon which I undertake to say that you, as intelligent men, must be as well convinced as if we had brought in here the entire mortal body of the deceased. I mean the testimony of Doctors Keep, Noble, and Wyman, and I approach it reverently when I consider the circumstances under which this identification was made, when I remember the long and patient labor of their conscientious man, Dr. Keep, upon the manufacture of a set of teeth for Dr. Parkman, that he might be present at the opening of that college building, of which he had been the munificent benefactor, that it should happen in the order of Providence, that in that very building, where he met his fate, that very set of teeth should have been found to identify his remains, and to vindicate his memory. Aye, and to vindicate the law. I do approach it reverently. I seem to see in it the guiding hand of Almighty God, leading us to the discovery of the truth. And when that witness stood upon that stand and gave us the history of his patient labors over those blocks of teeth, the counsel here, able and accomplished and vigilant as they are, must have felt and did feel that the great foundation of the defense upon which they had hoped to build up their theory was crumbling out, sand by sand and stone by stone from beneath them. And consider, too, that these witnesses were no volunteers, in order to fasten upon this unfortunate person a charge so awful and revolting as this. No, Dr. Keep's own emotion indicated with what reluctance he had come to that awful conviction. Why, gentlemen, why? Not simply that there were the remains of his friend, but that they were also the remains of the friend of Dr. Webster, who was also his friend. He was his teacher. He saw how it tended to fasten and fix this act upon him. What an immense stride was then made toward the conclusion at which a jury must arrive, when that great question of identity must be settled beyond controversy or doubt. The conviction pressed itself upon him that this prisoner, whom he would save if he could, must be connected with the mutilated remains of one who had been not only the benefactor of the institution in which he earned his bread, but his benefactor also, as these papers here well show you, the benefactor, the friend of him. Who should against his murderer shut the door, not bear the knife himself? And he felt as any man of ordinary feeling would, at coming to such a conclusion as the truth required him to state to us. I know those teeth were his, as well as if I had them entire in my hand today. That he could state this with confidence, take the testimony of the experts we put upon the stand, and what becomes of the miserable pretext which Dr. Morton presented, that such blocks of teeth could not be identified. They could be recognized, according to the beautiful analogy expressed by two of the witnesses, Doctors Harwood and Tucker, in the words of one, as well as the sculptor would know the product of his chisel, and the other, as well as the painter who had studied a face for a week and painted it upon the canvas, could know the portrait as his own work, wherever he might see it. If anything more were needed, it is found in the conformity of the jaw of Dr. Parkman to the mold which Dr. Keep had, which would correspond with all the peculiarities of the jaw of Dr. Parkman, picked out from the smoldering ashes, and by that true lover of science and uncompromising seeker for the truth, Dr. Wyman put together, produced here before us. if he had produced here Dr. Parkman's right hand, with a scar upon it which every one of his friends had known, the evidence of identity could not be more conclusive. When we consider that here is a man in his culprit stock, with such advantages of education and of culture as he has enjoyed, who is himself a devotee of science, and we feel that he has so debased and betrayed his high vocation and mission as to have slain, either in anger or in cold blood, whichever it may be, his fellow man, and his benefactor and friend. It almost sickens us. We feel that there is no shield for any of us against the commission of great crimes, that culture, science, and all the ennobling and purifying influence of education are utterly lost upon us. To find them subjected to such base uses as that chemist's laboratory has witnessed prompts us to exclaim with the poet, "O star-eyed science, hast thou wandered there to waft us back the tidings of despair?" But we recover and are refreshed only when we go to the other fact which this case discloses, that, although science had been debased for the purpose of destroying those remains, yet science, in its true vocation, in its noblest scope, sifts and penetrates those smoldering ashes and evokes from them those materials with which it reconstructs almost the entire body, which science had vainly attempted to destroy. It gives to us a renewed assurance of respect for science, and I cannot pass from this part of the case without expressing a feeling which has been often in my mind during the solemnities of this trial, the honor that is due to that noble profession through whose ministers this assurance has come to us, and we have welcomed them to our bedsides amid our trials and sufferings. We have loved and honored them, but when we meet them here, and see them taking the stand as they do, most reluctantly, against one of their own brotherhood, forgetting or rather trampling underfoot all those considerations which arise from caste, from class, and giving themselves unreservedly to the truth. Let it strike where it may, let it fall where it will. They challenge and are worthy to the highest honor, and they have my humble reverence. One of their number, whom we have looked to have been here, and whose aid, in another recent capital trial I had occasion to seek, in which his testimony showed how much he would have added to the impressiveness of this, has passed away from us since these investigations commenced, a man who honored the community in which he lived, who honored the profession to which he belonged, and who, for the cause of science, has been removed from us too soon. I referred to the late Dr. Martin Gay, whose testimony to that scene down in yonder prison and over at that medical college would have been as valuable to us as would his scientific testimony upon the question of the identification of the remains. I now pass to the consideration of another proposition. I consider the matter settled, beyond all question, that they were found in Dr. Webster's laboratory in the vault, the tea chest and the furnace, the remains of Dr. Parkman. The circumstances under which those remains were found, negative, without the aid of argument, the two propositions which have been presented by the learned counsel. One, that he died by his own impious hand, that he committed suicide. The other, that he died by the visitation of the Almighty, a natural death. No man, it seems to me, can call upon counsel to argue a question like that. Why, gentlemen, to have died a natural death and his body to be found thus mutilated and mutilated there? For what conceivable purpose? Is it possible that he committed suicide, and some person in mere sport had hacked those remains and burned that head? Preposterous! Absurd! Could his death have been innocent, with such a disposition of his body? No, gentlemen, it speaks louder than any language of mine can speak, that there was crime as there was concealment, connected with these remains. This hypothesis was not pressed by the other side. It was thrown out as a suggestion, consistent or inconsistent as might be with other propositions, and the inconsistencies of some of these I shall advert to presently. But this idea was not dwelt upon, and the counsel could not have entertained such an opinion. No, gentlemen, the circumstances under which those remains were found bring us conclusively to the conviction that crime was connected with the destruction of Dr. Parkman's life, by whomsoever it was done. I now, gentlemen of the jury, come to examine the hypotheses which have been set up on behalf of this defendant. I ask you to consider whether any one of them, even taken alone, independent of the rest, is a rational, reasonable hypothesis, such as the law contemplates to negative the hypothesis which the government maintains upon circumstantial proof. I shall then ask you to consider how consistent with each other these hypotheses are. I think I cannot be mistaken that the consumption of your time upon this latter subject will be superfluous, for although that argument which embraced these theories and propositions was addressed to you in the most impressive language and manner, and although each independent and distinct proposition came from my learned friend with a force and fervency which I could not hope to rival if I had the ambition to do so, still, I think, as fair-minded men of fair intelligence, you could not but have been struck with the manifest contradictions and inconsistencies into which his case has betrayed him. And yet there was no help for it. He did all that mortal man could do. He had the truth of the case against him, and I do not know that an argument could have been framed that would have been more satisfactory, certainly none more able and impressive, than he addressed to you out of the materials that he had at his command. But what were the propositions? They were that Dr. Webster admitted what we had proved, that Dr. Parkman went to that college at or about 1:30, that he paid Dr. Parkman the money, which we say the proof denies, and that beyond this he denies everything. Then the counsel undertake to construct their hypotheses. And what are they? In the first place, and most important, they disclaim now that our proof is in and uncontrollable, all imputation upon Mr. Littlefield as having been the author of Dr. Parkman's death. If they had not done that in words, you as a jury would be bound to put your impress upon that hypothetical statement of what Mr. Littlefield did, or might have done. It came, as the counsel told you, in the fearless discharge of his duty. It may be that it was in the discharge of a duty that he put Mr. Littlefield, an honest man, upon his trial here, though he did not dare to make the accusation against him that his client had the hardihood to make before he came here. The counsel knew that where we had corroborated Mr. Littlefield, he would stand unshaken, and that we had furnished them with the means of contradicting him if his statements were untrue, and that they did not contradict him in a single syllable. I mean to present Mr. Littlefield just as he is. I mean that justice shall be done to him, if justice is not done to him who libeled him. But I now speak of it as a part of the counsel's allegations, that he disclaimed all imputation upon Mr. Littlefield, as having been the perpetrator of this crime. But the counsel argues, supposing this to be the body of Dr. Parkman, it is not proved he died by violence. He might have died a natural death, and been stripped and robbed, and his body carried into the laboratory of Dr. Webster, and he not know it. End of section 35. Section 36 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 26. I have already had occasion to say to you, we are not here to discuss possibilities. It is no part of your duty, though it may be a part of the duty of the counsel. He could suggest nothing else. Why, gentlemen of the jury, he might, with almost equal plausibility, say that Dr. Holmes, the accomplished physician and professor, who entwines with his scientific laurels the wreath of the Muses, whose fame is precious to us all, who is known and honored and beloved everywhere, that Dr. Holmes might have killed Dr. Parkman when he was coming down out of his lecture room, but we are not dealing with possibilities. Having dismissed Mr. Littlefield and the other possibilities, the suggestion is that the deed was committed by somebody out of the college, and the remains carried there. And that really seemed to be the proposition upon which the council rested. You see the inconsistency of his other propositions. If Dr. Parkman went there at 1:30, and then went away, and Dr. Webster said he did, and thence to Holland's store, and bought his groceries and then back again to the college, and was there waylaid and murdered, then all the testimony which they put in afterwards of the afternoon alibi goes for nothing. He never was seen out of the building, if that is true. If he was killed elsewhere and carried there, it involves another absurdity. The idea is that it was done by some robber or marauder who waylaid him and, after he had slain him, carried his remains to that college. For what? Why, the first suggestion is to have them destroyed, or for concealment until the excitement arising out of his disappearance should subside. The other is, in order to get the reward which was offered for the discovery of the remains. Then it becomes quite natural to consider what is meant by the suggestion that the criminal got in there that night, and by that mysterious unbolting of the door. And when was that? Friday night. That was the night of the day of his disappearance. The robber and murderer was expeditious, upon the hypothesis that he separated from Dr. Webster and was wandering about the city deranged that afternoon, and his body concealed in the college that night. But how does this consist with the theory that he was killed elsewhere, and it was not until a search was made and a reward offered, and when slander began to breathe upon Professor Webster's name and connect him with the disappearance, that this marauder, whoever he was, went and deposited the remains in Dr. Webster's room, and there proceeded to dissect and destroy them? What is the proposition? Does it satisfy your minds, gentlemen? Does it raise a reasonable doubt? Remember that, whoever this marauder was, he was a tolerably competent dissector and anatomist, for the manner in which that body was cut up, in the expressive language of Dr. Holmes, showed it to have been done by a competent person. There was no botching about the business. No, gentlemen, he left. No rubs nor botches in the work. So that, whoever he was a tolerably skillful anatomist. More than that, he was something of a chemist. Do you remember the testimony of Dr. Charles T. Jackson, confirmed by one of the other medical witnesses? It was he and Mr. Crossley who, with Dr. Gay, made the examination. Their testimony, independent of that of Dr. Gay, is that they took portions of the muscle of the thorax and found that strong alkalis had been applied to it, which is known to chemists to be a most efficient mode of destroying flesh. But after slander had begun to whisper against the good name of Dr. Webster, there were rumors, were there? There was slander, were there? Which began to blow upon his good name. Gentlemen, I ask you to consider, as men having faith in Providence, whether it is likely that unfounded suspicions could attach to such a man as Dr. Webster of having committed an act like this. More, gentlemen, and this answers a very considerable portion of the theory advanced by the council. I ask you if you believe that it would be possible, in a community like this, distinguished for its intelligence and its humanity, that such a man as Dr. Webster could remain, not under suspicion only, but under an accusation like this, for 4 months together, and no hope-giving trace or indication of his innocence be discovered? Why, gentlemen, what interest had been involved in his innocence, if it could be made to appear? What anxiety and solicitude have been felt by all the friends of good order, of education, of that beloved university, the cherished child of our Pilgrim Fathers? If one of the officers of that university were charged with crime, he would have, as this prisoner has had, not only the sympathies but the repelling disbelief until proof forced its convictions upon us of every man in the community. Do you suppose that suspicion upon such a man as that would ripen into accusation, and that accusation into an indictment, and that indictment into trial? In a community like this, and the world sit down quietly and let it all go on, if he were an innocent man? But it is further urged by the counsel that, before suspicion had begun to be aroused, even as early as the Friday night of Dr. Parkman's disappearance, the person who carried the remains there got into that building in some incomprehensible way, and hence the door was found unbolted in the morning. You remember how impressive the counsel was about that unknown person, who might thus and then have effected his entrance into the building. This, of course, is utterly subversive of the other theory, if it has any foundation in the proof. But I think there is another suggestion worthy of your attention. On that Friday night, after 1 o'clock in the morning, and up to 1 the next day, who testifies of the whereabouts of Dr. Webster? Who beside him had a key to that door except Dr. Lee? The facility with which Dr. Webster flitted between the medical college and Cambridge has been made apparent to you by the testimony of his own witnesses. I too think the unbolted door had some connection with these remains, but not that it bears upon any other person than the prisoner. I cannot imagine that there was some murderer outside who carries these remains there, because suspicion had begun to breathe upon Dr. Webster. That would imply that this body had been put there at a very late period in the week. But in point of fact, gentlemen, until these remains were found on the premises, and until that startling discovery was communicated to the police, there was no evidence of a general suspicion against the prisoner. None whatever, until Friday, the day of his arrest. Then undoubtedly it was a matter of remark. There is no doubt but that, with regard to the college, public sentiment had been decided before that date. But let me say that the public are not prompt to entertain an unfounded charge of a great crime against a man who is set so far beyond the reach of suspicion as to make it require proof upon proof to connect him with the transaction. But what foundation is there for any such theory as this? There has appeared nothing yet, nothing whatever to point at or implicate any such third person. And upon what are you to try this cause, gentlemen? Hearken to your evidence, was the admonition with which you commenced your patient and protracted labors in this trial. And you are to take it all. I shall consider how much has been added to it by the defense by and by. 4 months have now elapsed, and neither time, place, mode of death, nor any other circumstance has directed attention to any third person. Nobody else is suspected. It is idle, it is absurd to suppose in a state of evidence like this, that anyone else committed the act which all that evidence tends to fix and fasten upon this prisoner. There is a further suggestion, I will answer it now, that the remains were carried to the medical college with a view to get the reward. I understand from my learned friend, to whose argument, to whose efforts, I am certainly disposed to do entire justice, that he used the matter of reward in connection only with this consideration, that it might be remarkable that the offering of the reward was coincident with Mr. Littlefield's commencing the search for these remains. The fact is not so, but if it were so, what an absurdity it would be, connecting it with anybody, that a person should deposit there and afterwards find there. What? Not that portion which has been satisfactorily identified, but parts which could still not be identified. How absurd that he should have destroyed all those parts of the body by which identity is ordinarily proved, and to which we must resort to prove it. The head, hands, arms, and feet, and then undertake to find the remains which were concealed in the vault, for the purpose of getting the reward, when the great question would be, in the first instance, whether they were the remains of Dr. Parkman or not. You will remember that all Mr. Littlefield found were the portions deposited in the privy vault. He did not find the portions in the tea chest, or the bones and teeth in the furnace, and he gave no intimations by which they could be found. He found simply the pelvis, the right thigh and left leg. And how did he find them? I shall consider that in a moment. The proposition, then, that they were put there for the purpose of obtaining a reward is preposterous. Then take the other proposition. Could any man in his senses have undertaken to destroy those remains in Dr. Webster's laboratory? In the daytime, remember, when he was there, as we show, not by Mr. Littlefield alone, but as they show negatively by their own evidence. For it is a most remarkable and significant fact that the 3 daughters of Dr. Webster who came here to testify in the defense have, by their own testimony, in a most remarkable degree, confirmed and corroborated Mr. Littlefield. They put their father away from home at the very time Mr. Littlefield puts him at the college, and Mr. Littlefield puts him away from the college at the very time they put him at home. There is no conflict, but a perfect harmony between the testimony of these witnesses. Now, the absurdity of any persons doing such a piece of work as this in that laboratory without the knowledge of Dr. Webster is manifest. Suppose they had secured their opportunities when he was out. There was that assay furnace, in which, upon the evidence, a fire had never been kindled before. Do you think Dr. Webster could have had a person there and a fire in the furnace without his attention being attracted to it? For what purpose would any other individual do this? Who would be so fortuitously presumptuous as to attempt to fasten upon a man in Dr. Webster's position an accusation like this by such means as these? Now, gentlemen, I intend to state to you 2 or 3 propositions upon this subject, which I think are clearly met by the evidence in the case and sustained. If Dr. Parkman had been killed in that college, and his body never carried out, but subsequently conveyed into Dr. Webster's laboratory for concealment or for the purpose of being consumed, then it is evident that either Dr. Webster or Mr. Littlefield must have known it. I think that we cannot escape from that proposition. Their hypothesis is that some assassin might have lurked in the entry, a little space of 8 feet wide, and as he came out of Dr. Webster's room, waylaid and slew him, and that he carried the body either to Dr. Webster's laboratory and ran the risk of being detected by him, or into Littlefield's apartments, or some other portion of the building, encountering an equal risk of being detected by him. The idea of an assassin's laying in wait, with 100 students all around him, and with the janitor near, and the front door broad open to the street, is as absurd as for a man to lie in wait in the Merchants' Exchange at midday, with the intention of committing a secret homicide. Then we come to the next hypothesis. Was Dr. Parkman killed outside of the college, and his body brought into the apartments of Dr. Webster? If so, it must have been brought there for 1 or 3 purposes: concealment, to be consumed and destroyed, or to fix the charge of murdering him upon Dr. Webster. The last I have already considered with regard to the first, concealment. It is obvious that it could not be accomplished, because Webster or Littlefield must know it. The idea of going into his laboratory to burn a body in his furnace and to conceal it from him is as absurd as it would be for him to come into this crowded courtroom and undertake to do it here. Was the body to be consumed and destroyed? All the evidence shows that this could not be done without his knowledge. Turning off the water, burning up the fire kindlings, so that only a small quantity was left, packing his knife in the tea chest, using up his tan, spilling his nitrate of copper upon the stairs, penetrating into his private room to get the twine, and the fact of that twine's being kept in Dr. Webster's private room, my learned friend found it convenient not to remember the grapplings and twine being all together in that private room in a drawer. Now I ask you, if any stranger could have done this, and Dr. Webster not known it? I put it even upon a possible hypothesis. I anticipate your answer. The idea of fastening suspicion upon Dr. Webster. What is that? It is not shown to you that he had an enemy even in the world. It is impossible to imagine that any man should have possessed the temerity of fastening the charge of murder falsely upon such a man. And yet, if that had been attempted by anybody, what would have been the natural course? Why, he would have taken the dead body there and left it in its unmutilated state. Found under these circumstances, it would have been conclusive. What was the probability of its being found? Suppose this hypothesis is to be true. The man who killed him outside the college in order to fix it on Webster and get the reward did nothing to discover it. Mr. Littlefield found those parts under the vault. Officer Fuller those in the tea chest, and Coroner Pratt or Marshal Tukey the bones in the furnace. If that is true, this unknown possible person took the most incompatible modes of carrying out his intention and adopted the most efficient means to defeat its fulfillment. I am addressing reasonable men. My learned friend, pressed as he was by the strength of the circumstances, was driven into these inconsistent propositions, absurd and ridiculous as they are, and he had the ability and skill to present them in a most impressive manner. My duty is to call you back to the testimony. There are in this case 2 or 3 great, overshadowing facts, which, long ere this, would have sent any common culprit and doomed convict from the prisoner's dock. Before adverting to them, let us consider the other proposition, which has not been made, not in terms been made, but which has been indirectly attempted to be maintained. I mean, the proposition that Mr. Littlefield is not to be believed. And why? Because, as the counsel was compelled to say, that if he was believed, it did make this case a strong one against the defendant. Gentlemen of the jury, why is he not to be believed? By what rule are you sitting here, as his fellow citizens, and under the sanction of your oaths? By what rule of evidence? By what rule of law? By what rule of justice? By what rule of right are you to say that Mr. Littlefield has not entitled himself to your credence? There are various modes of impeaching a witness. One is by attacking his general reputation for veracity. That gives him an opportunity to sustain his character by counter-testimony. If the counsel here had undertaken that mode of attack, they knew very well that, like the unskillful engineer, they would have been hoisted by their own petard. They knew that we could present ample evidence both to corroborate his statements and to sustain his character for truth and veracity. Another mode is to impeach him by showing the conflict of his testimony with that of other credible witnesses. No such conflict is found here. Corroboration and confirmation, rather. A third mode is to show the inconsistencies and discrepancies in his own testimony. This has been attempted. With what fairness or success we shall see, and you are to judge. I have another consideration to present, which, I think, is demanded by a sense of justice to a humble and honest man. To him, and to his wife and children, his reputation is as dear as that of a college professor is to him, and in the eye of the law is entitled to equal consideration. When I remember the load of obloquy which, coming originally from the defendant's lips, has been borne by Mr. Littlefield, the imputations which have been heaped upon him, so that during the rest of his life, abroad or at home, his name must ever be associated with this terrible tragedy. When I remember that those children of his must have said that Dr. Webster and Dr. Webster's friends and the reckless and thoughtless who sympathized with him at the risk of injustice to others, imputed to their father, if not a murder, a most foul and unrighteous conspiracy. When I remember also that he has been here upon this stand an entire day upon his examination, and taken up on another day, and subjected to a cross-examination by those who rank with the ablest cross-examining counsel in Massachusetts, and been subjected to all the scrutiny and sifting which their masterly powers could command, when, if he was untrue, if he was open to contradiction, his falsehood must have been exposed. And when I reflect that he has gone bravely through it all, that he has come out of the fiery furnace of an ordeal like this, without a trace of fire upon the garment of truth which he has worn, I put it to you, whether he shall longer continue to bear the imputation cast upon him by this prisoner, and which with the less directness of charge his counsel have now undertaken to impress upon you and upon the community. I challenge your sense of justice whether that shall not be put to rest forever. Gentlemen, are we here in a Christian courtroom? If he had contradicted himself or been contradicted by others, if he had been proved to have done anything which opened him to such an attack, I should not, most certainly, stand here to defend him. But he is charged with having told you an improbable story. We will see if he has done so in a moment. My present purpose is to show that injustice is done to the man. If that is the case, there is no defense for Dr. Webster, for it is certain that, these remains being there, it must have been known to Littlefield or Webster, and I think besides, it could not have been known to Littlefield without having been known to Webster. I do not put Mr. Littlefield upon this stand as a man of culture, of nice, delicate moral sense, but I put him here as an honest man who fills reputably his position in life, a useful though humble one, and in that position commands the confidence of those who know him best, and are best able to judge of him. During all this period, when the keen, sharp eyes of the police were upon him, when, as Constable Clapp tells you, and as Mr. Kingsley confirms him, every nook and corner and crevice, every pocket, every place on his premises was searched, when they had their eyes upon him, scrutinizing him every moment, that nothing should have been discovered, that what is of more importance he should have been retained in his place, ever since, by those very professors whose associate had been taken off to the cells of a prison upon his accusation, thus manifesting their confidence in the accuser, if not their conviction of the guilt of the accused. I say that, under these circumstances, he is entitled to some expression of their sense of justice from the whole community, if there is any sense of justice left in it. It shall be no fault of mine if he does not obtain it, so far as my humble voice can bear witness to my conviction of his truth. I should feel that I was false to every sentiment of justice, to every conviction of duty, if I did not utter it. Where, then, do we show Mr. Littlefield to have been? And where do they show him to have been? For if he was not where the government proves him to have been, they could have called these persons to have contradicted him. They could have called Doctors Holmes, Jackson, and Hannaford, Mrs. Harlow, and Thompson, and Grant, to show whether he spoke the truth, but he could not. I should have added also the members of the Suffolk Lodge, where he went on the Tuesday night. All his whereabouts during the week had been open to contradiction. He had spread himself just as broadly as the counsel could desire. There is not a syllable of conflict. A miserable attempt was made to show by the old man, Mr. Green, that he had said he was present when the conversation took place with Dr. Parkman. Even he concludes that upon the whole conversation, he was mistaken in his first impression. But the very man who took part in that conversation is put upon the stand, Mr. Todd, and proves conclusively that he did not say any such thing. Now, Mr. Littlefield is entirely uncontradicted here. Let us see what his conduct was, and I shall go over it more cursorily than I otherwise should, if I did not rely upon this proposition, which you will assent to, that in all that Littlefield has said, he has been open to contradiction. He has been carried over all this period of time, and he has not been contradicted. He has been left unimpeached, and by counsel who would leave nothing undone which could be done to serve the interest of their client. Then I say to you that I think you are bound to receive and accept the testimony of Mr. Littlefield as true. But whatever there has been in it that has been the subject of comment, that looks unreasonable, we have an explanation. In my view, there is not a single act testified to that is not perfectly explicable and explained by the theory that he had conceived a suspicion, which in my opening statement I put before you. He conceived as early as Sunday night. The fallacy of the argument of the counsel will be shown. In commenting upon Mr. Littlefield's testimony, he asked why he did not do this or that. Extraordinary conduct, he exclaims, that Littlefield should have gone to Webster's room Friday night, after coming home late in the evening. He took that fact, without considering the others, that he went at the same time, according to his custom, around into the dissecting room and the entries, to fasten up the building. Why should he not try Webster's rooms also? There were other objections to his testimony. Receiving the turkey. Heat of the fire felt on his face as he passed through the entry. Are these suspicions and extraordinary actions? The whole fallacy of the argument is that the counsel proceeds upon the assumption that Mr. Littlefield's suspicion on Sunday night was a settled conviction. Mr. Littlefield is not the command of language. When he says he has a suspicion, what is it? Consider the relations of the two men. Here was Littlefield, conceiving on grounds which I think you will justify, suspicions against his superior, upon whom he was dependent in some degree for his daily bread. Those were checked by his wife. For mercy's sake, don't ever say or think of such a thing again. But he could not help thinking of it. Originally, when Dr. Webster told him with his downcast eyes that he had paid Dr. Parkman, and that Dr. Parkman grabbed the money and ran off without counting it, when he found in connection with this that Dr. Webster pursued the unusual course of keeping his doors closed against him, why should he not entertain the suspicion? When Dr. Webster went on through the week in the same way, when he was learning that public sentiment was settling down decisively upon the idea that Dr. Parkman's remains would be found in that college and nowhere else, when it came to the point that that college might have been the scene of a riot in a mob, then he commenced a search in the only place unexamined, acting upon that honest suspicion, early conceived, honestly entertained, but still cautiously acted upon. Cautious because, if it should turn out to be erroneous, where would he be? Suppose he had undertaken to have broken through the door of that privy, what would Dr. Webster have done? If he had caught him there, and his suspicion had turned out to be unfounded, it was not a conviction that he was to find anything, not a probability, not an expectation perhaps, but a suspicion, arising out of Dr. Webster's conduct. Was he the only one? Were there not suspicions from others who had interviews with him? What was Mr. Samuel Parkman Blake's feelings when he came from that interview? And yet Mr. Littlefield is denounced for having entertained a suspicion which he did not consistently act upon. I maintain that he did act upon it consistently when you consider the relations between him and the professor, and that he should have gone in the manner he did to Dr. Jackson and Dr. Bigelow, shows the confidence of his suspicions at that time. That he should have created no disturbance and have made a very cautious, hurried, and imperfect examination when he went in on Wednesday is perfectly natural. I may as well answer here the objection to the counsel that he took the turkey. Why should he refuse it? Should he refuse the only present ever given him by Dr. Webster, and thus tell him his suspicions? It don't appear that he ate it, but it does appear that he did not dine at home on Thanksgiving Day, said all the pathos and poetry of my learned friend about his eating that consecrated meal received from a murderer is entirely lost. Then the warmth of the fire felt on the face. Why should he not feel it? As I understand it, when there is an intense heat in that furnace, the wall would be heated after the fire had gone down, and the heat of the wall need not have to be very great in order to feel the warmth in a narrow passage. Is there anything in that objection? At all events, Mr. Littlefield swears to it, and he is an unimpeached witness, and I feel authorized to say of him, as the counsel did of another witness, an unimpeachable one. Then the search made in the laboratory. Why didn't he break into the privy door? He had alluded to it once in the presence of the police, and they did not choose even to ask Dr. Webster to open it. He was not going to expose himself to the maledictions of Dr. Webster if he should find nothing there. But when the cloud thickens around the college, he communicates his suspicions to the professors, and one of them tells him to go through the wall before he sleeps. Why should suspicions attach to my friend Dr. Bigelow or to Dr. Jackson? Why didn't they say, go into that privy and put a lantern down and discover what you can? You are not to assume that something decisive had been discovered about Dr. Webster, and that Littlefield knew that the remains were there, or that he suspected that they were there to the degree that the council seems to believe. He held the suspicion cautiously, as a man naturally would hold it, and acted accordingly. Then there was secrecy, pledged on the part of Dr. Jackson. Of course, secrecy. Secrecy all through until something was discovered. And when those suspicions ripened into certainty, as they did when the remains were found, then if Mr. Littlefield were not an honest man and an honest witness, if he had a purpose to implicate Dr. Webster, why did he not point out the tea chest? Why did he not point out the bones? He did neither. End of section 36. Section 37 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 27. Now, gentlemen, if there is anything in any system of law which lies at the foundation of all justice, it is that, if a man is put upon his trial, he should first be accused. And that is what my friends on the other side have been insisting upon. They say that we have not charged Dr. Webster with sufficient precision in our indictment. They did not undertake to charge Littlefield at all, and yet they undertake to try him. And it is the breath of an advocate alone which is to fix and fasten infamy upon an honest, though a humble man. Gentlemen, is that justice? Christian justice? Let them come out. Let this prisoner have come out, through his friends and his counsel and in the open face of day, have undertaken to fasten this charge upon Mr. Littlefield, and it would have been met successfully, decisively met. Remember, gentlemen, that at a critical period in the history of these events, this prisoner and this witness, Littlefield, have once been face to face. Littlefield has confronted him. The dependent has stood up before the superior. The superior has been dumb before the dependent. Remember the testimony of all the witnesses who were at the college as early as Tuesday of that week, that when the significant allusion was made to the privy on the first day, and to the privy key on the second, that Littlefield, in a natural manner, stands up before the professor and says, that is Dr. Webster's private privy. He is the only person who has the key. And Dr. Webster bows them politely out the door. And when the key was asked for again on the second occasion, the Friday of the arrest, Mr. Littlefield said again, Dr. Webster keeps that key. What then does Dr. Webster do with respect to Littlefield? This man whose accusation against him is to strip him of name, reputation, perhaps life itself. What does he answer? He is dumb before the shearer and opens not his mouth. When he gets to that dimly lighted laboratory standing off 9 feet, at the nearest from the body, he pronounces upon the identity of these remains. And yet he does not hesitate behind Mr. Littlefield's back to charge him with conspiracy against him. But before his face, what does he do? What would an innocent man have done when face to face with the man whom he says he always hated, although he began to manifest some kindly feelings on the Tuesday before? when he made him the first and only present he ever made in an intimate intercourse of 7 years. When confronted there by him as an innocent man, he would have said, "Why, Mr. Littlefield, you have had access to my rooms. You can explain this." But not a word. Not a word. When the two men were together, there was foreshadowed what has since been followed up and made clear to every eye. Littlefield has spoken out everything. Dr. Webster has spoken out nothing. Now, through the breath of his counsel, is this witness to be attacked before a jury, before the world is not being entitled to credit and belief? No, gentlemen, go down into your hearts and see what justice you would demand for yourselves in a case like this. And what you would demand for yourselves extend to him. I ask no more. I should have added another thing that was unmistakable in the conduct of Littlefield, the conduct exhibited by him when these remains were found. He and his wife were examined here separately, apart from each other. What if Field was thus open to the defendant for detecting untruth and inconsistency, if any existed? It was impossible for them to have imagined what questions would be asked them, and if there had been anything untrue in their answers, would not have Mrs. Littlefield crossed her husband's track in a rigorous cross-examination? And yet there is not a particle of conflict. When he came up, says Mrs. Littlefield in simple and truthful phrase, he bursted out a-crying. The counsel talks about Mr. Littlefield being the janitor of that college, and therefore familiar with subjects of dissection. True, gentlemen, but even he, familiar as he was with them, when that awful truth which had been but first a vague suspicion, and had kindled its flame in other minds gradually along through that week, till he had been compelled from his fear of what might happen to the college to go into that vault, when that ripened into the certainty that the remains of Dr. Parkman were there, that the founder and patron of the institution had had his mutilated and dishonored body thrown down under its basement. Even he could not choose but weep. Was it not a natural expression of feeling which would have thus been extorted even from a man of flint, which you see by his appearance on the stand that he has not? What opportunity had Littlefield to be in any way concerned in this matter? Mr. Littlefield was in Dr. Holmes' lecture room within 5 minutes probably of the time when Dr. Parkman entered that building. He went to Dr. Holmes's before the close of the lecture. He assisted him in what he had to do. After his lecture was finished, he then came down with Dr. Holmes at 2:15. Now we cannot ask Dr. Holmes the question whether the statement is true, because Littlefield having stated it, and being unimpeached, he could not be corroborated, but they had it in their power to contradict him if the statement was untrue. Then, according to Littlefield's testimony, he made his preparations for the fires in the furnaces in the medical lecture room and the dissecting room, and also prepared the stove in Dr. Ware's private room. And at 3:00, Dr. Bosworth calls there and finds him engaged in these accustomed occupations and in his ordinary dress. There we have Littlefield at 5 minutes before 2, at 2:15, at 3:00, and then at 4:00. He was lying down, as we prove by his wife's niece, and Mr. Petit calls and testifies that he saw him. And then we find from 5:30 to 6:00 he dresses himself and goes to Mr. Grant's dancing academy, and he is there that whole evening. Now, where is Dr. Webster? Then there is another consideration with which I shall lead this matter. If Mr. Littlefield had anything to do with that body, he had access to that receptacle of the bones from the dissecting room, and could command an entrance to it. His throwing anything down in it would have excited nobody's suspicions who might be passing through the entry. He understood that lock, and if he had those remains there for any other purpose than for the gross and incredible purpose I have already discussed, of fastening suspicion upon Dr. Webster, he could have deposited them in the dissecting vault beyond all doubt. The question is asked, why did not Dr. Webster deposit them in the dissecting vault? 2 satisfactory reasons. You know whether he had access to it. I very much doubt whether he knew where the key was kept, or could have unlocked it if he did. When you visited the building, gentlemen, you tried that lock and ascertained for yourselves how difficult it was to unlock it. The other reason is that he was exposed while there at any moment to observation from the students who were passing day and night to that dissecting room. But all these possible alternatives of what he might have done suggest another consideration, and it covers a large portion of the counsel's argument about the folly of the prisoner, if he was really guilty. When you are tracing the history of a criminal, when you are attempting to mark out the course which he has pursued, you must remember that in judging of his course and in weighing his conduct in your anxiety and your conscientiousness of purpose, to arrive at the truth your own honest hearts can furnish you with no common standard. What he would do, you cannot easily conceive. We always hear of the folly of a criminal. It is very rare that a great crime is committed without prompting such remarks as that he would not be fool enough to have acted so unwisely, so indiscreetly. It is not in the order of divine providence that a man engaged in a criminal enterprise shall retain the possession of those faculties which were given him to be used in the work and the ways of virtue, and the course he takes may be, to the intelligence of the merest child, the extremest folly, when in his own mind it is the height of adroitness and art. Crime is foolish. It has always been so from the beginning. It always will be so until the end. It is as true now as it ever was, that guilt bedarkens and confounds the mind of man, that human will of God abandoned, in its web of snares strangles its own intent. One further suggestion arising out of the proof in this case may impress your minds as it has my own. If a man has an object which he wishes to get rid of, the possession of which is fatal to him, or rather the world's knowledge of the possession of which would be fatal to him, what is the most obvious thing that occurs to him as the instrument and agency of destruction? Fire, fire, for that reduces the organized structure to a mass of undistinguishable ashes. Mr. Foreman, suppose today a person should entrust to your keeping the simplest thing, with an injunction upon you that your possession of it must not be known to any human being, that the discovery of it in your possession would be ruinous and fatal, involving your reputation, your liberty, your life. Now, put it to yourself, in what manner you would endeavor to dispose of it, so that all trace of your connection with it might be beyond the reach of human discovery. You might have an opportunity to bury it. Still, the fear would arise that some person might exhume it. It would burn. You must get rid of it. And yet, you say, if I leave any trace of it, I am not certain, I am not safe. Its relics may come up at some future time to confront me. If I throw it into the sea, that sea may give it up again, and it may be traced to me. But if I can destroy it by fire, I shall be secure. It is not the possession of the thing, but the terrible consequences that will follow from the world's knowledge of that possession, that renders its destruction so difficult and perplexing to him, upon whom those consequences will be visited. A narrow line, marked out upon a level floor, may be confidently traversed by a child, without an inclination to either side, but broaden that pathway tenfold, and let it stretch across a chasm, and the man of the firmest nerves and the most practiced self-command would no more dare to cross it than he would to, or walk a current roaring loud on the unsteadfast footing of a spear. And so with this learned professor, for in that his intellectual self-discipline makes him no exception to the common lot. When he had that body to dispose of, he had 2 things to do, and we come now to a consideration of what he did, to show his connection with the murder of Dr. George Parkman. He had, I say, 2 things to do. 1, to destroy the body and all things pertaining to Dr. Parkman, whether of his remains or his effects, and at the same time he was to avoid suspicion. He was to keep of his natural and customary deportment, It was not to seem to be embarrassed anywhere. It was not to be caught anywhere or at any moment off his guard. If a person spoke to him in relation to Dr. Parkman, he was to be in a condition to meet the subject with calmness and self-possession. He was to maintain that external demeanor, which would enable him to go to Professor Treadwell's and sit down and converse upon indifferent topics. He was to make it appear that he was, at Cambridge at times, inconsistent with the destruction of that body. But it may be said that, although this was his obvious course of conduct, if he could self-command and control himself, yet that it was not within the compass of his or of any man's power to accomplish it. Gentlemen, you have seen him here through these 2 past weeks. You have seen what his deportment has been during all the solemnity and impressiveness that have marked the progress of this trial. You have seen him when others were affected to tears, when the judges upon the bench, the counsel at the bar, the witness upon the stand, the entire audience throughout this hall, were unable altogether to repress their emotion. You have seen him when his own daughters were upon the stand, and even the hardened heart of a public prosecutor was too much moved to subject them to a cross-examination. Through all these senses, is not he a psychological phenomenon, who, like this prisoner, innocent or guilty, could remain unmoved? Never has he blenched but once, never but when detection, exposure, discovery yawned before him. Then he drooped and fell prostrate, as innocence never did. That prostration continued through all the horrors of that night of his arrest and the day that followed it, and when reassured by the visits of his legal friend and adviser, he rose again to the great conflict and was calm. Calm everywhere, at all times, under all circumstances, so long as he had anything to resist, to fight against. This power has been at his command. It has failed him only when fear, the fear of exposure, detection, like the sense of guilt, crushed all his manhood out of him. Take any shape but that, he has been able to say, and my firm nerves shall never tremble. Mr. Franklin Dexter, who is sitting near the prisoner's counsel. Footnote, Dexter Franklin, 1793 to 1857, born Charlestown, Massachusetts, member Massachusetts House and Senate for many years, United States District Attorney 1841 to 1845, 1849 to 1854. End of footnote. Is there any evidence that I interfered in this matter? Mr. Clifford, there is evidence, sir, that you was sent for to visit him at the jail. Mr. Dexter, I should like to know who testified to it. Mr. Clifford, gentlemen, I shall have occasion to advert to this again. I am here to discharge my duty with fairness and justice to everybody, but with fearlessness also, whatever may be the impressions of those around me. I have mentioned no man's name and alluded to no man's presence who does not appear in this cause. I now come to state the evidence which attaches to the prisoner and shows him to have been connected with the murder of Dr. George Parkman. We have waited for an explanation of this evidence, and we have waited in vain. Undoubtedly we repel, as by an instinct, the presumption that such a man as Dr. Webster could commit such a deed. I was not unimpressed with the comments which the counsel made in view of such a proposition. His former fair reputation, as shown by the evidence, is admitted. The fact that he held a professorship in Harvard College is evidence enough of this, and it is honorable to us that we do hold education in such respect, that when an educated man, and a man holding a high social position, is charged with a crime, our people, not the educated alone, but the humble, the illiterate, repel at once the probability of its truth. But, gentlemen, we deceive ourselves. The annals of crime forbid us to indulge this pleasant delusion. We have been too much accustomed to regard it as native only to the low levels of social life, as skulking out from its dark hiding places of squalor, ignorance, and depravity, to inflict its deadly blows upon society. But the history of great crimes of violence shows us that neither intellectual culture, high social position, nor even the refining influences of cultivated domestic life can prove a shield against strong temptation, acting upon a frivolous and neutral character, upon a character that has not its anchorage deep and firm in steadfast religious principle. There is a class of character, thank God, and we have instances around us now which of itself would be almost sufficient to countervail any amount of circumstantial proof that those who bear it had been seduced into crime. But the proof in this case, which shows the connection of the prisoner with Dr. Parkman, forbids us to class him in that category of men of unapproachable virtue. It prompts rather the sad suggestion, see what a goodly outside falsehood hath. When we see the best and purest men among us take the stand to testify to his former reputation, this case must go far to correct the popular notions on the subject. It must impress us with the great truth that out of the heart of man, not out of his head, are the issues of life and all those restraining influences which keep him in the way of virtue. If the influences which come from within are wanting, no matter what his degree of intellectual culture, no matter what the graces and accomplishments of which he is master, no matter what may be his reputation among those who can see only the outside of the man, when the great trial of temptation comes, the temptation, it may be, to keep from exposure and ruin that very reputation, a fear though a false one, he knows not, no one can know what he may be left to do. The work of spiritual dilapidation may have been going on within him, unobserved by the world's eye, and the first indication that the fair outside fabric of his character is not free from crack or blemish is in its sudden, utter, and irretrievable fall. There never was a maxim so much perverted in its application as that which has been cited and dwelt upon by the council, both in the opening and the close, that no man becomes suddenly vile. This may be true, but it does not follow that the first overt act of guilty is the first step from virtue. It is the first, perhaps, that the world sees, and yet the world's judgment may have been long an erroneous one. Between such a man as I have described and the poor outcast, with whose face the prisoner's talk is associated, there are two modes in which the world arrives at its decision and pronounces its judgment. We tried the other day in a neighboring county a man born and bred among us, under the influence of our institutions all his life, for the murder of his wife and two sleeping children. For one in his condition, insanity was the ready and obvious defense, while if he had been an educated, gently nurtured, simulating sinner, the cant of the day would be as obviously suggested the other answer, that the moral evidence outweighs the circumstantial proof. Such a crime could not have been committed by such a man. No, gentlemen, wherever and in whatever outward circumstances you find the heart of man, with all its deceitful passions, and in the strong language of Holy Writ, its desperate wickedness, there you will find the liableness, too, and the potentiality of crime. And it is fortunate for society that it is upon no fine theories, which it may be pleasant but fatal to us to cherish, but upon the legal proof presented to them, that the duties of jurors are to be discharged. You are to try this prisoner upon this proof, and from that you are to say, as reasonable men, whether this charge against him has not been made out by the government. End of section 37. Section 38 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 28. Before going to that proof, it may be proper for me as a set-off to some of the cases cited by my friend on the other side in his opening, to present a few historical cases of an opposite character. I have before me a list of them, from which I will select 2 or 3, the study of which leads to the precise result to which my recent remarks have tended, and which are in answer to those cases and those considerations which were presented to you by the counsel on the other side. It is now just about 100 years since, in our mother country, an accomplished scholar, a lecturer, and teacher was arraigned before the highest judicial tribunal of that realm to answer to the charge of having murdered 12 years before another man for money, and the evidence that that man was dead was the discovery of his bones in a cave, where they had been deposited by the murderer. During that interval of 12 years, that murderer, with the red stains of blood upon his hands, had wielded the pen of a scholar, had corresponded with the most learned men, was engaged at the time of his arrest in the preparation of a most learned dictionary, which embraced a knowledge of other languages besides his own. That accomplished scholar, Eugene Aram, who has been the subject of a celebrated work of fiction, of a history stranger than any fiction, was tried, convicted, and executed for that murder, committed 12 years before. So with the Reverend Prelate of the Church of England, Dr. Todd, who was executed during the last century for a crime which the whole civilized world held up in its hand with horror, to find perpetrated by a man like him, and yet he confessed it all. But we need not cross the ocean or the century to obtain such instances. Take the case of Colt in New York, for the murder of Adams. There was an indebtedness, and the victim was beguiled by an appointment into the place of business of his murderer, and slain for a paltry debt. The case in New Jersey of Robinson, who killed Mrs. Sniden in his own cellar, and by a strange concurrence of circumstances was detected, was tried and convicted, then confessed, and was executed in another instance. Take the case of another educated man, Dr. Coolidge of Maine. What was there to have prompted him to crime, any more than the unhappy prisoner here? No, gentlemen, it is not in any considerations derived from the cases cited by the defense that you are to look for the exculpation of this prisoner, or to have the weight of this evidence impaired in the least degree. Reputation is one thing, character is another. A man who could do what is proved by the most incontestable evidence the prisoner has done cannot come here and stand before a jury and put himself upon his character and nothing else, without asking them first to obliterate all moral discriminations and to surrender to a prejudice the real convictions that the facts must force upon their minds. Now, gentlemen, let us come to the consideration of the facts which go to show that Dr. Webster was concerned in the death of Dr. Parkman. I think I have shown hitherto that Dr. Parkman never left that building after he went into that college, that all the evidence of his having been seen that afternoon is really of no account, that it could not have been slain by any other person, that it could not have been done, especially by Mr. Littlefield. And now we come to the consideration of this great question. Was he slain by the prisoner at the bar? First, let us consider the relation which Dr. Webster bore to Dr. Parkman. I do not know that I care to have a better description of that than was given to you by my learned friend who closed this defense. He expressed it in connection with the proposition that, if he did commit the act, it was manslaughter and not murder. He represented him, and I adopt the description so far as it shows Dr. Webster the debtor, whom his creditor believed had done him a fraudulent wrong, and that Dr. Parkman was acting upon that belief and pressing for the payment of his debt. And I think it is true that, when you take into account the fact that Dr. Webster had promised Dr. Parkman from month to month and from week to week and from day to day up to the time of that fatal Friday, that he should have his money from the proceeds of the sale of his lecture tickets, then, when he knew that all the proceeds of these tickets were appropriated to other objects, that he could not pay him from them, when you see also that Dr. Parkman held a mortgage on his household furniture, when you see that he had threatened him with exposure, for it appears from a communication made to Dr. Parkman by Robert G. Shaw, that on the 9th of November, 2 days after the lectures commenced, Dr. Parkman calls upon him, that on the 12th and 14th he calls on Mr. Petit, that on Monday the 19th he calls on Dr. Webster again, which is an important fact ignored by Dr. Webster, that afterwards Dr. Webster sent a note to him, which the council regretted could not be here. I join in that regret. Every possible search has been made for it. He doubtless had it in his pocket when he was murdered, when that is followed up by a visit to Cambridge on Thursday, and the toll gatherer tells you that he came down to the bridge about that period more than once, inquiring for Dr. Webster. When we consider all this, we have a pretty clear understanding of the relations between these parties. Dr. Parkman is following him up continually. For what? Dr. Webster has no money to meet him. What is his condition? Here is this creditor, inexorable, as he calls him, and as his counsel echoes, inflexible, I think, would have been more just. The cloud over him is broadening and blackening day by day. What can he do? What is he exposed to? The disclosure to the world of his false but fair character, the exposure of his fraud, but more, and that which comes nearest home to the bosom of such a man, for I grant you he has strong domestic affections and warm attachments. That which comes nearest home to the bosom of such a man is, that all his effects were liable to be seized at any moment, and his home stripped to that which stood as security for his debts. His household furniture was all that was left. The minerals, as you will see, when you examine the mortgage, were already disposed of, and money raised on them to pay his debts. That had all been exhausted. You will see by the papers we put in that his friends' benevolence and beneficence had been exhausted, and he had no resources left. He was left stripped and bare to receive the shock coming upon him from this creditor, whose just indignation he had reason to dread. What was involved in this impending blow, which he thus feared was about to be struck home upon him? The loss of caste, the loss of reputation. We could not stand an hour with that reputation assailed and exposed. Now, gentlemen, when you come to motive, I undertake to say that no poor illiterate outcast from the dregs of social life, who prowls out from his hiding place to steal the bread for himself, starving, or for his starving wife and children, ever had a motive which addressed itself with more force to him than was thus addressed to this prisoner by circumstances like these, to get rid in some way, in any way, of this tremendous cloud that was darkening all around him and deepening every hour. Certainly he was the last man with whom Dr. Parkman is shown to have been in contact. Dr. Parkman is found dead on his premises, and enter his lock and key, and he gives no explanation. His property is found in his possession, and he gives a false account of how he came by it. His body is mutilated under such circumstances as I have shown you could not exist without the prisoner's knowledge. His own movements, acts, declarations, and the unconscious disclosures, which his fear of detection wrung from him, are evidences of his guilt. Now, gentlemen, what were his financial relations to Dr. Parkman? Here is a most instructive chapter. Dr. Parkman had held 2 mortgages, one to secure the $400 note, which was given in 1842, and another which secured that note and another note for $2,432, which was given in 1847. The mortgage that was given in 1847 covered all his household furniture, all his books, minerals, and other objects of natural history. That cabinet had been disposed of, so that all was left to secure his mortgage was the household furniture, and what books he may have had. That $2,432 included the $400 note. In 1842, Dr. Parkman had made a loan to Dr. Webster of $400 and had taken a mortgage. He took his note for $400. In 1847, a loan is made to Webster, of which Dr. Parkman contributes $500. The whole amount of that loan is $1,600. In addition to that, there is a balance of $332, which was included as an indebtedness to Dr. Parkman. $500 contributed, and $332, which is still due on the $400 note. Dr. Parkman takes the mortgage for himself and for all the other contributors in his own name. Dr. Webster, in the meantime, according to the statement found in his possession made by his friend Mr. Cunningham, had paid all Dr. Parkman's portion of that loan, except $125, which the doctor, as a mere act of kindness, had given up. Now, on April 25th, 1849, the actual indebtedness from Dr. Webster to Dr. Parkman was $456.27. That was made up of three items: the old balance of $348.33 upon that $400 note, $125 of the new loan, and from these is to be deducted $17.56, which Mr. Cunningham says Dr. Webster has the receipt for. Those you will see are the items which make up $456.27, and they are all due at different times. All Dr. Parkman's interest in that $2,432 note is included in the $456.27. Then Mr. Cunningham tells him, "You owe Dr. Parkman $456.27. Mr. Prescott, $312.50. Mrs. Prescott, $125. Mr. Nye, $50. Mr. Cunningham, $25, for a total of $968.77. Now, do you think that Dr. Parkman, with his habits of business, intended to go to Cambridge and cancel that mortgage? You will remember that I invited the counsel to explain this, but they stopped their evidence at this point, and so it stands upon the papers. Now, Dr. Parkman never intended to carry that mortgage to the medical college with any such purpose. Other parties had an interest here. He says on this very note that the other mortgage of the $400 note is to be canceled when he receives $832 on the large note. He had received $375 before Mr. Cunningham made his examination. Then there was a balance due him, as we have shown, of $456.27. Chief Justice Shaw. What was the date of the note of 1847? Mr. Clufford, it reads as follows: January 22nd, 1847. Value received. I promised to pay to George Parkman on order $2,432 within 4 years from date, with interest yearly, a quarter of said capital sum being to be paid yearly. John W. Webster. You see that this note is at 4 years. That reminds me of another thing. It was not due. Value received. I promised to pay to George Parkman or order $2,432 within 4 years, but a quarter of it only was to be paid yearly. If he did expect to get his pay, what would he have done? Would he have given up that note to him, leaving his friends to seek their remedies as they could? Dr. Webster had his statement from Mr. Cunningham in April 1849. It was a sum without interest. Having obtained these notes from Dr. Parkman, having got these notes into his possession, he is to make up his story, and in order to do that, he must fix upon the sum he had paid to Dr. Parkman. He did not owe Dr. Parkman $483.64 on the 23rd of November. We prove that by his own documents. We prove it by the papers found in his own wallet. He sets down to frame his story, and there is the most extraordinary document ever found in the pocket of an honest man. You will remember the interviews he had with Dr. Parkman. On the 9th of November, Dr. Parkman calls on him. On Monday the 19th, he calls again and leaves him with that declaration: "Tomorrow something must be done." The next day he writes the note. You will find that the Monday night of the interview is entirely ignored. Nothing is said about the doctors going over to Cambridge to see him. Nothing between the 9th and the fatal 23rd. What is the story he prepares? He tells it twice on the same piece of paper. What is the object of that? Is a man keeping a journal on such a piece of paper as that? If he were, it is important. If he is writing an account of consequence of the disappearance of Dr. Parkman, why, he had already communicated it to Dr. Francis Parkman, to Mr. Blake and others. But, gentlemen, there is intrinsic evidence that here, on the 23rd, he did not owe Dr. Parkman $483.64. That was not the sum he owed him. He is to sit down and fix that sum. Here is his paper. November 9th received $510. For Dr. Bigelow, $234. Petit, cash, $276. Dr. Parkman came to the lecture room, took the front left-hand seat. Of what importance was that? Suddenly stopped, came to me, and asked for money, desired him to wait till Friday, November 23rd. Thus, you see, stepping over entirely the evening of the 19th, as all the tickets were not paid for, but no doubt would be by then. A good deal excited, went away. Friday, 23rd, called at his house about 9, told him if he would call soon after 1, he should have the money. He called soon after 1, and I paid him. Now there is added to that at a different time, with different colored ink, $483.64. There is added, said I owed him $483.64. This would imply that he had fixed upon his story. Here are his own figures, and yet he states that Dr. Parkman says he owed him on the 9th $483.64. And he says on the 23rd, after a half-month's interest, that he paid him just that sum. Do you think if Dr. Parkman was standing on points like this with this man, that if he owed him that amount on the 9th, he would not have insisted on the $1 or $2 interest, which would have accrued on the 23rd? Do you think he would have said nothing about the continuing of the interest to the 23rd? Then, on the paper which Dr. Webster wrote afterwards, I think you can see between his writing these 2 pages that he had fixed this amount in this way. $456.27 to April 25th, 1849. $27.37 interest, for a total of $483.64. Now, if you will reckon, you will see that this is 6%, which would carry it over to April 25th, 1850. Do you think that Dr. Webster would have paid a year's interest when only 7 or 8 months was due? Perhaps you will say that he did not do it, and that this amount is made up from other items, from the $125 and the $17.56, to which I have already alluded, which was a receipt of money which Dr. Webster had paid Dr. Parkman. But he evidently did do it by casting this year's interest, as we show by his own figures. Now, to say that you are to cast 6% on all the above items is palpably wrong, because he had different times for which to compute the interest on the several items. The computation is made at the 6% on $456.27, and it brought him $483.64. Now he says, 9th, to Dr. Parkman $483.64, by his account, desired him to wait till Friday the 23rd. Friday, 1.5 paid. He to clear mortgage, and the other matters which are not material. You will have the paper with you, and you will see for yourselves. Here is another piece of paper. Here is found in his wallet a little piece of paper bearing the figures $483.64, and another little piece which had reference to something else. Jug, keys, tin box, sorter. I do not care to go into that. Why is this memorandum of $483.64 put into his pocket and carried about? It is evidence that it is all a falsehood, but it is a fiction which concerns his reputation, which concerns everything dear to him, that he should be consistent in, and it would not do for him to change it. Having committed himself to Parkman and Blake, he must adhere to his statement to them, lest he should omit by some slip of the tongue, giving the right amount. He carefully puts down $483.64 and puts it into his wallet, and carries this a double version of the affair, omitting 2 interviews, making a rate of interest which did not exist. And then, gentlemen, what is more important than all, there is found in the way in which you have already been apprised, through the letter written to his daughter. Tell Mamma not to open a little bundle which I gave her the other day, but to keep it. A bundle that turns out to be these 2 notes, and yet from beginning to end, he represents Dr. Parkman as taking that money from him, turning suddenly around and dashing his pen through the signature. He says not a word about 2 notes, expressly confining his statement to 1 piece of paper, and yet here are found in his possession 2 notes, bearing those marks which, if made by Dr. Parkman, must have required those dashes to have been made. As it is proved, neither one of them was made by a pen. That is placed beyond question by the uncontradicted testimony of both the experts, Mr. Gould and Mr. Smith. We can show you how it might have been done. You will have an opportunity to see how it might have been done by a peculiar instrument found on his premises. But at all events, he has falsified, and it is not the most serious thing about which he has falsified. End of section 38. Section 39 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 29. I hope, gentlemen of the jury, I shall very soon relieve you and myself from the examination of this painful case. I am aware I have already occupied more of your time than I expected I should have occasion to, and I thank you for your patient attention. But there is a duty resting on me which I cannot evade. I proceed now to consider, in connection with the remarks I have already submitted to you this morning, the proposition that Dr. Webster has falsified, notwithstanding all his declarations, and you will judge how consistent these declarations are when you come to consider the statements he made to James H. Blake, to Mr. Littlefield, and to Dr. Parkman on Sunday, in connection with the statement to Mr. Thompson, his own witness. This last named witness, under his own hand, has testified that Dr. Webster told him there were 2 persons present when he paid the money, and he now states that he thinks he was told there were 2 persons present, though he is not quite certain that this was the statement, but that there were 2 persons, one of whom was the janitor, who had just left. Now either of these statements was untrue. Then the statement he made to Mr. S.P. Blake about his entrusting the mortgage to Dr. Parkman to carry it over to Cambridge to cancel it is untrue. Dr. Parkman would never have attempted to cancel that mortgage, involving as it did the interests of other parties. Then take all the circumstances under which he states that Dr. Parkman received that money and went out from that building with the bills in his hands. I put it to you to say whether that representation was true. I now come to a more serious matter still. I say to you that, from the evidence in this case, he told the toll-gatherer that he had paid Dr. Parkman when he had not paid him. I say to you from the evidence here, and from the absence of evidence, that he never paid that money at all. Take the deposits in the Charles River Bank and the manner in which they were drawn out, and compare them at your leisure with the account which Mr. Petit rendered here, as the collecting agent of Dr. Webster at the times he paid him money. It now appears that the whole number of students was 107. Mr. Petit has accounted for 99. Mr. Littlefield for 2. Where could he have obtained the money to pay this? Not from the sale of the tickets, the proceeds of which he had, in his embarrassed circumstances arising out of an improvident mode of living, which of itself is dishonesty, devoted to other objects. A man who lives beyond his means, knowingly, and trusts to the chances of making others the sufferers, is a dishonest man. Take these representations and take the evidence before you, and then ask from what source he derived that money, and you have the great overshadowing falsehood which goes to the root of this whole case. This prisoner and his counsel have never been unmindful of the great importance of showing where he got the money to pay that $483.64 to Dr. Parkman. Let me say that for 4 months he has held at his command the entire treasury of this Commonwealth, to summon here every witness from whom he had received $1. You will observe the coroner's inquest was held immediately after this terrible event. You will observe that the moment the results of that inquest were placed in my hands, they were passed to him before I had read them myself, and he has had them from that hour to this. I am willing to take a still more recent period, the finding of the indictment in January 1850. I am willing to take that as the time from whence they saw the importance of ascertaining where the money came from, but not a syllable of explanation is vouchsafed to us. And why? Because he had no money to come from any quarter, least of all from that which he declared to the toll-gatherer it did come from, the sale of tickets. The law of this Commonwealth places its entire treasury at their command. Every dollar expended for witnesses, or for the officers who summoned them, is paid by the Commonwealth as well for the prisoner as the government. He is like nothing in the vigilance and acuteness of counsel, in knowing all the points made against him, or in furnishing the means that could explain them. Every student that attended his lectures might have been summoned. Everyone who has paid to Mr. Petit or anybody else could have come upon that stand and shown us to a mathematical demonstration how much he has paid and to whom. Gentlemen, not $1 is shown. By the comparison of these two accounts of the deposits in the Charles River Bank and the payments made to Mr. Petit, you find a perfect coincidence with a single exception. On the 14th of November, Mr. Petit paid him $195, and on the next day he deposited $150. And now the suggestion is that he took out a $100 bill of the New England Bank and substituted other smaller bills for it, that he took out the $45, and that he was gradually hoarding up the sum to pay this note. This is too transparent a fallacy to put to the intelligence of the jury. We come to the unhappy conviction that, if there is anything proved here, it is that Dr. Webster had no money to pay to Dr. Parkman, that he was compelled to prepare his statement and his story, and he did it in the manner I have stated to you. Then, that interview with Mr. Petit, what does it indicate? Why, gentlemen, it was an accidental interview. Mr. Petit states to you that he communicated no message. He calls there at 9 o'clock on that fatal morning, and what does Dr. Webster try to impress upon his mind? Why, he tells him that audacious falsehood, that Dr. Parkman was a peculiar man, subject to the aberration of mind, that he had placed his business out of his hands, and put it into the hands of Mr. Blake. But, he said, you will have no more trouble with Dr. Parkman. I have settled with him. That was after he had made an appointment with him to go into the medical college, where, separate and surrounded and walled in from all the rest of the building, his own apartments were, as Dr. Holmes testifies. And is there not a strange inconsistency in the story that he went to Dr. Parkman's to have a settlement with him? Why not have paid him there? Is there a particle of evidence that he was in a better condition to pay his at 1:30 than at 9 o'clock? Did not Dr. Parkman do business at his own house? If he had the money, he would have said, "Thank God, I will get rid of this creditor now. What evidence is there that he received this money between 9 o'clock and 1:30? Whoever there was who paid him in that brief interval, they have had the resources of this government to bring here upon that stand and enlighten you. And believe me, nothing which they could do has been left undone. If he did not pay Dr. Parkman, and that he did not, is apparent from all these facts, and perhaps as strongly from this fact as all others, that Dr. Parkman never would have given up that note or canceled that mortgage, which involved the interest of other parties. Never in the world. If he did not pay the money, if he did not have the money to pay with, then how did he get those notes? You will find a little memorandum on one of them, that it was paid November 22nd, 1849. Was that the first thought, corrected afterwards by an afterthought, that Dr. Parkman might have shown these notes to Mr. Kingsley or Mr. Shaw, or somebody, on Friday morning, and therefore that it would be fatal to him to have it understood that he paid him then? Was it prompted in the first instance by the fact that at 9 o'clock he had told Mr. Cbteddy he had settled with him? Dr. Webster did write in his own handwriting, $483.64, balance paid November 22nd, 1849. Then, gentlemen, the whole thing is changed. The story was prepared as I have already told you, evidenced by the documents found in his possession, evidenced by the documents which he attempted to conceal. You remember he impressed upon his wife to keep the bundle and not to open it. I ask again, if he did not pay those notes, how came those notes in his possession? What becomes of all these contradictory and inconsistent theories that Dr. Parkman was murdered by somebody else or elsewhere? I put it to your intelligence. Answer that. Now, gentlemen, I shall briefly consider the evidence which goes to confirm all this. I am reminded, gentlemen, and it is a fact that I should not forget, for it is pregnant with importance, that on that Friday morning Dr. Webster did receive from Mr. Cbteddy a check for $90 of the proceeds of the tickets, the source from which he said he would pay Dr. Parkman, and from which he afterwards said he had paid Dr. Parkman. And yet we find from the books of the bank that this identical check for $90 was deposited by him on the next day in the Charles River Bank. I leave here all this matter of finance, with this exposition of the significant truth thus developed by their financial relations. What was the condition of things in that laboratory when those remains were found? I shall go less fully into this than if I had not consumed so much time, so much more than I expected, upon the earlier topics of the case. There are some things which I should do great injustice to this case to overlook. In the privy vault with the remains, there were found certain towels which were produced here. I especially call your attention to the fact that some of these smaller towels were marked W. One of them, it is here clearly in proof before you, was in that laboratory and in his upper room on the very morning of that Friday when this fatal interview with Dr. Parkman took place. Then, gentlemen, that knife found in the tea chest, why, the counsel for the defense overlooked in their comments upon this the important fact which they themselves had put into this case by the cross-examination of one of the government witnesses, that on the 17th of November, that knife was over at Cambridge, and afterwards, between the 17th and 23rd, was brought over to the medical college. Now, it is said that that is evidence of design to fasten suspicion upon Dr. Webster in connection with the remains, and that the minerals which were not entirely covering the tan on Tuesday, when Kingsley saw the fire and tea chest, were not put there by Dr. Webster. The very fact of that search, that Mr. Kingsley's attention was called to that, would it not prompt him to have piled on more minerals, and was not that done, evidently? And the knife was found there. It had been in his possession, and who, pray tell me, if I had not utterly failed in making myself understood, who could have done this but Dr. Webster himself? And gentlemen, it may very well be said that if that hammer, the disappearance of which is one of the marked facts in this case, has been got rid of, He might also have been equally anxious to be rid of the knife. The yataghan was there, a murderous-looking instrument, recently cleaned as Dr. Jackson testified. As you will see, it is enough for me to say that here were murderous instruments connected with him, and with no other human being. Why, too, did he have that tan sent over here in that suspicious way? Why not let Mr. Selwyn have admission to his laboratory, as he had done 200 times a year before, as he swears to you? Whether it was to be used for the tea chest or the tin chest, neither you nor I can tell. It is an anti-putrescent, and would stifle odor. And what is more significant, although Mr. Selwyn brought over for him 2 empty boxes, the faggots, and the bag of tan, the bag of tan was taken into the laboratory by Dr. Webster, and the others left outside. If anybody else had done this after his direction to Selwyn to leave them all outside the door, would not Dr. Webster's eye have discovered it? There was charcoal and anthracite coal and pitch pine kindlings, which disappeared in considerable quantities during that week. The process was slow, and I will tell you why it was slow. He had those clothes to get rid of. The minutest circumstances are sometimes most important. The report of the physician shows that there was among the remains a shirt button, and if he separated the body from the clothes, remember that he had the clothes to get rid of as well as the flesh, thus accounting for the time expended. And the blood upon the pantaloons and the slippers. These were treated of in a very summary way by the counsel, as being of no consequence. I submit whether they are or not. If they were drops of blood falling from above, then I agree that it must have had much less weight than it will have, as the facts are shown by the testimony of Dr. Wyman, that it was probably spattered from beneath. And then those stains upon the stairs. They were there when Littlefield saw them, tasted, and found them acid. His testimony is abundantly corroborated by Dr. Wyman, who says that they were fresh. Kingsley saw them also. It turns out that they were nitrate of copper, and I defy any man to look upon them as you have looked at them and believe that they had not been thrown there by design, spattered as they were, up against the perpendicular sides of the stairs. If my eyes did not deceive me, and you have had the same opportunity to examine them that I have, I submit whether I am not right. It is proved that they were fresh, and they are shown to be among the most efficient agents for removing the characteristic signs of blood. Dr. Wyman tells you water is as good for this purpose as anything. Water was used most freely. The cachichu was always running. The party had succeeded in removing all other traces. That which confessedly was done would have been more difficult than the removal of the traces of blood, if traces of blood there were. If the mortal wound did produce an external effusion of blood, to the extent that would seem to be implied by the course of argument on the other side, which by no means appears from the testimony, as a man may be stabbed in the region of the heart, and all the effusion, or almost all of it, be within the chest. Here were the means of removing blood. Much was said of the overalls. We did not introduce them. I have no idea that he had on his overalls. I never made a point of it. So all that requires no answer. Those skeleton keys, did he state truly where they came from, or was there a connection between them and this transaction? Was the filing done by himself? For remember, they were filed. And is it a probable fact that the keys that would open the dissecting room were picked up by him in the street and carelessly thrown into that drawer? We cannot trace the course of such a man's inexplicable conduct, any more than you can trace the course of the serpent upon the rock. But there are signs and indications which will not be lost upon intelligent men. Then we find that in his private room there were grapples made from fish hooks, which had been purchased on the previous Tuesday. And when you come to examine them and take the whole testimony in relation to them, you find that the first grapple was made of 3 hooks. You will find that they had been used, that oxidation had commenced upon them. One of them had become quite rusty. Then one was made of 2 hooks, then one of but 1. Then he goes and purchases on Friday smaller hooks, all the time flitting between the college and Cambridge to keep up his alibi. And then you will determine for yourselves whether importance is to be given to this fact of the fish hooks. You find around the thigh of these remains a piece of twine, which the council have treated in a contemptuous manner by saying, if there had been a ball of twine, he would have been as likely to have taken that as he would to have been there, overlooking the fact that that twine was not found down in that laboratory, nor in the upper laboratory, but in the private room of Dr. Webster, to which he alone had access and in his private drawer. And I ask you whether this does not connect him directly with the remains in the tea chest. Then the mode in which that body was cut up. I have adverted to the attempt to destroy it by alkalis, but I come to what is of more importance than any other fact, connected with the condition of things in that laboratory. Dr. Webster, gentleman, carried in his pocket the key of that privy, in the vault of which were found those remains. There is a fact in this case which has not even been alluded to by his counsel. Gentlemen, I ask you to look at that key when you are alone and ask yourselves the question whether a gentleman, a man of culture, would be likely to carry around in his pocket so cumbersome a key as that, which he could, by no possibility for any honest purpose, use anywhere else. When that key is called for, what is his answer? It hangs up yonder. It is not found there. The key of his wardrobe is found. He says, I do not know, then, where it is. Then that door is broken open, and it turns out afterwards that while they were at the jail and before they had gone to the college, that privy key, which locked up those remains, had been borne about in the prisoner's possession, and was taken from his pocket by the person who arrested him. In the great case of Courvoisier, for the murder of his master, Lord William Russell, that case which has made all Europe ring with strictures upon the conduct of the council, whether just or unjust, the great fact insisted upon was that the bloody gloves were found in the trunk of the prisoner, put there, as it was contended by his counsel, at a subsequent time to fasten suspicion upon an innocent man. Here were the remains themselves found, not in the trunk of the prisoner, but found in a place to which he alone had access, the key of which he kept in his own pocket, and the fact of which possession he denied. And you will determine whether I have said too much or said too strongly. Not only that this prisoner stands justly charged with the homicide of Dr. Parkman, but that his mutilated remains have been found under his lock and key. The matter of the blankets, of new blankets and counterpanes, is inexplicable to me. Why they should have been put there or carried there I do not know, and you will judge. I make no suggestion respecting them. End of section 39. Section 40 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 30. Now, what was his conduct and his whereabouts through that week? In the first place, he was locked into his laboratory at unusual times, during a week of official leisure. Has he shown or attempted to show that he was engaged in anything which required his presence there? That he was so locked in does not depend on Littlefield's testimony alone. Clapp, Rice, Starkweather, Fuller, Mrs. Littlefield, Mr. Samuel Parkman, Blake, Mr. Salwin, who had often gone there before, testified to it. The Cachucha water was running. No fires were wanted, and yet it is here in evidence, unimpeached and unimpeachable. The fires were kept up during that week, more intense than were ever kept there before, and in places where no fire was ever kept before. Gentlemen, when was he there? I have already stated to you, and to the court, that upon a critical examination of the testimony of his 3 daughters, there is a most significant and remarkable corroboration of the testimony of Littlefield. They do not conflict in any particular. He was there on Friday afternoon. What was he doing? Where did he dine? I have already asked you that question. It is worthy of your consideration. On Saturday morning, you have no trace of him. From Saturday morning at 1 o'clock until Sunday in the afternoon at 1 o'clock. Have you any assurance where he was during that interval? Is not the argument just and fair that he had come over in one of those flittings of his from Cambridge to the medical college? Nobody else had a key to the building but himself and Dr. Lee, and there is no pretense that Dr. Lee was there. The door was left bolted at night and was found unbolted in the morning. In the course of that forenoon on Saturday, when Littlefield went in to build his fire and was about to proceed down the laboratory stairs, he received for the first time in his life the peremptory order, "Mr. Littlefield, go out the other way." He went as he came in. On Sunday he was there. Then he had those interviews of which I have spoken, and upon which I do not care to dwell. In his interview with Mr. James Blake, his story was prepared, and you have been asked with great significance, if he were a guilty man, why should he come to communicate that interview? For nobody would have known it if he had not. If nobody was to know it, why does he have the notes? How did he know but that they had been exhibited at Dr. Francis Parkman on that very Friday morning? The fact that he communicated his interview is explicable on other grounds also. How could he know but that he would be remembered on that morning by the servant? And what a fatal fact if he kept it to himself, if it should turn out afterwards that he was recognized. But suppose he had been perfectly sincere, and had wanted simply to communicate with this family the fact of the interview. Then I submit to you, considering the relations between him and the Reverend Dr. Parkman, he would not, at least, have slept that night without sending a note to relieve the agony of that family. But he waits till Sunday, and is dissuaded from going in the morning in order to go to church. He had an early dinner on Sunday in order that he might go over and communicate with Reverend Dr. Parkman. But he does not visit him till he had spent some time in the college. He does not get to Dr. Parkman's house till 4 o'clock in the afternoon, and then he makes a communication, the object of which seems to be to impress on Dr. Parkman's mind just 2 things. One, that he had paid money to his brother. He was never to appear. These notes would be traced. He must show that he had paid them. The other, that his brother was in a strange condition, and that he rushed out in a hurry, indicating a disordered mind. And that concluded all that cold, businesslike, unsympathizing interview with the family of his own pastor, and the pastor of his children. Then on Monday, that striking interview with Mr. Samuel P. Blake, when he braced himself up to answer questions. It is commented upon by the counsel that he was too warm in his interview with one and too cool in his interview with the other, but both are consistent with the theory I have suggested. I come now to another subject. Mr. Blake said that he, Dr. Webster, told him enough to make him believe that Dr. Parkman took that mortgage from him, although we find that very mortgage in Dr. Parkman's house. We find an interview with Fuller and Thompson on Sunday night. Mr. Thompson did not observe what Fuller did, and Fuller did not hear what Thompson did. They are to be taken together. Mr. Fuller witnessed the agitation of Dr. Webster. Mr. Thompson heard by statement of his interview with Dr. Parkman. This is all evidence, and the statements that either 2 persons were present when he paid the money, or 2 persons, one of whom was the janitor, had just left, were both fabrications. On Tuesday he wanted no fires. His lecture would not bear the heat. Is it true that, with the knowledge of this fact, the counsel can turn around and say that the counsel for the government have not shown that it would bear it? Dr. Webster could show by the students what his lecture was that day, and then the chemist here could tell whether it was a matter to bear heat or not. This is for him, and not for the government to show. Then Clapp's search. It amounts to nothing except the leading away from the privy and opening of another door, through which Dr. Webster led them. Mr. Kingsley saw a fire in the assay furnace on that Tuesday. That fire was burning, and Dr. Webster was there, and the tea chest was there also. The tin and the minerals in it on that day. Then, gentlemen, he gives that turkey to Mr. Littlefield. If there was an attempt at conciliation, it was not an attempt of Littlefield's, but of Dr. Webster, so far as it amounted to anything. And it is consistent with the fact that he stated that he had such a horror of this man. If you believe Mr. Littlefield, on Wednesday, Dr. Webster was at that furnace. He was away from home by the testimony of his own daughters. Fire was burning. He locked up everything fast, covered up this fire in the furnace, and left it to burn and smolder away. Then his other object, that of keeping up the alibi, was to be attended to. He was at home at dinner on Tuesday, but he came into town on the afternoon. For what purpose? So far as it appears, to give Mr. Littlefield this turkey. Nothing else. On Thursday, Thanksgiving Day, he was at home after 11 o'clock. On Friday in the morning at 8 o'clock, he was at home. At 9 o'clock on that morning, he was at Mr. Waterman's shop ordering the tin box. It is said by one of his daughters that they were in the habit of sending plants to Fayal. If that had been the purpose of this box, never needed before, would it have required the strong handle? It, too, plants were to be sent in it would have been soldered up tight. Who ever heard of sending across the water live plants in a box so soldered up as to exclude the moisture and the air? More decisive than this, his daughter tells you that she does not know, as there was any intention of sending plants at that time. And Mr. Waterman tells you he never made such a box for him before. But that interview with Mr. Waterman is very significant. Dr. Parkman, he says very energetically, did go to Cambridge, and then he tells the story about a man's having seen in a mesmeric state a cab, the number of which was obtained, in which Dr. Parkman was carried off, and blood was found in it. I do not know how it strikes your minds, but that a teacher at Harvard College should be here, in the city of Boston, in the shop of a mechanic, trying to impress upon this man the truth of such a story as that, strikes me as singular. He followed up that day telling that same story to Mr. Littlefield and his wife. Then in the course of that day he buys the fishhooks, and in the afternoon goes over to Mrs. Coleman's and has that striking interview with her. Or was he trying to ascertain from her, or to make her say? Why, that Dr. Parkman was seen by her on Friday. Are you sure it was not on Friday? And even after she had given him reasons, and even after he goes to the door, he repeats the question, are you sure it was not on Friday? Trying to impress her with that idea. Then that night on that week, or some one of the nights on that week without his family, upon the evidence of Mr. Sanderson, the watchman, he went out in the late omnibus between 11 and 12 o'clock. I have thus traced him and shown that he did all that was competent for him to do, that he went to Treadwell's, not by invitation, but a casual call, that he played whist, which is all consistent with his subsequent conduct, and with that which he has shown here. It required nerve. He has it, and enough of it. Accepting and only accepting when fear fell upon him, and the dread of impending exposure made him afraid. Gentlemen, I have but a word to say in relation to these anonymous letters. The counsel has called your attention to one single feature, which was spoken of by Mr. Gould as characteristic generally of Dr. Webster's writing. He has called your attention to it in this letter, as being of a different character. That is, the figure 9. Look at that figure 9 and see if it is not evidently disguised. Then, there are some other circumstances in connection with this. I do not profess to be an expert, but when I find a respectable man like Mr. Gould, who has paid 50 years' attention to this matter, and another Mr. Smith, who has had perhaps 30 years' experience, coming upon that stand and saying to a jury that they have made a thorough examination and that they have no doubt that the handwriting is that of Dr. Webster. I think their testimony is entitled to some respect. If a mechanic should come and tell me, as a lawyer, that such a thing could be and such a thing could not be, and it was exclusively within the province of his art, if I believed him to be an honest man, I should defer to him. If a shipmaster should come upon the stand and undertake to tell me, as a lawyer, that under certain states of the wind and of the ship, such a result would happen, I should believe him, because he has experience and is competent to instruct me. And when a man comes and says that having had 50 years' experience in the examination of handwriting, that he has no doubt, and that is confirmed by the testimony of another witness, who also has no doubt, that it was written by Dr. Webster, then it is entitled to consideration. That letter is written by a man accustomed to composition. It is signed civis, the Latin word for citizen. It is written by a man who had some knowledge of the Latin tongue, who would be likely in a matter so interesting to the public to have undertaken to communicate with the city marshal under an anonymous signature. If it were Dr. Webster, and he was innocent, would he not have done it personally, making such suggestions as he considered important? Then other letters are not testified to so positively, namely the dart, and what I have called the Sanskrit letter. But you will find that the latter is written on a fine, delicate note paper. It was not written with a pen. That there was an instrument found in Dr. Webster's laboratory which is fitted to make this is proved. And that instrument is such an instrument as might have made those erasures upon the notes, which were not made with a pen. But I submit this part of the case to your judgment, without pressing it upon you. Gentlemen, I do not know but that I have said almost all that is necessary for me to say with regard to Professor Webster's conduct prior to his arrest. I now propose to add a single word respecting his conduct afterwards. I had spoken of his meeting Mr. Littlefield. He had spoken to Mr. Starkweather of Mr. Littlefield before he met him face to face. But that conversation with Starkweather is too important not to have your attention called to it for a single moment. Here is a man, certainly, of intellectual culture, of a certain degree of self-discipline, such as you would expect to find in an educated man. He is called upon at his own house, after his own premises have been searched for the missing body of one whose disappearance has excited the entire community. He is waited upon by 3 police officers. They say they wish to make a further search of his premises. He makes no objections. He calls their attention to the fact that Mrs. Bent had seen Dr. Parkman. He knew that story. Did it impress his mind that nothing was discovered? Did he suggest this in the hope that, on going to Mrs. Bent with these police officers, she might modify her statement? I stop at the Leverett Street jail. Mr. Clapp goes in and, upon returning, requests them to get out. He submissively and without inquiry follows them into the prison. Who is Dr. Webster, and who are they? He, a professor of Harvard College, and they, police officers of the city of Boston. He follows them, and not till they reach the inner office of the jail does he ask what it means. Mr. Clapp replied, not that Dr. Parkman's body was found, but Dr. Webster. You remember I called your attention to the soundings which had been made above and below the bridge. We have been sounding about the medical college. We have been looking for the body of Dr. Parkman. We shall look for it no more, and you are now in custody, charged with the murder of Dr. Parkman. He articulated half a sentence, continued Mr. Clapp. I could not understand it, and then he said, I wish you would send over to my family. I told him they would be better not to learn it till morning. He seemed inclined to speak a word or two, and I told him he had better not say anything about it. What was his conversation when he left alone there with Mr. Starkweather? And remember that not even in the cross-examination was it attempted to be shown that this conversation was not reported exactly as it was taken down. The appeal is then made to you to consider him as an irresponsible person, that he was in no condition to know what he was about, and that you ought not to regard his declarations any more than you would those of a raving maniac. He had intelligence and malevolence enough to endeavor, then and there, to make a causeless accusation against an honest, though a humble man. He did make inquiries, and from that time he was master of himself. He says to Mr. Starkweather, "You might tell me something about it." Immediately after Mr. Clapp and Mr. Spur went out, he asked for water. A pitcher was brought, and he drank several times. He asked if they had found him. I told him not to ask any questions, but it was not proper for me to answer them. No man ever had more consideration for Mr. Parker down to Mr. Starkweather than Dr. Webster had that night. He was expressly cautioned. He said, "You might tell me something about it. Where did you find him? Did they find the whole of the body?" I asked him if, with the knowledge this prisoner had that they had been sounding about the medical college and should look no more for the body, what prompted that inquiry? Did they find the whole of the body? "Mr. Foreman, or either one of you gentlemen, I ask you to put yourselves in the condition in which Dr. Webster was that night, being an innocent man. A tipstaff has put his hand upon your shoulder, and you are taken into custody. And the body, he says, of a murdered man is no longer to be searched for, because they have been searching enough, and you are arrested as his murderer. Now, what would prompt you to put such a question as that, not knowing that the body was cut up? Did they find the whole of the body?" There outspoke the guilty conscience, showing a knowledge that the body of Dr. Parkman was not in entirety, but separated into fragments. I then asked him if anybody had access to his private rooms but himself. "Nobody but the porter, who makes the fires." Next, a pause. Then he says, "That villain, I am a ruined man." He then put his hand into his pocket and took something, and then he had those violent spasms, and the other symptom that followed through that night, and in the presence of Mr. Cummings, the turnkey, while tossing upon his bed, unconsciously comes out from that confession. I expected this. Now trace him down to the medical college. He had had no information that the body had been found. Mr. Clapp told him simply that they should search no more. When he had reached the college and when they were searching the private room, where they can find nothing, then he is calm. But when they got down to the laboratory and it was discovered that the remains were found in the privy vault, then came that spasm again. And if you believe what the witnesses testified to, the sweat streamed out from upon him, though he was complaining of cold. His pantaloons were saturated and his coat moistened with perspiration. I ask you if this man, who has gone calmly through, innocent or guilty, more than any man I ever knew, whether you can believe that there was the mere prostration of an innocent man, or whether it was the guilty conscience that drew the sweat of that mortal agony out of him. When he found that there was nothing discovered but these remains in the vault, upon which no marks of identity, and which he did not see nearer than 9 feet, he says, why did they not ask Littlefield? They took me down there and asked no questions, and he comes here with no declaration of that fearful night, which had been extorted from him by inquiries. All that comes here is voluntary, unconscious confession of mute nature in the man. Now, I have but one other fact to comment upon, and I will relieve your patience. On Saturday, he remains in this condition. Mr. Andrews states to you that he went in there in the morning, and then he made that cruel accusation against Littlefield, although he said, not as the counsel put it to you, but in his own language, that is no more Dr. Parkman's body than it is my body. But how in the name of heaven it came here, I do not know. This is his defense, and it is expected that this asseveration, which is no more than his plea of not guilty, is to outweigh the proof. Gentlemen, Was he in that condition when he could have made an inquiry at any time? Can you conceive of any innocent man going along through 24 hours nearly, but was followed up during that day, and being perfectly mute, making no inquiry? The only thing was to ascertain from Starkweather what he could not tell him with propriety, and from that hour in which the remains were found, not a word escaped him in regard to the matter. He continued there till the police court on Monday. He says, "I will go to prison. I will let my family suffer the torture of suspense. I will let my name be blighted by the prejudgment of the world. I will not even ask them what their evidence is." Then he returns to that prison, and there he writes the letter containing this sentence. "Tell Mamma not to open the little bundle I gave her the other day, but to keep it just as she received it." Gentlemen, you had that letter with you. Here is a man of education. Here is a man who has lived all his days under the influences of cultivated social and domestic associations. Here is a man, a professor in a Christian university, whose motto is Christ and the Church. He is in the cell of a prison as he was described by his counsel, and he sits down under this terrible accusation, an accusation that he had been guilty of a crime at which the universal heart of the world revolts. And gentlemen, he is the victim of a conspiracy which has fabricated that accusation against him. He sits down to write to his daughter to ask his wife to conceal that which, when this note was read and the officers went there, turned out to be the two notes and that statement of the indebtedness of himself to Dr. Parkman. And you'll find it underscored, not to open the bundle. He is writing a letter for the first time to his daughter, and I ask you whether he indicates in that such a character as his counsel would claim for him. What is that letter? Not a word in it that he himself was assured of his innocence, and telling her to keep up her heart, for it would all be made right. Not a syllable which would strengthen and assure them, not a word of reliance upon God in that dark hour, but a paltry enumeration of his physical wants, and so on through a little pepper and a little tea. Gentlemen, I forbear. I submit to you that it is not a letter from an innocent father, the victim of a foul conspiracy, immediately after his imprisonment to a distressed and anxious child. I will not comment upon it. You will consider with what justice the claim can be made, and how it indicates character. Gentlemen, we have been asked here to consider that, if this act was done by Dr. Webster, it must have been in the heat of blood, provoked by contest, and therefore be considered as manslaughter. When the counsel said, "Would to God that he had rushed out and said, 'I have killed my brother man.' Remember what he did. Remember his plans, which repel the presumption that it could have been done in the heat of blood. I have not thought it proper to dwell upon the circumstances which imply premeditation, nor do I do so now. It is entirely immaterial whether he premeditated this one day or 1 minute. If you are satisfied that he did remove Dr. Parkman from this mortal life, however sudden, if it was done with an instrument likely to cause death, and unprovoked by a blow, then it is just as much murder as it had been premeditated it for months. We find in that the implied malice of the law. I leave it to you to say whether you do not find the express malice of the law. The treatment of these remains proves incontestably that there was the malice afterwards, if not before. As described by the great reader of human nature, it doth seem too bloody, first to cut off the head, then hack the limbs, like wrath and death and malice afterwards. I do not know as you could find in the books a better illustration of the implied malice of the law than this cruel conduct indicates. Have you any doubt from all this evidence that Dr. Webster had an agency in the death of Dr. Parkman? Can you doubt it for a moment? It is not a possible doubt that will shield you from your responsibilities. It must be a reasonable doubt. And, turning to the bench, I invoke your Honor's instruction to this jury as to what a reasonable doubt is. It is a doubt for which a man can give a good reason, and not a mere possible doubt that somebody else may have done it. And it is for you to say upon all this evidence whether you do entertain that reasonable doubt which is recognized by the law, and which, extended beyond its fair meaning, would leave society at the mercy of the passionate, the lawless, and the depraved. End of section 40. Section 41 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 31. Gentlemen, you have had appeals to you in behalf of the prisoner's family, both in the opening of the counsel and in the closing argument. God forbid that we should forget them, though he did. We will remember them better than he remembered the family of Littlefield, whom he could gratuitously charge with being the author of a homicide, or a conspiracy, which was worse, and more than he thought of the family of Dr. Parkman, when he was endeavoring to impress upon Mr. Petit, by a gross and audacious falsehood, that Dr. Parkman had been insane, taking away from them in their bereavement the consolation of thinking of him as he was, and as the proof has shown him to have been, on that fatal morning, in good health of body, his mind in its undimmed intelligence, and in unusually cheerful spirits. There is another family we are not to forget, that wife whose partner and protector has suddenly removed from her companionship, that invalid daughter on whom his last thoughts were most probably centered, and as was indicated by the purchase of that delicacy for her on Friday, that daughter to whom his kind and paternal presence made up the daily sunshine of her weary hours, but to whom, in his assiduous kindness, he will never come again, and that only son who was compelled to hear, in a foreign land, the heart-crushing intelligence that he should see his father's face no more, and who comes home to enter upon the large responsibilities which his father's death devolves upon him, without parental guidance and counsel. The family of the prisoner are not to be forgotten. Our hearts bleed for them now, but as one of the great providential penalties of sin, that the innocent must suffer with and for the guilty. In the official experience which has been common to my learned friend and myself, we have often seen the mother, the sister, heartbroken, appealing for mercy for some sinning, erring son or brother. Gentlemen, it is so everywhere, and no man can transgress the laws of God without involving others in the suffering that must follow. But is that a reason why we should fail to do our duty? Compassionately, it is true, but resolutely and firmly like men? It was the remark, gentlemen, of a great English statesman that the great object of all good government was to obtain a good jury. If in any government this is true, it is especially so in ours, which is a government of laws and not of men. The constitution of this commonwealth, as I have already intimated to you, as its first and highest object, has the protection of life, the security of human life against the violence of passionate and the machinations of wicked men. And, gentlemen, shall it fail of this, its high purpose? If you undertake to exercise here the prerogative of mercy, a prerogative which is assigned by that Constitution to another tribunal, how can you tell, gentlemen, what mercy is? I very much doubt indeed whether these murders, which are so thickened upon us of late, the investigations of which have crowded within the last few months our judicial annals, I very much doubt whether here in Massachusetts we should have had to deplore them all, had it not been for the weakness of jurors, who have permitted those proved to be guilty through a false tenderness of conscience to go unpunished. Remember that great maxim, which has been long honored in other lands, Judex Dominator, cum nocens absolviator. The judge is condemned when the guilty is acquitted. The juror who permits the guilty to escape convicts himself. If ever we have had a case which requires the jury to stand up firmly to the discharge of their great duty as citizens, it is here and now. The mercy which is to be exercised by a jury may be more effectually exercised by a conviction, oftentimes, than by an acquittal. How can you tell? Who can tell? How many great crimes might have been spared to humanity if all our verdicts heretofore had impressed upon the public mind and the public heart the certain conviction that judicial punishment follows, like its shadow, detected crime. I do feel, gentlemen, that upon 12 men here is resting a higher responsibility than ever rested on 12 men in Massachusetts before. Remember that we have had here, through these long and weary days, those whose labors will carry this trial, and all this mass of proof, unanswered by any explanations on the part of the defendant, into all lands, to be read in all languages, and to be read, gentlemen, as a memorial of you among all men, a testimonial of the degree of inflexibility and firmness which you shall have exhibited in upholding, paramount and supreme, the law under which human life has claimed and enjoyed protection in this Commonwealth of Massachusetts since its foundation by the Pilgrims. The judge to the prisoner, Chief Justice Shaw, prisoner at the bar. Before committing this cause to the jury, if you have anything to say, you may address the jury, making any statement that you think fit, and which you think necessary for your defense. I ought to inform you also that this is a privilege granted to you, which you may use or not at your own discretion. Professor Webster's statement. Professor Webster: I feel indebted to your honor for this kind permission. I cannot go into an explanation of the network of circumstances which has been woven around me, and which, in 9 cases out of 10, would require many hours to unravel, though to probably 9/10 of them I could give a satisfactory explanation. On all the points, testimony had been placed in the hands of the counsel, and my innocence would have been firmly established if it had been produced. But acting entirely under their guidance, I have sealed my lips, and from the first moment I have trusted entirely to them. They have not seen fit to bring forward the evidence on a great variety of subjects, which therefore have been brought to bear with consummate ingenuity against me. I trust they will not be considered against me by the jury. I will allude to 1 or 2 of the subjects which have been unexplained. I doubt whether the letter written by me from the jail to my daughter, and which has been read, was the first, because there were 2 or 3 long letters which I wrote about that time. The inference from the sentence in that letter, which led to the examination of my private papers by the police, was different, very different, from what was intended by me. The explanation of that sentence is as follows. I had read in one of the daily prints, which were distributed in the prison, some of the various fabrications which were made respecting me, and one of them which I saw was that I had purchased a quantity of oxalic acid. It immediately occurred to me that that very parcel referred to was saved and could be produced. For several days Mrs. Webster had reminded me of a want of citric acid, and laughed at me when I returned home for forgetting to obtain it. On the very day of my arrest, I stopped at Mr. Thayer's apothecary establishment in Bowdoin Square, conversed about half an hour on various topics, and purchased the citric acid. I carried it home and placed it in my wife's hands, saying, "There is your acid." I knew that the possession of the acid would show that it was not oxalic, and hence the request about the bundle not to open but to keep it had no connection with the papers. Mr. Charles Cunningham was at my house when the officers came there to examine. They broke open a trunk, examined it, and left. Afterwards, Mr. Cunningham opened that trunk and, in looking over the papers, found the notes lying there, and thinking they had been overlooked and that the officers might come again, laid them in sight, and made a memorandum of it in the presence of a witness. Then, with regard to Mr. Thompson, I conversed with him on this very point of aberration of mind, and also asked him if Dr. Parkman had in his hand, when he saw him, this very bunch of lettuce, and I think he added that he had a bundle. In regard to the nitrate of copper, either the lecture preceding my arrest or the one preceding that, I had occasion to show the experiments of changes of color in gases. I prepared a large quantity of the nitric oxide gas. In a 2-gallon jar were placed nitric acid and bits of copper. Nitric oxide gas is thereby produced. After standing a few hours, it becomes colorless, and during the lecture, by the admission of oxygen gas, it becomes of a bright orange color, the gas being changed by this experiment into nitrous acid. Blood, by the admission of oxygen gas, is changed from dark venous blood to florid red. And so I might go on and show how these circumstances which have been testified to have occurred. My very calmness has been brought against me. My trust has been in God. I have been advised by my counsel to remain as calm as possible. That money paid Dr. Parkman I had positively laid by, from day to day in this little trunk, and unfortunately no one can be produced who saw me pay it. Several years ago I had been in the habit of having students in my laboratory, but for a number of years I had prepared everything with my own hands. The reasons why I excluded anyone from my laboratory are obvious. I will not allude to them. This will serve to give the jury an idea of the perversions, as I must call them, which have been brought forward in this case. Every day from the Friday of the disappearance to the following Friday, I never was absent from my home after 9 o'clock at night. And as to being seen by Mr. Sanderson, it is altogether a mistake. I was at home every night. In regard to where I dined on Friday, I would say at about 3 o'clock I went toward the omnibus office to go out, but stopped in at Brigham's and took a mutton chop. From there I went to Kidder's, and from thence to the omnibus office. But accident put it into my power to show that I had been at one place on Wednesday evening. Having occasion to make a little present, I went to Monroe's bookstore and bought Humboldt's late work. I took that book with me, stopped again at Brigham's, and thence went to Mr. Cunningham's. On my arrival, I found that I had forgotten my book. They went to Brigham's and found the book, but unfortunately on the other occasion, I cannot prove the fact, and so it has been with the greatest number of other circumstances. I will not detain the court by detailing them. If the court will allow me to say one word more, I have felt more distressed by the production of these various anonymous letters, I had almost said, than by anything else, and I call my God to witness, while I positively declare I never wrote them. Since my trial, my counsel has received on this day a letter from this very civis, and if he is present and has a spark of humanity, I call upon him to come forward and acknowledge it. The charge of the Chief Justice, Shaw, C.J. Gentlemen of the jury, it is with the deepest sense of the responsibilities which devolve upon me that I rise to address you upon the most important and interesting subject that can be called to the attention of a jury. But this case has continued so long, it has been brought now to such a crisis, the whole of the evidence and the whole of the argument being before you, that we feel unwilling, notwithstanding the lateness of the hour, painful, responsible, laborious as it is, not to go on with the cause, that you may proceed to consider of your verdict. For this purpose, not because it is not important, but on account of the peculiar circumstances, I shall be more brief than I should otherwise be. But it is, after all, mainly a question of evidence. The principles of law for which the court are responsible are few, plain and simple. I shall be able to state them briefly, and it will be my duty to consider the rules of law, rather than make an examination of the evidence itself. Gentlemen, some appeals have been made to you upon your duties, I think after what is apparent of this character, after the long work of a fortnight, the mode in which the cause has been conducted, the degree of solemnity which has been affected the minds of all, must have already affected you more than any words of mine can do, with the vast importance to all citizens of their great rights, and above all, the right to life. I may make a few uncivil observations upon what I consider the appropriate duties of jurors and of courts in a case of this description. This is a case in which a party is charged with a high criminal offense, one of the highest known to the laws. We profess to live in a government of laws, and now by a distribution of those powers which go to make up the powers of a civil community. The Constitution has entrusted to another department of the government the power of making the law. For that we are not responsible, and whatever may be the view of all of us, or any of us, upon the subject of the particular punishment which that law has appropriated to a particular offense, it is not our duty to consider it, but it is our duty to carry them into execution, to administer them truly and fairly. And every government must not only have the legislature to make the laws, but the judicature to administer them. The appropriate province of jurisprudence is to take the law as we find it, and when any person is brought before us in the manner required by the law, we are to consider what the law and evidence are, and whether or not he has violated it in any such way as to be amenable to public justice. If so, we are to declare it. Here is division of duties. The jury have their duty, the court have theirs, and each is responsible for its own. It is the province of the court to lay down and state what the laws are, to regulate the course of proceeding in a particular case, to direct what shall or shall not be considered competent evidence, and generally to conduct the trial. But it is for the jurors to take this mass of evidence into consideration, to apply their best judgment and their best efforts to ascertain the truth, and then to declare that truth in what is called the verdict, that is, in the declaration of truth. This is the province of the jury, and while each continues and keeps within its own province, the law will be administered. All will be done which should be done, for the punishment of the guilty and the relief of the innocent. With these preliminary considerations, I will consider this case. This, gentlemen, is an indictment charging the defendant, the prisoner at the bar, with the crime of murder. Homicide, gentlemen, of which murder is one of the highest species, is of various degrees, according to the circumstances. There may be homicide that is the death of another in self-defense. It may be in the execution of criminals and in other ways. Homicide is a generic term, embracing every species by which the life of man is taken. It may be lawful or unlawful. It is lawful when it is alone justifiable, in war or by an officer under a proper warrant, and it is also justifiable in self-defense. It is not necessary for me to go into those distinctions, but I will state them briefly from the books, and then submit your consideration the crime with which the defendant is specially charged. The indictment in the present case charges that the present defendant, Professor John W. Webster of the Medical College and professor in the college at Cambridge, did on the 23rd of November last violently make an assault upon Dr. George Parkman, and then and there did deprive him of his life by violent means. And so the grand jury declared that in these forms, or one of them, this crime was committed. The law provides what the punishment shall be, but in determining what murder is, we all resort to that great magazine, the common law. This provides what murder is, but the statute provides only that the person who shall be guilty of willful murder shall be punished with death. But the common law of England and of Massachusetts is as much binding as that of our own legislature. We adopted it when our ancestors settled here. It has been successively adopted since that time, and was introduced into the Constitution of our own state, and it has the same force as if it had been specially enacted by the legislature. Referring then to this, I may as well state it now from a former memorandum of mine. I ought to have said that in rising to address you. It would have been certainly more satisfactory to have taken more time, but this would have prevented you from entering on your duty immediately. But, gentlemen, I will state, therefore, from a former memorandum, revised for this purpose, that an unlawful homicide is distinguished into murder and manslaughter. End of section 41. Section 42 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 32. Malice is used in the technical sense, not only including hatred and revenge, but every other unjustifiable motive. If a man should kill another with a motive of gain, it is unlawful. It is not confined to one or more individual persons, but it is a thing done malo animo, with a malicious mind, when the fact has been attended with such circumstances as carry in them the plain indications of a heart, regardless of social duty, and fatally bent upon mischief. And therefore malice is implied from any deliberate and cruel act against another, however sudden. Manslaughter is the unlawful killing of another without malice, and may be either voluntary as that done with a real design and purpose to kill, but through the violence of sudden passion, occasioned by some provocation which, in tenderness to human nature, the law considers sufficient to palliate it and rebut the presumption of malice, or from accident, when not accompanied with any intention to take life. Hence it will be seen that the characteristic distinctions between murder and manslaughter is malice express or implied. It therefore becomes necessary to ascertain, with some precision, what constitutes the legal nature of malice, and what evidence is requisite to establish the proof of it. The authorities, therefore, proceed to state that the implication of malice arises in every instance of intentional homicide, the fact of killing being first proved. Therefore, all the circumstances of excuse or palliation are to be satisfactorily proved, unless they result from the evidence produced against him, showing that if any killing is proved, it must have been with provocation by blows or other justification, and if there is no justification or excuse in the attendant circumstances, the case will be such as to warrant the conviction of the party. This rule is founded upon the plain and obvious principle that a person must be presumed to intend to do that which he in fact does, and that he must intend the natural, probable, and usual consequences of his own acts. Therefore, where he assails another with a dangerous weapon, with a weapon likely to do bodily harm, the presumption is that he intended death, or great bodily harm. And as there can appear no proper motive for such a cruel act, in the absence of proof, the consequence is inevitable, that it was done unlawfully. On the contrary, if the death is inflicted so suddenly after provocation, and if there be any such cause of provocation as the law allows, as to make it manslaughter, the act is deemed to be without malice aforethought. It is a settled rule that no provocation with words only will justify a mortal blow. Then if, upon provoking language, the party intentionally revenges himself with a mortal blow, it is unquestionably murder. It is a settled rule that no provocation by words only, however opprobrious, will justify a mortal blow intended to inflict death. I shall have occasion to explain that where a pistol is discharged at the body of another, where a heavy bludgeon or an axe is used upon the body of another, where a knife is used, these are dangerous weapons and are indicative of an intention to kill. The law will reduce it to manslaughter if there be provocation sufficient for this. But words are not sufficient for this. It must be at least an assault. The word aforethought is used not as simply implying deliberation or the lapse of time, but as rather intended to indicate purpose or design, and in contradiction from accident or mischance. I may verify these positions perhaps by being permitted to read one or two passages from a work of good authority, one from which passages have already been read to you, by opening counsel for the defense, from the pleas of the crown by East, a gentleman afterwards one of the judges in India. East Crown Law, Chapter 5, Section 2, murder in the sense now understood as the voluntary killing of a person under the king's peace. And in my definition, I use, in place of that term, the words under the peace of the Commonwealth. Of malice prepense or aforethought, either expressed or implied by law, the sense of which word malice is not confined to a particular ill will to the deceased, but it is intended to denote, as Mr. Justice Foster expresses it, an action flowing from a wicked and corrupt motive, a thing done malo animo, where the fact has been attended with such circumstances as carry in them the plain indications of a heart, regardless of social duty, and fatally bent upon mischief, and therefore malice is implied from any deliberate, cruel act against another, however sudden. Section 12. The implication of malice arises in every instance of homicide, amounting in point of law to murder, and in every charge of murder, the fact of killing being first proved. All the circumstances of accident, necessity, or infirmity are to be satisfactorily proved by the prisoner unless they arise out of the evidence produced against him. But it is intended here only to speak of the more deliberate and depraved species of that offense, where a mind is brooded upon its prey, and marked out the object of destruction in cool blood, and not where there is heat of blood arising from provocation or from mutual combat, where there is a use of a dangerous weapon, where it is intended to destroy life or to do some great bodily harm. And I use this qualification of some great bodily harm because a person may use a dangerous weapon and say that he did not intend to kill. If he intended to do some great bodily harm and deaths ensue, it is not enough for him to say, I meant merely to wound him, but the blow unluckily killed him. It is no excuse. He intends to do great bodily harm. Then what is that will reduce murder to manslaughter? It is said in the passage that has been read that it is out of regard for the frailty of human passion. Every man called upon suddenly to defend himself is inspired with the principle which puts him upon resistance, and if, during that period, he attacks the party thus injuring him by blows, and death ensues, it is regarded as done through heat of passion, and not through malice or that cold-blooded feeling of revenge, which more properly constitutes the emotion, the feeling, the passion of malice. And so, again, in an instance which may be presented of heat of blood and mutual combat, two persons come together, not intending to quarrel, because if they do intend to fight a duel, then it is murder. The two persons come together. Angry words arise. Then they come to blows. It is immaterial who strikes first, supposing that there is nothing unfair on either side, but it is a fair combat. One seizes an instrument and strikes a deadly blow. That is regarded as heat of blood, and though not excusable, because a man is bound to control his passions, it is not that higher offense which is called murder. We have gone into these distinctions, though there is not much necessity for it, because where death ensues and there is no evidence of provocation, or of heat of blood, or mutual combat, the fact of killing implies murder, and the jury would be warranted in finding a verdict of murder. There seems to have been little evidence in the present case that the parties had a contest. There is some evidence of angry feelings, but angry words are not sufficient, and unless these angry feelings resulted in angry words, and words were followed by blows, then there is no evidence of mutual combat or provocation on the one side or the other. With these distinctions, and without going more minutely into the law, we will proceed to the further consideration of this case. The party is charged with having committed the crime of murder upon the deceased. In order to establish this fact, two things are to be proved. In the first place, that death has been inflicted upon the party alleged to be deceased. Of course, where he is dead, that this has been inflicted by violence, that it has been inflicted under such circumstances as to exclude, beyond reasonable doubt, any supposition of its being done either by accident or suicide. If a dead body is found, and seems to have been destroyed by violence, three questions should be asked. Did he destroy his own life? Was it caused by accident, or was it from violence inflicted upon him by others? In most cases, there are facts and circumstances which surround the case, which answer the questions at once. If you see the effect and the cause is apparent, there is no more deliberation. You sometimes find that a coroner is called. Sometimes it is unnecessary to hold an inquest, although there may be some indications of a sudden death. What is the reason of a coroner's inquest? A man has suddenly died, and it is proper that there are investigations into the cause of death. You perceive by the whole course of this trial, by the tenderness of the law for the party deceased, and all connected with him, by the tenderness also manifested towards the prisoner, how carefully and how scrutinizingly the law regards the life of every member of society. It is not necessary for me to say here, the spirit pervades the whole body of our law, that before the law all are equal, and whatever may be the circumstances of the individual, it makes no difference. Life has been destroyed by violence. Therefore, the law institutes proceedings, and whether, as in one of the most recent cases which occurred, it be a colored child in a country almshouse, or whether it be one of the most eminent individuals in the community for science and wealth, it makes no difference. The same apparatus is provided, the same security provided for every individual. Then the purpose of the inquest is, when there is a sudden death, that the public shall be informed, and the community have a right to know how it happened. Therefore, an officer is appointed whose duty it is to go to the spot, take all the evidence arising from the state of things, obtain a jury, and ascertain what are the facts. If, as in the present case, they appear to charge any individual, then that is the basis of further proceedings. If they are satisfied that it is, by an act of God, a dispensation of providence, then they must report that. The result is given to the proper authority. Thus, every means is taken to vindicate the law. If it be suicide in England, the party forfeits his goods. In our Commonwealth there is nothing of the kind, and therefore if it be suicide or accident, no further action is necessary. But if some person is charged with murder or manslaughter affecting the life of the individual, then it is the duty of the officers to proceed further. This, gentlemen, is a case in which a person suddenly disappears, in which evidence has been laid before you to show that he was deprived of life at or about a particular time, under such circumstances as to lead to a strong belief that some person or other had done the act which led to this result. Now, this is to be proved by circumstantial evidence. That is, nobody saw the act done, and therefore it becomes important to state what circumstantial evidence is, and to give you some idea of the mode in which an investigation is to be pursued by the aid of circumstantial evidence. The distinction between direct and circumstantial evidence is this. Direct or positive evidence arises, where a witness can be called to prove the precise fact which is the subject of the issue in the trial. That is, did one man cause the death of another? That is the fact to be proved. Well, no witness saw it, but can it not be proved? Circumstantial evidence may be of such a nature as to warrant a conclusive belief that somebody did it. and it would be injurious to the best interest of society to have it so ordered that circumstantial proof cannot avail. If it were necessary always to have positive evidence, how many of the acts committed in the community which destroy its peace, which subvert its security, would go entirely unpunished? No, gentlemen, it is not so. There may be evidence quite as strong indeed, sometimes considered stronger from circumstantial evidence as from positive. The attempt to compare one of these means of proof with the other is not based upon sound elements of comparison, because there is no common medium by which they can be compared. Each has its own advantages and disadvantages, and it is necessary to understand them both. The necessity, therefore, of resorting to circumstantial evidence is absolute and is obvious. Crimes are secret. Most crimes seek the security of secrecy and of darkness. It is, therefore, necessary to use another mode of evidence than that which is direct, provided there is another mode. And thanks to a beneficent providence, there is furnished a means of proof in another way, which is quite as strong and quite as satisfactory as that arising from the direct testimony of a witness. But I have stated that each has its advantages and its disadvantages. Now, the advantage of positive testimony is that you have a man who, if he is to be believed, saw the act done, and the only question is whether he is to be believed. You have the satisfactory evidence of that witness, and from the circumstances and peculiarities in which he is placed, he may be entitled to belief. The advantage is that you have a man who testifies to the fact itself. But in the case of circumstantial evidence, no person having witnessed the fact, you arrive at it by a series of other facts, which by long experience we have so associated with the fact in question, that they lead to a conclusion as direct, as positive, as satisfactory, as if it was derived from positive proof itself. Circumstantial evidence is founded on experience and obvious facts and coincidences, establishing a connection between the known and proved facts and the facts sought to be proved. It must be a fair and natural inference, not a forced or an artificial one. There are some instances where the law has declared that a fact shall be considered as evidence of such a conclusion, but it has not commonly been so, and perhaps the better rule is that it should not be so. It has sometimes been held that a woman who is the parent of a bastard child, and who gives no notice of the birth of her child, being found with a dead child, it is to be presumed that she murdered it. But that is an artificial and not a natural presumption. But in circumstantial evidence, the inference to be drawn from the facts is a probable one, and it should be a necessary one. The presence of one is proof of the existence of the other. For this purpose, therefore, each fact which is necessary to the conclusion must be distinctly proved. It is not, therefore, that you may offer partial proof of a variety of facts, and then ask the jury to draw an inference from them. Each fact must be proved, as I have said, that is, each fact necessary to the conclusion. It does sometimes happen, as it does in the present case, that facts are offered in evidence, not because they are necessary to the conclusion, but to show that they are consistent with it and not repugnant to it. If the proof of one of these facts fails, it does not destroy the chain of facts. It fails only to give them that particular corroboration. I will only illustrate it by a fact in the present case, which I shall consider more particularly by and by. Suppose, for instance, there is proof here which goes to show that the teeth found in the furnace were the identical teeth belonging to Dr. Parkman, as examined a fortnight before, and actually seen by one person the day before his disappearance. This has a tendency to prove that he was the person. The first great fact to be proved being what is called the corpus delicti, the body of the crime. Ordinarily, it is to prove that the crime has been committed. Now suppose at the same time there is other evidence in the case of a less conclusive nature. For instance, the shape, size, height of these various parts when put together, which would naturally conform to the body sought. Now, this latter view would fall short of being a conclusive circumstance because the same height and the same other indications might not be so indicative of the individual. They go to corroborate the first evidence thus far, that they are consistent with it, and a great part of the evidence is resorted to, not because each of these particular facts is necessary to establish the main conclusion, but because they go to show that the circumstances are not such as to be repugnant to or inconsistent with it. It must depend upon a basis of facts, which must be as strictly proved by testimony as any other facts must be. The coincidence may be of a physical character or of a moral nature. The ordinary views and feelings with which parties act are facts, and they are of such uniform operation that a conclusion may be drawn from them, that if a person acts in a particular way, he does it from a particular motive. When they are of a physical and mechanical nature, they are very strong. Sometimes they may be so strong that there can be no question on the subject. Take an instance where it is natural or physical. Certain circumstances may exist which are so conclusive as to leave no doubt. One of the recent cases that occurred in this court was a murder by stabbing in the heart with a dirk knife. What were the coincidences in that case? There was evidence tending to show that the party charged had possession of the knife during the day. On the next morning, the handle of the knife was found, having been thrown into an open cellar. Some of the witnesses testified that that was the handle of the knife. Afterwards, at a later hour of the day, the blade of that knife was found broken in the heart of the deceased. Now, when the pieces came to be fitted together, no person could have any doubt that the blade was the blade belonging to that handle. No two knives could have been broken in precisely the same way as to produce edges that would so precisely match. An instance is mentioned in the life of Lord Eldon, that he was in one of the courts trying a criminal charged with murdering another with a pistol. There was a great deal of evidence tending to show that he was near the place about the time the crime was committed, and other evidence going to create suspicion that he was the person who fired the pistol. But still, the circumstances failed to be conclusive of fastening it precisely on the individual, which was the great object of all this investigation. The surgeon stated in his examination in the presence of the judge that the pistol must have been very near the body. On being asked why, he replied, because the body was blackened, and the wad was found in it. Said the judge, "Did you keep that wad?" "I did," was the response, and the judge requested him to examine it. It was found that the wad was made from a part of a song, and the other part was found in the defendant's pocket. The two parts corresponded. I only put these as cases showing what are and what are not, circumstances from which conclusions may be drawn as satisfactorily as from positive testimony, but these are from physical causes. There is another class of circumstances which are to be considered as moral, arising out of the conduct of men in certain situations, because from long experience it is known that men act from motives, and that men in certain circumstances are likely to act in a particular way. Indeed, this is the only mode in which a great variety of crimes can be proved, because there are many crimes which can be proved only from the intent. Now, the intent is a secret of the heart, which can be known only from his declarations, and those he may express to none, so that they remain known only to him who is the reader of all hearts, except by external acts. But it is reasoned from the fact that a man, doing a certain thing, acts in a particular way, and as I have already stated in another part of the case, a man is always presumed to intend the natural and usual consequences of his own acts. The natural conduct of men is such that fair inferences can be drawn from it. It is necessary to the proper administration of justice that such evidence shall be admitted, because it is, in its nature, satisfactory, and if proved, it is equally conclusive. There are various other views taken, where, for instance, probable proof is brought of a state of facts, the absence of evidence tending to a contrary conclusion is then to be weighed, to be considered, and I shall have occasion to consider that by and by, in another part of the present case. So if a party who is called upon to meet a charge, and against whom stringent proof is produced, can offer satisfactory evidence to account for the circumstances in which he is placed in another way, and does not do it, the presumption is that the proof, instead of rebutting the charges, would have the contrary effect, and therefore he suppresses the evidence. There is another consideration, and that is this, that inferences coming from independent sources, different from each other and tending to the same conclusion, not only support each other, but support each other with an increased weight of evidence. To illustrate, suppose, for instance, in the case just mentioned, that the paper containing the song was produced. It is barely possible that he might have picked up the piece. It is not conclusive that he wanted the gun himself, from the fact of the piece of paper being found in his possession. But suppose, from another, and an entirely independent witness, it was proved that that individual purchased that paper, that particular song, at a shop the day before. Then we have concurrent circumstances, coming from different sources independent of each other, which bear upon the same conclusion, and therefore have a very strong tendency to establish the result. Under this head, that is, under the head that a party who can produce proof, and does not do it thereby, to some extent, corroborates the evidence produced against him, may be referred various other considerations, where it is shown that the party has attempted to suppress proof, has endeavored to prevent things from being known, which might make against him. Such efforts, when proved, exert an influence against him. It sometimes happens that a man may be placed in such a situation that he attempts to resort to deception for the purpose of concealing proofs, when he is an innocent man, instead of having the fact produced. That was the point in the case produced yesterday, of a man who was convicted of the murder of his niece, because she suddenly disappeared under circumstances that gave rise to the suspicion that she was dead. Then he attempted to impose on the court for presenting another person as his niece. The deception was discovered and operated against him. In that light, in connection with these various considerations, certain rules can be applied to circumstantial evidence. The first is that the circumstance on which the conclusion depends must be fully established by proof. They are facts. They are not less to be proved by competent evidence than if they were the direct proof. Under this rule, great care is to be taken by guarding against pretended circumstances, which might seem to raise suspicion against the party. There are found, detected, and in general it may be considered as one of the wisest provisions of Providence, that where certain things have happened in reality, there they must of necessity correspond, because what has happened once may happen again, and therefore if the facts and circumstances all correspond, there is then a strong belief in their truth. But if there be one circumstance repugnant, not consistent with them, then they cannot agree, because two things impossible cannot agree. The familiar illustration is, where persons have been slain and placed in certain positions to make it appear that they had committed suicide. In one case of this kind, there was the print of a bloody hand, a bloody left hand, on her own left hand. It was therefore impossible that the theory of suicide could be maintained. So in another case, where a man was found dead, shot by a pistol ball with the pistol in his hand, of course this indicated suicide. But upon an examination of the bullet, it was found to be too large for the pistol, and hence you will see at once that suicide was impossible. The rule, therefore, is that the circumstances upon which the conclusion depends must be proved. I have already attempted to distinguish that upon which the conclusion depends, and that which is not essential to the conclusion, but only corroboratory of it. If they are not of that character upon which the conclusion depends, then the failure of anyone does not make the case fail, but only fails in the corroboration. End of section 42. Section 43 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 33. The next rule to which I ask your attention is that all the facts must be consistent. What has happened may happen again. What is impossible could not have happened, and therefore the facts must be consistent with each other. Considering them to be the facts upon which the conclusion depends, if any one fact is wholly inconsistent with the hypothesis of guilt, it of course breaks the chain of circumstantial evidence and puts an end to the case. Of this character, gentlemen, is an alibi. And what is an alibi? A man is charged with crime. He says, I was elsewhere. Alibi. The Latin word for elsewhere. Well, if that is true, that cannot be consistent with the fact of his being there at that time. At precisely 8 o'clock on a given evening, he is proved to be in one place. Therefore, he cannot be in another place at precisely the same hour. That has been the source of a vast deal of contrariety, because an alibi is easily suggested. With a little contrivance and a little arrangement of proof, a person may seem to have been in one place when he was in another. If the alibi is proved, then it is a certain conclusion, because a person cannot be in two places at the same time. Therefore, showing him to be in one shows him not to be in the other. But wherever such proof is attempted, there must be the most rigid and strict inquiry whether the fact is proved to the satisfaction of the jury. And false testimony in the attempting to prove that a man was in another place from his real one is open to all the various suggestions of contrivance, such as the appearance of sudden riding from one place to the other, and various other modes of that description. Another fact, which appears in one of these cases, a man was accused of stealing timber. The evidence was gone through with, and seemed to make a very strong case against him. But on the whole, it was proved that if he did it alone. Then a witness came forward and stated that one man could not lift the timber. It would take 5. That was sufficient to close the case. But where the circumstances are proved, where they lead to a certain result, it may not be the same species of evidence, but it is legal evidence, competent evidence, and evidence which is necessary in many cases, in order that the guilty may not escape. But they must be of a conclusive tendency. Yet, how is that conclusive tendency to be shown? Whether the party had or had not, the motive to do the act may be shown. That there was an advantage to be gained by it, plunder to be obtained, the circumstances which the party fails to prove when he might prove them, the attempt to create and impose false evidence, the attempt to withdraw attention from himself to a third person, to suppress actual facts, and various other modes of this description. These all tend to show that circumstances which might have affected that party, as well as any other party, were such as to implicate him because of something wrong. Having a motive, and nobody else having such a motive, nor there being any other cause of homicide shown, such as making threats, manifesting a disposition to do the act, and various other things, come under the head of what I have stated to be moral coincidences, and facts which coexist with each other. The fact should be, to a moral certainty, exclusive of any other reasonable hypothesis, besides the one proposed to be proved. This is merely an expansion of the last suggestion which I made. They must be such not only as are consistent with the guilt of the party, but must exclude and overthrow every other reasonable hypothesis. They must have a tendency to show that no other individual could, under any reasonable presumption, have done the act which is alleged to be done by the party. They must prove the corpus delicti, or the offense committed, the fact that the crime has been committed. The evidence must prove not only in a case of homicide or death by violence, the hypothesis presented, but to a reasonable extent, it must exclude a reasonable hypothesis by suicide, or by the act of another party. This is to be proved beyond reasonable doubt. Now then, gentlemen, what is reasonable doubt? It is not possible doubt only, because everything is doubtful. It is that doubt which, after the entire consideration of all the evidence has been taken, leaves the jury uncertain. It is not a mere probability, arising from the doctrine of chances, that it is more likely to be so than otherwise, but a reasonable moral certainty. That is, a certainty that weighs upon the mind, weighs upon the understanding, satisfies the reason and judgment that, without leaving any other hypothesis, the facts are such as to implicate the defendant and do not implicate anybody else. This we take to be proof beyond reasonable doubt, because if it went beyond that, if it required absolute certainty, as it is of a moral character, this species of evidence would always be insufficient. It is therefore that evidence which excludes every other hypothesis beyond reasonable doubt. Now, we are to consider these rules as applying to the present case. The charge is a charge against Dr. Webster of the willful murder of Dr. Parkman on the 23rd of November last. In the first place, it is necessary to ask what is the indictment, inasmuch as it is the duty of the court to decide upon all points of law. And as the form of indictment is a question of law, under the authority which has been presented here, we have investigated this subject, and I now give the result. This indictment contains 4 counts. I will not read them, but it charges the commission of the act of homicide by 4 different modes of death. Legal proceedings established by old, long, well-confirmed precedents sometimes do seem to differ, but the general rule is that no man shall be held responsible for crime in any form until it has been substantially set out in some charge, substantially and formally set out in some charge. But whatever may be the form, the offense shall be fully and formally, clearly and substantially set forth. It therefore often becomes necessary to set forth several counts. When a person who does not know these rules sees these counts, he is very apt to say that these are inconsistent. But we are to consider that a party who draws the indictment often does not know which charge will be proved. But in order to meet the evidence, he may set them forth in as many counts as he pleases, and aver as many modes of death as he chooses. And if any one of them is proved, that is all that is necessary to sustain the indictment. Satisfactory proof of any one mode of death is sufficient. It is said that there are various forms of indictment adapted to many of the modes in which death may be inflicted. But is not science continually discovering new modes? Suppose in the chemical laboratory, a person might be held fast while chloroform was placed over his mouth until he dies. Suppose such a case has never before occurred. Shall such a party escape on that account? I think not. And therefore, as in cases of new modes of locomotion, the common law has a rule for all new cases. Not that it foresaw that a steamboat would be built, or that railroads would intersect the country. Yet its general principles embrace all these cases, and therefore, whatever be the form of death, still the charge in the indictment, if it presents the mode of death in as special a manner as the circumstances of the case will allow, is sufficient. The same authority that has been cited, I will read a passage from East Crown Law, Chapter 5, Section 13. The manner of procuring the death of another with malice is, generally speaking, no otherwise material than as the degree of cruelty or deliberation with which it is accompanied may in conscience enhance the guilt of the perpetrator, with this reservation, however, that the malice must be of corporal damage to the party, and therefore working upon the fancy of another, or treating him harshly or unkindly, by which he dies of fear or grief, is not such a killing as the law takes notice of, but he who willfully and deliberately does any act which apparently endangers another's life, and thereby occasions his death, shall, unless he be clearly proved the contrary, be adjudged to kill him of malice prepense. The mode is not material. How are we to consider this indictment? The first count contains the charge of death by striking with a hammer, the second by something nearly like it, the third by throwing upon the floor and beating with the hands and feet, and thereby producing death, and the last is the count which I shall presently read. Now, in a case of this description, if the parties prove to your satisfaction that Dr. Parkman lost his life by any means suggested, of which there has been proof offered, perhaps the reasonable probability would be, independent of any direct proof about the body, that it was done by a blow, or a stab in the side, or something similar, and therefore, if such fact were proved, it might be considered sufficient. It may be impossible to determine in which of these modes death was produced, yet if it was made in some of the modes suggested, then it will warrant the finding against the defendant. The last count is as follows. And the juries aforesaid upon their oaths aforesaid do further present that the said John W. Webster of Boston aforesaid, in the county aforesaid, in a certain building known as the Medical College, there situate on the 23rd of November last past, in and upon the said George Parkman feloniously, wilfully, and of his malice aforethought, did make an assault on him and said George Parkman, in some way and manner and by some means, instruments and weapons to the jury unknown, and did then and there feloniously, wilfully, and of his malice aforethought, deprive of life, so that he, the said George Parkman, then and there died. And so the jurors aforesaid upon their oaths aforesaid do say that the said John W. Webster, him the said George Parkman in the manner and by the means aforesaid to the said juries unknown, then and there feloniously, wilfully, and of his malice aforethought, did kill and murder against the peace and dignity of the Commonwealth aforesaid, and contrary to the form of the statute in such case made and provided. The court are of opinion, and for the purpose of this trial adopted, that this is a good count of the indictment, and from the necessity of the case it is so, because circumstances may be imagined in which the cause of death could not be introduced into an indictment. Some books enumerate various modes in which death may be inflicted, strangling, smothering, and depriving of breath. But if new modes occur, as the use of ether or chloroform, continued so as to produce death, the body may be put into such a condition that no one can determine how death was occasioned, and it may be said, to the jurors unknown. The precaution which is taken in the books in explaining murder shows that death produced merely by fright or grief is not included. A person who frightens another to death is not, strictly speaking, a murderer. Murder must be some physical force applied to the person. This count charges an assault. That is a technical term, well understood in law. It is something inflicted upon the person and naturally excites sudden and violent resentment. Then this count charges death, by means, instruments, and weapons to the jurors unknown. Now the rules of law prescribe that the grand jury will present the charge with as much certainty as the circumstances will admit, and if there was no evidence by which they could specify more particularly, then this count is conformable to the law, and therefore, if you are satisfied that the defendant is guilty of the crime charged, this form of indictment is sufficient to warrant a conviction. This is all, I believe, it is necessary to state with regard to the form of the indictment. Then what is necessary to be proved? It is necessary in the first place to establish the corpus delicti, or the offense charged, that the death was effected by violence, and that the circumstances are such as to exclude accident or suicide. Now, gentlemen, what are the facts charged? They are these. It is alleged that on the 23rd of November, in the forenoon, Dr. George Parkman, very well known by most persons in this vicinity, was in good spirits and health, that he walked with Mr. Shaw downtown, that he was seen in different places that forenoon, that he was traced to different places until between 1:30 and 2 o'clock, that he was seen about to enter the medical college, that, having gone in, he never came out of that college alive, that he was missed as soon as he would naturally be. It is further charged that no general proclamation was made till Saturday morning. Search was made for him in various directions on Friday and Saturday morning, but it was not thought best to make a public proclamation until the cars on the various railroads came in at noon. At that time, the police were called into action, and search was made. That such search was continued with great activity in all directions where there was any likelihood of his being found until the termination of a week. That certain remains of a dead body were found, which led to the arrest of the defendant. That the next day, proper examinations were made, and that there were further discoveries, that further parts of the dead body were found and examined under such circumstances as to induce a reasonable belief that they constituted portions of the dead body of Dr. George Parkman. This is the charge, and you are to decide whether the evidence does or does not tend to charge guilt upon the defendant. In the first place, is the crime proved? If the party was in good health and in good spirits, and that he so continued to the day of his disappearance, by the evidence before you, this must be considered a fact, until something to the contrary is shown. It is alleged that he went to the college and met Dr. Webster. This is admitted by himself, but then the question arises whether anything further was heard from him. 3 questions then arise in the present case. First, were these the remains of the body of Dr. Parkman? And if so, were they found under such circumstances as to exclude any belief that he came to his death by accident or suicide, so as to leave the other conclusion that he came to his death by violence? And if so, then by whose hand? In the first place, then, gentlemen, it seems to be proved by testimony that is unquestionable that he disappeared sometime in the forenoon, so far as his family are concerned, on Friday the 23rd of November, and that he did not return that day to dinner. That is a fact uncontested. Then another question arises, whether any other mode or cause of that disappearance is shown. It is argued that the search which was made was unusual, was unprecedented, was extensive, that every line of inquiry was followed up, which seemed to indicate a favorable result, and no discovery made. Perhaps, as the first point on the part of the defendant was on the score of the alibi, it may be as well to refer to that, because if, after the time when, by the probable circumstances of the case, it would appear from the proof that his life was destroyed in the medical college, if at all, he was seen elsewhere, of course, that would be a circumstance inconsistent with the allegation that he was last seen entering the medical college. If the alibi is made out, it is conclusive in his favor. Now the question is whether he was seen. There is a point made afterwards to which it may be necessary to allude. When you are called to consider the evidence of any particular fact, of course, you are to decide upon the preponderance of the weight of evidence in favor of or against it, and therefore when a certain amount of evidence is adduced to establish one conclusion, if there is a vast overwhelming amount of evidence to establish the other, however the proof might have been if it stood alone, it will not stand against the greater mass of testimony. The witnesses in favor of the alibi of Dr. Parkman are Mrs. Hatch, Mr. Thompson, Mr. Wentworth, Mr. Cleveland, Mrs. Rhodes and her daughter, and Mrs. Greenough. It is not necessary to go over all their evidence. You will remember that the notice of Dr. Parkman's disappearance appeared in the public papers on Saturday afternoon, that on Sunday a general inquiry was made, that on Saturday afternoon and evening, and on Monday they had a pretty thorough search, and so it continued up to the succeeding Friday, when the remains were found. No doubt, during that period, there were various stories as to his having been seen during the day of his disappearance, and may be very probable that there were some accounts which were made during that period, and very honestly made by the persons who thought they saw him. But I said that this was to be compared with the evidence on the other side. Gentlemen, perhaps it is somewhat peculiar to our own country, but it is perfectly well known to all men of experience that when a great event of this kind arises, which fastens upon the mind of the public, the whole community are resolved at once into a body of inquirers. Everybody tells to everybody else whom he has seen, and what he has seen, within the last 24 hours, or within the last week. It is upon those statements that at last a line of inquiries is made, which leads to the true result. One says, I saw such a thing, and another thing, but when compared, they do not agree. There are two circumstances which apply to proof of alibi. In the first place, there is the uncertainty which applies to the fact, not to say anything about an intentional misleading, but a witness is always liable to be mistaken. Then, in order to establish the fact, it must be proved beyond reasonable doubt that the party was seen at the precise time and place where he is alleged to have been seen by the witness, and that is the difficulty with regard to proof of alibi. There is always room for the difference of time to be explained, owing to the difference of time pieces, which sometimes vary 5 or 10 minutes. On Saturday, notice was given. On Sunday, his disappearance was pretty generally known in the west part of the town. I believe on Monday morning it was universally known in the city. Then thousands were put upon their recollections to say whether they had seen Dr. Parkman, where, when, and under what circumstances. Now, he was a person very well known. Perhaps no man of his age and situation was better known here, in person, than himself. Now, notwithstanding this proof, the question is whether he would have been likely to have been seen by many persons if he had been moving through the streets in the manner indicated by this testimony. Judge for yourselves. Would there not have been hundreds of thousands of persons who would have seen him and have testified to it? This, however, is negative testimony. But if anything happens and persons do not see it, if they were placed where they might have seen it, this, though negative, leads to an affirmative result. That is one of the modes to lead you to a view of the truth. If you are satisfied that there was a great number of persons along the streets where you were said to have been seen, Cambridge, Court, Washington streets, etc., would there or would there not have been a great variety of persons who would have confirmed that statement? If so, it is a comparison of the testimony, negative on one side, positive on the other. Now it is said that positive testimony is more available than negative, and it is not infrequently happens, in proof of this sort, that one witness sees one thing which another did not. Now, when two persons are placed in a position to observe, and one says that he did see it, and the other says that he did not, I do not see why they do not contradict each other. For though one is negative and the other positive, yet if the one who testifies that he did not see it was placed in a position in which he would have seen it, if it had occurred, they are contradictory. Owing to the dimness of the hour at which he was said to have been seen by Mrs. and Miss Rhodes, it is possible that they were mistaken in the individual. They may have been mistaken also in the day. If a person says, I know it was the day, because I wrote a note on that day, he may have misstated it at the time, which is a matter of common experience. One of the papers in this case bears upon its face an impossible date, having been dated the 31st of November. If the actual proof is such as to show that the deceased party lost his life at or about 2 o'clock in the medical college, then it is impossible that it should have been seen after that time. And whatever may be the causes, it must be that the parties were mistaken. But this depends upon the main evidence brought to establish the case. If that puts it beyond reasonable doubt that he was there, and at that time murdered, then it places it beyond reasonable doubt that he could not have been seen at a later hour. One remark with regard to those different persons who saw him in the course of Friday afternoon. They do not come to establish any one theory. Now, if he had been seen by one person in one place, and subsequently by another person in that direction, and so on a certain length of distance and time, then they would have tended to corroborate each other. Mrs. Hatch is not relied upon. The other testimony is that he was seen by Mr. Thompson, who came from East Cambridge and who estimated his time by the East Cambridge courthouse clock, a new clock, and proved by some witnesses to be irregular. By Mr. Wentworth, who saw him in Court Street, nearly opposite Mrs. Kidder's, by Mr. Cleland, who saw him in Washington Street, and by Mrs. and Miss Rhodes, who saw him in Green Street, going in an opposite direction to them, as they were going home to Chambers Street, and Mrs. Greenhouse saw him in Cambridge Street. They do not seem to correspond with any one theory. If the other evidence is sufficient, it goes to show that this must have been a mistake. But this is proper evidence to compare with the other evidence, and therefore, if of such a character as to raise in your minds a reasonable doubt, and if the contrary be not proved beyond such reasonable doubt, the case of the government is lost, and the defendant is entitled to an acquittal. The difficulty of establishing such proof is, first, as to the day, second, as to the time of day, thirdly, as to the identity of the person. Then contrast it with the supposed controlling proposition that if Dr. Parkman had been in those places, other persons would have seen him. Take these things into consideration and see if a reasonable doubt is produced. It is true that the time is not of itself material to this case. If it should be established that he was seen at 1:30, or 2, or 3, or 4 o'clock, still the crime may have been committed. But the importance of this proof is this: inasmuch as all the proof on the other side tends to establish the fact that he did go about 1:45 o'clock into the medical college, and that he did not come away, then it would have a tendency to control that proof and render the fact doubtful. But if the evidence is otherwise, such as to prove that Dr. Parkman lost his life at the college about 2 o'clock on Friday, then it cannot be proved that he was abroad, whatever may have been the source of the mistake. But the question whether he was abroad bears upon that proof. Then the question is whether the defendant was there upon that day, and did meet Dr. Parkman by appointment, and did act upon the temptation to kill Dr. Parkman. It is not necessary to establish the fact of seducing him there. But if proved, then all implied malice is laid out of the case, because it is murder by expressed malice. On that Friday, Dr. Webster lectured. It was the last day he was to lecture, previous to the ensuing week. He remained there, as he says, till about 1:30 o'clock, and did meet Dr. Parkman, and paid him the money. Tracing the evidence, then, with regard to Dr. Webster, it appears that he was at Mr. Kidder's that afternoon, and there is some evidence tending to show that he was at the college about 6 o'clock. This testimony is from Mr. Preston, a medical student who is in the low wing at the West End, where the students are in the habit of practicing dissection, daily and constantly. Mr. Preston says he was coming out of the dissecting room at about 6 o'clock. I think you will recall his testimony, though it was given pretty early in the trial. He states that he had an engagement at 7 o'clock, that his own tea hour was 6:30 o'clock, and that he started early enough from the college to reach home in season for tea. so that he states it at 6 or 6:30 that he saw Dr. Webster passing into the college shed. This is the evidence of that day. If there is no evidence beyond this, if Dr. Parkman is not seen afterwards, then the conclusion seems to be strong, that having gone there in good health and in 1 week found bereft of life, he came to his death not by accident, not by the visitation of Providence, because if he had been by accident, it would have been known. There would be no motive to conceal it. The concealment, therefore, has a tendency to show from the facts and circumstances under which this body was found, if that was his body, that he came to his death by violence. You will judge whether that is a natural and proper conclusion. If so, then the question arises, were these his remains? Was the body of Dr. Parkman found? It has sometimes been said by judges that a jury never ought to convict in a capital case unless the dead body is found. That, as a general proposition, is true. It sometimes happens, however, that it cannot be found where the proof of death is clear. Sometimes, in a case of murder at sea, the body is thrown overboard in a stormy night. Because the body is not found, can anybody deny that the author of that crime is a murderer? End of section 43. Section 44 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 34. Now, about the mode of death. Suppose that a man is struck on the deck of a vessel. His skull is fractured, and he remains for a length of time insensible. Suppose that while in this condition he was thrown overboard. The evidence tends to show either that it was death from the blow or from drowning, though we cannot tell which, and yet it may be said that it was certain that it was one, and is absolutely uncertain which it was. It is not necessary for me to go into all the evidence. The remains were in 3 places. One was the privy, and when we speak of the privy, we refer to the cellar of the building, the only corner of which was used as a privy. A second part were found, partially calcined, in the furnace, and still other parts in the tea chest, and all the parts being found near one place, and all connected with one apartment. If these places were resorted to for concealment, you will judge whether the person who concealed one part is the same that concealed the other. If a person had a motive to conceal one part, then he probably had a motive to conceal the other. These are thought by the witnesses to be part of one human body. But if, upon examination, it were found that there were 2 right legs or 2 right arms, they could not be the remains of one body. They might perhaps have been the remains of anatomical subjects. It is therefore of importance to ascertain whether they were parts of one human body. If all the parts coincide with each other as one body, those parts that were found in the basement and those found in the tea chest, and those in the furnace, all corresponding, then the natural conclusion would be that the same person who concealed one did the whole, and that they did belong to the same body. Then the question would be whether those were parts of a body used for dissection, because finding a dead body in the medical college, the first natural conclusion would be that they were parts of a body used for dissection. Then the question is whether that is negatived. The physicians have testified as to the manner in which the dissection was performed. Dr. Holmes and Dr. Wyman have testified. Dr. Ainsworth says that it is his business to keep an account of the subjects, and as they now have the sanction of the laws in furnishing the means of obtaining subjects, it is necessary to keep accurate accounts of them. He testifies that all are accounted for. It is testified to be a uniform custom, when a subject is brought for dissection to the medical college, to make some preparation before dissection commences. That is done by injecting the arteries with some chemical substance, which tends to preserve the body. This, therefore, is the first question, to ascertain whether these remains were parts of an anatomical subject. One inquiry was, had the blood vessels been injected? That could be ascertained by chemical analysis. Portions of the blood vessels were taken out and committed to the examination of Dr. C.T. Jackson and that late eminent chemist, Dr. Gay, and Dr. Crossley. In consequence of Dr. Gay's death, his examinations were not finished, but were concluded by Drs. Jackson and Crossley, and they testified that these arteries had not this anatomical injection. Now then, the first evidence that was offered was that these parts were laid in juxtaposition, and that they appeared to correspond in height and figure with the body of Dr. Parkman. Here is one of the cases to which the rules of evidence apply, to which I called your attention in speaking of circumstantial evidence. If this had been alone relied upon as proof of identity, it would be left doubtful, because parts of the body were wanting, and those the parts by which identity is commonly established. Had there been marks upon the portions of the body which remained, and they could have been proved as natural or artificial marks upon the body of Dr. Parkman, of which there was no evidence, it would have tended to prove identity. If there be in the teeth sufficient evidence of the specific identity of these remains with those of Dr. Parkman, then the fact that they did not differ in shape, size, or height from those which did belong to him would have this effect. They would not of themselves be sufficient to prove identity. They would be comfortable to the supposition that this was the body of Dr. Parkman, not opposed to it and yet not specific enough to be direct evidence of it. You are then to determine whether the body was identified by the teeth. It is scarcely necessary for me to do more than to name the witnesses which have been called to testify upon that subject. It is certainly a very interesting inquiry whether the teeth can be identified or not. It cannot have escaped notice how great a similarity there is in this to the investigation of what are called fossil remains. Persons have studied the anatomy of the bodies of reptiles and of the lower orders to such a minute degree that from the figure, from the openings, they are able to say from a single bone even what class they belong to, and thus trace the inquiry and ascertain the existence of races and species of animals. But still you are told here, by the anatomist, by Dr. Jeffries Wyman, who is reputed to be excellent, that by finding a small piece of bone it is possible to determine to what part of the body that belonged. There are particular parts through which particular nerves or vessels pass, by which it can be determined that they are part of the temporal bone, the cheekbone, or some other. Dr. Keep was called and stated that 3 years previous, in 1846, he made teeth for Dr. Parkman, to whose teeth and stumps various adjustments were to be made. He testifies that they were adjusted and fitted. Now the gold having been melted, but the blocks of teeth remaining, with several peculiar angles and points, the question was whether he could ascertain their identity. It is merely necessary for me to refer you to this testimony. He was of opinion that he could identify them. He was satisfied that they were the teeth of Dr. Parkman. If you are satisfied that that conclusion was right, then this testimony is of very different character from that of the shape and size, and has a strong tendency to prove that it was the body of the deceased person. I barely refer to the persons who have testified to this. Dr. Keep, with his assistant, Dr. Noble, think that they can identify these blocks of teeth. Dr. Morton is of opinion that there is not enough to enable an artist to identify them. And with regard to all that, Drs. Harwood, Codman, and Tucker have testified the other way. You are to determine by all the testimony whether those were the teeth of Dr. Parkman and belong to the same body as the other parts, and if so, it has a strong tendency to a proof of death by violence, and then the corpus delicti is established. Otherwise, not. If this is not proved to the satisfaction of the jury beyond reasonable doubt, then the dead body is not proved to be that of Dr. Parkman, and the proof of the corpus delicti, as offered by the prosecution, fails. But if this is satisfactorily proved, then the next question for the jury is, by whom was it done? I have already submitted to you the question whether or not these belong to the same person. If they belong to the same person, if these were the teeth of Dr. Parkman, you will recollect the reasons that they gave why the teeth were in the head before being put into the furnace. Then one part, being identified, identifies the rest. Gentlemen, I shall pass over all that has been said in regard to Mr. Littlefield. Footnote. On July 24th, 2 months after his conviction and a month before his execution, Dr. Webster expressed a wish to see Littlefield. The latter came to the prisoner when Dr. Webster told him he had done him great injustice and asked his forgiveness, saying, "All that you said was true. You have misrepresented nothing. But as a dying man, I have no recollection in regard to the sledgehammer. I cannot bring my mind to bear on it." End of footnote. I am not aware that the conclusion depends upon his testimony. You are to judge of and give that weight to it, as you think it deserves so far as it should command attention. It is not impeached. You will attribute to it the value and importance which it merits. Before proceeding away from this question of the remains, it may be proper to allude to the fact which was stated by Mr. Littlefield. I am not sure that it was by any other witness. That is, why these remains were not placed in the dissecting vault, instead of being placed in the laboratory and cellar. Seeing limbs there would have excited less suspicion. Mr. Littlefield says that it was double-locked, and that, though the key was there, it was in a dark place, and he had charge of it. I state several things here as I happen to find them upon my minutes, because they may as well come in at one place as at another. The general outline only of these facts it is necessary to state. Undoubtedly from Monday and Tuesday till Friday, there was pretty close watch kept on the medical college. On Monday, one of the family went there, Dr. Samuel Parkman. Mr. Kingsley and 2 officers with him were there also. A more thorough investigation was made on Tuesday by 4 officers, yet probably not particularly thorough, but every part had been looked through, at least except the vault. I speak of it as a vault because, though it is a large section of the cellar, yet it is separated from the rest by a solid wall and separated from the dissecting vault. The privy leading from the lower laboratory was the only means of access to it, except by taking up the floor, or by making an aperture through the brick wall. Every part of the building had been searched except that. With regard to the conduct of the defendant at the time of the arrest and since, it strikes us that not much can be drawn from it. Such are the various temperaments of people, such is the rare occurrence of an arrest for this crime. Who can say how a man ought to behave? How can you say that he was too much moved, or too little moved? Have you had any experience how you would behave in such a position? Judge you concerning that. The facts are before you regarding his conduct and language. They are a part of the evidence, but it strikes me that they cannot be very important. If the testimony is sufficient without, then this species of evidence is unnecessary. If they are not, then the conduct seems not sufficient to give any conclusive effect to the other proofs. Now, gentlemen, there are 2 things to consider. From the law which I have read to you, it appears that if 2 persons meet and one voluntarily destroys the life of the other, and no evidence appears, either in the testimony brought to convict him, or in that produced in his behalf, to show provocation or heat of blood, it is held to be murder or homicide with malice. I have stated that malice may be either implied or express. Malice express is where there is evidence of design in the previous acts of conduct of the accused. Murder by poison must be by express malice, because there must have been preparations previously. But whether malice in any case be expressed or implied, it is always murder if the homicide be voluntary and not death produced in heat of blood. There are two theories on which this is thought to be murder. One is that it was by express malice, and the other is that it was implied malice. That is, that if the express malice is not proved, and if the mitigation to manslaughter is not proved, still, in cases where there is not accident or suicide, it is murder by implied malice. The theory on the part of the government is that Dr. Parkman was the creditor of Dr. Webster, that he held two notes against him, that one was given as early as the year 1843, for $400 or $500, that afterwards another note was given, in which Dr. Parkman advanced another sum, making up in the whole $800, and other friends of Dr. Webster contributed enough to make up the sum of $2,400, so that, when collected, it would be partly his own and partly the money of others, that Dr. Parkman had insisted very urgently for the payment till the time of his death. It would seem from the facts which appear in the case that what he was urgent for was the payment of his own debt. Now, although he held the note for $2,400, which was not due till March 1851, still that embraced the $500 and the $332 a part of the old note, so that this smaller note, though not given up, was to be considered as paid when the larger note should be settled. You perceive, therefore, that he held two notes, one due to himself and one due to himself with others, that he had pressed for payment rather earnestly, that Dr. Webster had put him off, that the time had come for receiving the annual stipend, that Dr. Parkman had expected to receive his pay at that time, that Dr. Parkman wished to obtain the money received from the sale of tickets, that this fact was received from Dr. Cbteddy by Dr. Webster himself, that on Monday evening Dr. Parkman called at the college and urged Dr. Webster very strongly for payment, that the reply was that he could not pay him on that day, that he was finally put off until Friday. It seems, however, that in the interval he was seen on Thursday to go to Cambridge. Now, the paper which was found in his possession, being a paper drawn up by Dr. Webster's friend Cunningham, will exhibit the pecuniary transaction between these two parties. The suggestion is that Dr. Webster called at Dr. Parkman's house on that Friday morning and said that, if Dr. Parkman would come to the medical college at 1:30, he would pay him. The ground taken on the part of the prosecutor is that this was done for the purpose of inducing Dr. Parkman to come there, without the intention of paying him, that he did not pay him, that he had not the means of paying him, but that his object was to get possession of those notes on which this claim was due. And in consequence of this engagement, Dr. Parkman did go, that Dr. Webster, instead of being prepared to pay his debt, took measures to destroy the life of his creditor, with a view of getting possession of the notes without payment, that he did get such possession, that he then gave out to the world that he had paid $483.64, which was the smaller note, and therefore that the object was an act of plunder, and that, too, by taking the life of the individual. If that is proved to your satisfaction, undoubtedly it is a case of express malice. If proved, I cannot distinguish between this and a case of property found upon the person alleged to have plundered another of his property. Such possession, established by proof beyond reasonable doubt, tends to show that plunder was the object for which the act was done. Gentlemen, you will have the notes. There is abundant proof about the pecuniary transactions between Mr. Cbteddy and Dr. Webster. Mr. Cbteddy was an officer who was appointed to collect the dues from the students. He testifies to you that he happened to be at the medical college on the morning of that Friday, and they went there for the purpose of paying Dr. Webster $90, which was due to him, having paid him $250 or $260 before. $500 was received by Mr. Cbteddy to Dr. Webster's credit at one time, about half of which was paid to Dr. Bigelow. You will compare these statements of Mr. Petit with the bank book and say whether these were the sums received by Dr. Webster during that period. There is one of the circumstances which is very significant, and that is that the $90 paid on the morning of the Friday to Dr. Webster by Mr. Petit was not a part of the money used for the payment of the note for $483.64, which Dr. Webster stated that he paid on that day, because it appears that that was paid in a check on the Freeman's Bank, and also that on the next day, though possibly on that day after 2 o'clock, but not credited, as it was after bank hours until the next day, when the check was entered to his credit on the books of the Charles River Bank. Mr. Petit says that he told Dr. Webster that he did not choose to be troubled by Dr. Parkman, and on account of his desire of avoiding Dr. Parkman, he had previously told Littlefield to inform Dr. Webster that he would meet him on that Friday morning at the medical college to pay him whatever sums were due. He testifies that, though he had some business transactions with Dr. Webster at that time, he thinks he did not mention to Dr. Webster the harsh language used by Dr. Parkman. Still, he said he did mention that he had had trouble, and that Dr. Webster said there would be no difficulty about it, for he had settled with Dr. Parkman. If this engagement with Dr. Parkman was made by Dr. Webster with the purpose of getting possession of those notes, and by means of this arrangement he did get possession of those notes, it would be a very strong case of murder by express malice. A fact, if it be so, that there was still money due on the larger note, I mean money not paid, and which was not due for more than a year, would be a still stronger circumstance than finding the note that was due, because it is stated now by the defendant that he had collected money for the purpose of paying the $483, but he has not stated that anything more than that was paid. The evidence to show that these two notes were found in the possession of Dr. Webster upon a search of his house at Cambridge is before you, and you will judge whether it proves the fact beyond reasonable doubt. This is one of the facts in the chain of evidence which the court deemed material, without which the chain of circumstantial evidence would not seem to be complete. End of section 44. Section 45 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 35. It was my intention to examine all the testimony of his own account of the payment of the money. I think that you will find that the statement made to Mr. S. Parkman Blake was one of the fullest. I intended to read it, but I think it is not necessary. He says that Dr. Webster informed him that, about the time of the engagement, namely, at 1:30 on Friday noon, Dr. Parkman came to the medical college and that he paid him in the smaller room. That he took the money and started off hastily, with the money and papers in his hands. That Dr. Webster said to him, "You have not canceled the notes." That Dr. Parkman turned and dashed his pen through the signature, and was then hurrying away. When Dr. Webster spoke to him about discharging the mortgage, that he replied, "I will go and see to that." This mortgage turned out to be on personal property. The office was, therefore, that of the town clerk at Cambridgeport, and not at East Cambridge as was supposed. But if you find that money was due on the other note, and that the note was obtained without paying anything, you will have to consider the motive for it. If it is proved, this may tend to make out a case from circumstantial evidence, because it would tend to connect the defendant individually with the possession of the note, having a motive to obtain it. Then there is a great variety of circumstances tending to show the acts of the defendant in concealing these remains. Now, if it be surmised that these remains were placed there after the death of the party, and without the knowledge of Dr. Webster, of course, this concealment would not affect him. But I have already stated that the three portions were so situated with regard to each other that whoever had a motive to conceal one probably had a motive to conceal the other. And if this was done under circumstances so as to render it necessary, that it must have been done with the knowledge of Dr. Webster, that strengthens the conclusion that it was done by him, or at least with his concurrence. It is not necessary to go through all the circumstances relied upon to show the conduct of the defendant after he was arrested. If the defendant was charged with the guilt of murder, or if any man found himself charged with the guilt of such an offense, and the circumstances remain unexplained, they might tend to show an apparent consciousness of guilt. Dr. Webster's conduct, we think, ought to be considered to have a very slight bearing. There is nothing from the experience of the jury to show how men will act when charged with such a crime. The fact, in regard to Dr. Webster's statements made to different persons, that he never mentioned 2 notes, and yet 2 notes are found in his possession, would go to show motives of a conclusive character. So the fact that these papers were found in his possession or custody in Cambridge is of importance. It may be that he alluded in his letter to his daughter to the package given to his wife a day or 2 before, when he had been applied to obtain some citric acid. The letter does not say package, but bundle. Whether those were the papers which he requested to be concealed would be immaterial, and therefore it would be immaterial whether that was the package which he referred to, because the papers themselves furnish the material evidence. But if it referred to them, the letter itself might go a little further and show that he thought the possession of those papers might be hazardous to him, and therefore the attempt to conceal them, if proved, would bring it within the rule that the attempt to suppress proof or to alter any of the facts in the case would go against the accused. But if it led to a search, and hence these papers were found, the papers have the same effect, whether it alludes to them or not. It is sometimes said that small circumstances go to show great truths. Identity is sometimes proved by small circumstances. It is argued on the part of the prosecution that a piece of twine was tied about these remains similar to what was found in Dr. Webster's room. Gentlemen who have undertook to destroy these remains, whether the defendant or any other person, had access to the rooms of the defendant, and undoubtedly would use all the means within reach, whether under lock and key or not. To a person with such views, a lock would be of little avail. The whole apartments may be considered to be under the control of Dr. Webster. Of his knowledge of the fire and his presence, you can judge from the evidence. With regard to this twine, that somebody had the intention of concealing these remains, proposing first to conceal them, then to destroy them, is pretty manifest from the manner in which they are covered up and concealed. The same person who had the motive to do one probably did the whole. The same person who packed up the body used the cord. It seems a slight circumstance. By not dwelling upon these various circumstances, I do not intend to withdraw them from your consideration, but the time admonishes me that I must draw to a close. I might enumerate the witnesses. They are very numerous. The persons who speak of the search are Messrs. Shaw, Blake, Tukey, and others, as shown by witnesses Dr. Francis Parkman and Mr. Blake. The conduct of the defendant at different times was of such a character, and he was in such a situation that you will judge how far any statement made by him at those times ought to be considered as evidence bearing much against him. There is one circumstance which is dwelt upon with some force by the prosecuting officer, which ought, in the opinion of the court, not to be considered against the defendant. That is, that he waived an examination in the police court. Here was the inquest charging him with murder. What is the purpose of the police court? It is simply to find prima facie evidence to warrant a commitment. It is customary oftentimes to waive an examination there. The magistrates would not go into it as thorough an examination in that court as here. Its object is simply to ascertain whether a warrant shall be issued for the commitment of the accused. His waiving an examination there seems to us immaterial, more especially as there had been an inquest charging him with an offense. The judges consult together. I am told there had been no inquest at that time, but that is immaterial. There was sufficient evidence to hold the party for trial, and that is all that is required. Then, gentlemen, the question of the anonymous letters. If a person attempts to divert attention from himself, more especially if it is to fix attention upon others, that is one of those circumstances arising out of human conduct when an individual has been guilty of crime. But the facts cannot be proved certainly, and unless they are proved beyond reasonable doubt, they are not material. This only goes to show that, if the proof existed without them, they would corroborate it. But if the letter marked civis is written by him, you will judge whether he was placed in such a situation as to induce him to write it. A man may be placed in such a situation that he thinks there are strong circumstances against him, and without actual guilt may attempt to ward off proof. But proof is necessary. With regard to the other two letters, the proof is slight. You will judge for yourselves whether any of them were written by the defendant. If this act of homicide was committed by Professor Webster, and there is not sufficient proof to mitigate the crime to manslaughter, then the conclusion would be that it was murder by implied malice. If the other assertion is proved, that it was intended to decoy him to the college to do this deed, that is express malice. If it is not proved that he was there, then there must be a general verdict of acquittal. There is another point. It is competent for a person accused to give evidence of character. Now there are cases in which a man may stand in such a situation that a good character would be very important to him. A stranger may be placed where there were circumstances tending to charge him with larceny or with some other species of crime. He may show that, though there are suspicious circumstances, yet where he is known, he is esteemed to be of perfectly good character, and that sustains him. Such a character may defend him from such a crime. But where it is a question of a great and atrocious crime, it is so unusual, so out of the ordinary course of things, he must have been influenced by such facts and circumstances as to create effects which have unfrequently been produced upon a human mind, so that the evidence of character may be considered as far inferior to what it is in the case of smaller crimes. Against facts strongly proved, character cannot avail. It is therefore in smaller offenses, and such as relate to the actions of daily life, that if a man be charged with being light-fingered, for instance, he may bring evidence with regard to his character, showing that he would not be likely to yield to such a small temptation. In such a case, evidence concerning character may be given with some effect. But with regard to the higher crimes, the mere possession of a good character, though of less avail, is competent evidence to the jury and is one of a species which the party has a right to offer. The party accused may give evidence of it, and if he does, the party opposed may present evidence to contradict his witnesses. But a person who is charged with such an atrocious crime as this ought to prove his character by very strong evidence, to make it counterbalance strong proof on the other side. It is not competent for a prosecutor to give in proof of the bad character of the defendant, and it cannot be done unless the party on the other side puts in evidence of his good character. Gentlemen, we commend this case to your serious consideration here. It is impossible that a great many things should not be omitted. I shall feel rejoiced if I have stated such of the main considerations of this case as shall enable you to come to a fair and just conclusion. Many things press upon my mind which I intended to mention, and yet I have taken as much time as I ought to take. Gentlemen, we commend this case to your serious consideration. Weigh it unto the rules of law. Consider that you have been called upon and set apart. In the first place, drawn by a lot from those most experienced. You have been then selected from the body of those who have been drawn by a lot from those most experienced. You have been then selected from the body of those who have been drawn with all the advantages of which the condition of humanity will admit. And gentlemen, when it is said that it is possible to err, that is true. It is nothing more than to say that we are human. It is always possible to err. All that we can hope to do, you and your department and we and ours, is to exercise the best faculties of our minds, to give all the weight to the evidence which it deserves, to weigh carefully on both sides, and although we should come to a result which at some future time may be proved to be erroneous, yet still a consciousness that we have done our duty will sustain us. I commend this cause to your consideration. Take sufficient time, weigh the evidence, and give such a verdict as will satisfy your own judgment and your own sound conscience, and I am sure it will be a true one. The verdict. The jury retired and the court took a recess. 3 hours later, 10:50 p.m., the prisoner was conducted to his seat within the dock. Shortly after, the jury came in and then the court entered. Footnote. The following interesting letter, published in the Boston Daily Evening Traveler of April 1850, gives an account of the proceedings of the jury room. The author was Mr. Albert Day. To the editors of the Traveler, gentlemen, having read in several papers what purported to be a relation of the scenes and events which transpired in the jury room on the trial of John W. Webster, I have felt desirous, now that the subject has been brought before the public mind, that a plain statement of the more important matters connected with the jury room should be made, as it might prove interesting, if not instructive to the community. The jury was composed of 12 men, from as many different branches of the mechanical and mercantile professions. They were from 4 different religious denominations, and their ages varied from 28 to 66 years. They were men whom I should designate as possessing good common sense, men capable of judging, of discerning, of appreciating evidence, and estimating its importance. The jurors, after they had become better acquainted with each other, and as the evidence began to bear with crushing weight upon the prisoner, and the complicated network of circumstances seemed to encircle him, felt strongly the need of that wisdom which cometh from above, to guide and direct their minds aright in their most momentous and responsible situation. It was then that our worthy foreman, whom we all most highly respect, and whom we shall ever remember with pleasure, proposed to the jury that they should have religious services every evening. The proposition was most cheerfully responded to, and ever after that time, the voice of praise and prayer ascended, as we trust, from sincere hearts to the throne of infinite wisdom and mercy. I need not say that the burden of every prayer was for wisdom to guide and direct unto a right decision, and for blessings most rich and precious to descend upon the prisoner and his afflicted family. I now come to the closing part of this momentous trial, when the witnesses for the defense had given in their testimony, and the counsel for the prisoner announced the evidence on their part closed. A feeling of pain and anguish must have come over the mind of every juror. What? Can no more be said, no more be done in behalf of the unhappy prisoner? Is that the evidence, the only evidence on which we are to place our verdict of not guilty? At that very time, with the light which the able charge of the Chief Justice afterwards gave us on several points of the law and the evidence, I think I speak the sentiments of nearly, if not quite, all the jury, when I say that they were as fully prepared for their verdict as they were when they retired to the jury room after listening to the most able and eloquent pleas of the prisoner's senior counsel and the Attorney General. So strongly, so fully had the evidence pointed to the prisoner as the guilty man, and to no one else. After the jury had gone to their room with the various evidences of guilt spread out on the table before them, and the door locked upon them, shut out, as it were, entirely from the world, with nothing but the eye of the omniscient God upon them. So painful was the sense of responsibility, so unwilling were they to come to the result which all felt they must come to, that 30 to 40 minutes was spent ere anything was done, when at last the voice of the foreman was heard calling them to order, and reminding them of their duty, however painful. And when they had all taken their seats around the table, then it was that one of the jurors rose and said, "Mr. Foreman, before entering upon the further consideration and decision of this most important matter, I would propose that we seek for divine wisdom and guidance." The proposition met with a cordial response, and the foreman called upon a juror to offer a prayer. This was done most feelingly and sincerely. We then proceeded to the most trying and painful part of our arduous duty. The various articles which were put into the case were examined by the jury, and particularly those things which seemed to bear most strongly against the prisoner. The final decision of the question was resolved into 3 parts. First, are the remains of a human body found in the medical college on the 30th of November, 1849, those of the late Dr. George Parkman? Second, did Dr. George Parkman come to his death by the hands of Dr. John W. Webster in the medical college on the 23rd of November, 1849? Third, is Dr. John W. Webster guilty, as set forth in the indictment, of the willful murder of Dr. George Parkman? When the vote on the first question was put, 12 hands arose immediately. Some little discussion then took place. When the second question was tested, and 12 hands at once arose. The third, the most important question of all, was next to be tried. Quite a pause ensued. One juror, in his sympathies of kindness for the prisoner, who was his personal acquaintance or friend, and his afflicted family, shrunk from the fiery ordeal. Can't we stop here? Can't the law be vindicated and justice satisfied if we pause here? Must we take the life of the unhappy prisoner? Some discussion ensued. The mind of the juror seemed more calm, and he expressed his readiness to vote on the final question, which was then put, and 12 hands arose. The die was cast, and John W. Webster was pronounced guilty of murder. Thus ended the closing scene in the jury room. What afterwards transpired in the courtroom is already known to the public. When our foreman then pronounced that awful word, guilty, the jury as well as the prisoner trembled and grew faint. And what a relief it was to us when we were again allowed to go free and rejoin our families and friends, after so long and painful a separation. And there was not a juror's heart but would have leaped for joy could the prisoner have been justly allowed the same unspeakable blessing. One of the jury, Boston, April 3rd, 1850. End of footnote. The clerk. Gentlemen of the jury, have you agreed upon a verdict? We have. Who shall speak for you, gentlemen? The foreman. The clerk. John W. Webster, hold up your right hand. Foreman, look upon the prisoner. What say you, Mr. Foreman? Is John W. Webster, the prisoner at the bar, guilty or not guilty? The foreman, guilty. The clerk. Gentlemen of the jury, hearken to your verdict, as the court have recorded it. You, upon your oaths, do say that John W. Webster, the prisoner at the bar, is guilty. So you say, Mr. Foreman. So, gentlemen, you all say. When the foreman pronounced the word guilty, the prisoner started like a person shot. His hand dropped upon the rail in front, his chin drooped upon his breast, and after remaining thus a moment or two, he sank into the chair, covering his eyes with his hands. A death-like silence followed, and all eyes were fixed in sadness on him, whose hopes had now fled. For nearly 5 minutes he remained in this state, apparently unconscious, when Mr. Merrick conversed with him. The prisoner sat some time after the court adjourned, with his handkerchief to his eyes, and at his own request was removed to his cell, where he might be left to himself, free from the gaze of others. The sentence, April 1st. The court met at a few moments after 9 o'clock. The assemblage in the room embraced some of the most distinguished persons of the state, and many from other parts of the country. At 10 minutes after 9, the prisoner, in custody of 2 constables, was brought into court and took his seat in the dock. His appearance betokened extreme melancholy. He was downcast and nervous, and appeared to be suffering from terrible emotions. The Attorney General: May it please your honors, the prisoner at the bar at the January term of the municipal court in this county was indicted by the grand jury for the crime of willful murder. On that indictment, according to the provisions of the law, the prisoner was arraigned and pleaded not guilty. Counsel of his own selection, capable and faithful, were assigned to him by the court to assist in preparing and conducting his defense. The issue then has been presented to a jury almost of his own selection. Every aid from counsel has been rendered in making out his defense that could be rendered, and that jury have found him guilty of the charge. It now becomes my painful duty to move that the sentence which the law of this Commonwealth affixes to this offense should be passed upon the prisoner. The Clerk of the Court: John W. Webster, have you anything to say why sentence of death should not be pronounced upon you according to law? The prisoner rose, and placing his hands upon the bar in front of the dock, looking calmly towards the bench, he seemed as if disposed to speak, but, after a bow, again resumed his seat without doing so. End of section 45. Section 46 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 36. Chief Justice Shaw. On the call of his name, Professor Webster stood up. John W. Webster, in meeting you here for the last time, to pronounce that sentence which the law has affixed to the high and aggravated offense of which you stand convicted, it is impossible by language to give utterance to the deep consciousness of responsibility, to the keen sense of sadness and sympathy with which we approach this solemn duty. Circumstances which all who know me will duly appreciate, but which it may seem hardly fit to allude to in more detail, render the performance of this duty on the present occasion unspeakably painful. At all times and under all circumstances, a feeling of indescribable solemnity attaches to the utterance of that stern voice of retributive justice which consigns a fellow being to an untimely and ignominious death. But when we consider all the circumstances of your past life, your various relations to society, the claims upon you by others, the hopes and expectations you have cherished, and contrast them with your present condition and the ignominious death which awaits you, we are oppressed with grief and anguish, and nothing but a sense of imperative duty imposed on us by the law, whose officers and ministers we are, could sustain us in pronouncing such a judgment. Against the crime of willful murder, of which you stand convicted, a crime at which humanity shudders, a crime everywhere and under all forms of society regarded with the deepest abhorrence, the law has denounced its severest penalty in these few simple but solemn and impressive words. Every person who shall commit the crime of murder shall suffer the punishment of death for the same. The manifest object of this law is the protection and security of human life, the most important object of a just and paternal government. It is made the duty of this court to declare this penalty against anyone who shall have been found guilty, in due course of the administration of justice, of having violated this law. It is one of the most solemn acts of judicial power which an earthly tribunal can be called upon to exercise. It is a high and exemplary manifestation of the sovereign authority of the law, as well in its stern and inflexible severity as in its protecting and paternal benignity. It punishes the guilty with severity in order that the right to the enjoyment of life, the most precious of all rights, may be more effectually secured. By the record before us, it appears that you have been indicted by the grand jury of this county for the crime of murder, alleging that on the 23rd November last, you made an assault on the person of Dr. George Parkman, and by acts of violence deprived him of life, with malice aforethought. This is alleged to have been done within the apartments of a public institution in this city, the Medical College, of which you were a professor and instructor, upon the person of a man of mature age, well known, and of extensive connections in this community, and a benefactor of that institution. The charge of an offense so aggravated under such circumstances in the midst of a peaceful community created an instantaneous outburst of surprise, alarm, and terror, and was followed by a universal and intense anxiety to learn, by the results of a judicial proceeding, whether this charge was true. The day of trial came. A court was organized to conduct it. A jury almost of your own choosing was selected in the manner best calculated to ensure intelligence and impartiality. Counsel were appointed to assist you in conducting your defense, who have done all that learning, eloquence, and skill could accomplish in presenting your defense in its most favorable aspects. A very large number of witnesses were carefully examined, and after a laborious trial of unprecedented length, conducted, as we hope, with patience and fidelity, that jury have pronounced you guilty. To this verdict, upon a careful revision of the whole proceedings, I am constrained to say, in behalf of the court, that they can perceive no just or legal ground of exception. Guilty? How much, under all the thrilling circumstances which cluster around the case and throng our memories in the retrospect, does this single word import? The willful, violent, and malicious destruction of the life of a fellow man, in the peace of God and under the protection of the law. Yes, of one of the midst of life, with bright hopes, warm affections, mutual attachments, strong, extensive, and numerous, making life a blessing to himself and others. We allude thus to the injury you have inflicted not for the purpose of awakening one unnecessary pang in a heart already lacerated, but to remind you of the irreparable wrong done to the victim of your cruelty, in sheer justice to him whose voice is now hushed in death, and whose wrongs can only be vindicated by the living action of the law. If, therefore, you may at any moment think your case a hard one, and your punishment too severe, if one repining thought arises in your mind, or one murmuring word seeks utterance from your lips, think of him, instantly deprived of life by your guilty hand. Then, if not lost to all sense of retributive justice, if you have any compunctious visitings of conscience, you may perhaps be ready to exclaim in the bitter anguish of truth, I have sinned against heaven and my own soul. My punishment is just. God be merciful to me, a sinner. God grant me that your example may afford a solemn warning to all, especially to the young. May it impress deeply upon every mind the salutary lesson it is intended to teach, to guard against the indulgence of every unhallowed and vindictive passion, to resist temptation to any and every selfish, sordid, and wicked purpose, to listen to the warnings of conscience, and yield to the plain dictates of duty, and whilst they instinctively shrink with abhorrence from the first thought of assailing the life of another, may they learn to reverence the laws of God and of society, designed to secure protection to their own. We forbear, for obvious considerations, from adding such words of advice as may be sometimes thought appropriate on occasions like this. It has commonly been our province, on occasions like the present, to address the illiterate, the degraded, the outcast, whose early life has been cast among the vicious, the neglected, the abandoned, who have been blessed with no means of moral or religious culture, who have never received the benefits of cultivated society, nor enjoyed the sweet and ennobling influences of home. To such a one, a word of advice, upon an occasion so impressive, may be a word fitly spoken and tend to good. But in a case like this, where these circumstances are all reversed, no word of ours could be more efficacious than the suggestions of your own better thoughts, to which we commend you. But as we approach this last sad duty of pronouncing sentence, which is indeed the voice of the law and not our own, yet in giving it utterance, we cannot do it with feelings of indifference, as a mere formal and official act. God forbid that we should be prevented from indulging in expressing those irreparable feelings of interest, sympathy, and compassion, which arise spontaneously in our hearts, and do most sincerely and cordially deplore the distressing condition into which crime has brought you. And though we have no word of present consolation or of earthly hope to offer you in this hour of your affliction, yet we devoutly commend you to the mercy of our Heavenly Father, with whom is abundance of mercy, and from whom we shall all hope for pardon and peace. And now nothing remains but the solemn duty of pronouncing the sentence which the law affixes to the crime of murder, of which you stand convicted, which sentence is, the court and spectators rising, that you, John W. Webster, be removed from this place and detained in close custody in the prison of this county, and thence taken at such time as the executive government of this commonwealth may, by their warrant, appoint to the place of execution, and there be hung by the neck until you are dead. And may God, in his infinite goodness, have mercy on your soul. The prisoner sank back into his chair and wept. He took a handkerchief, and after wiping his face, placed his forehead upon the bar, as if to conceal the current of his tears from the 1,000 eyes that were turned upon him. In this position he remained until disturbed by the officers who had him in charge. About 5 minutes were now passed in solemn silence, which was suddenly broken by the Chief Justice, who said, "Mr. Sheriff, the prisoner is in your custody. Mr. Crier, adjourn the court until tomorrow morning at 9 o'clock. The prisoner was accordingly manacled and remanded, and the court adjourned. The appeal and confession. The prisoner appealed to the Supreme Court on several technical questions of procedure, but on June 18th, judgment and sentence were affirmed, Chief Justice Shaw delivering the opinion of the court. While the appeal was pending, he presented a petition to the governor and council for a commutation of sentence, in which he said, "I ask to be permitted to declare in the most solemn manner that I am entirely innocent of this awful crime, that I never entertained any other than the kindest feelings towards him, and that I never had any inducement to injure in any way him whom I have long numbered among my best friends. To him who seeth in secret, and before whom I may ere long be called to appear, would I appeal for the truth of what I now declare, as also for the truth of the solemn declaration, that I had no agency in placing the remains of a human body in or under my rooms in the Medical College in Boston, nor do I know by whom they were so placed. I am the victim of circumstances, or a foul conspiracy, or of the attempt of some individual to cause suspicion to fall upon me, influenced perhaps by the prospect of obtaining a large reward." This was withdrawn, probably on the advice of his counsel, and on July 2nd his clergyman, Reverend George Putnam, appeared before the council and stated that Dr. Webster had made a confession to him, which he read to the council, the main portions being as follows. On Tuesday, the 20th of November, I sent the note to Dr. Parkman, which it appears was carried by the boy Maxwell. I handed it to Littlefield unsealed. It was to ask Dr. Parkman to call at my room on Friday the 23rd, after my lecture. He had become of late very importunate for his pay. He had threatened me with a suit to put an officer into my house and to drive me from my professorship if I did not pay him. The purport of my note was simply to ask the conference. I did not tell him in it what I could do or what I had to say about the payment. I wished to gain for those few days a release from his solicitations, to which I was liable every day, on occasions and in a manner very disagreeable and alarming to me, and also to avert, for so long a time at least, the fulfillment of recent threats of severe measures. I did not expect to be able to pay him when Friday should arrive. My purpose was, if he should accede to the proposed interview, to state to him my embarrassments and utter inability to pay him at present, to apologize for these things and my conduct which had offended him, to throw myself upon his mercy, to beg for further time and indulgence for the sake of my family, if not for my own, and to make as good promise to him as I could have any hope of keeping. I did not hear from him on that day, nor the next Wednesday, but I found that on Thursday he had been abroad in pursuit of me, though without finding me. I feared that he had forgotten the appointment or else did not mean to wait for it. I feared he would come in upon me at my lecture hour, or while I was preparing my experiments for it. Therefore, I called at his house on that morning, Friday, between 8 and 9, to remind him of my wish to see him at the college at 1:30. My lecture closing at 1. I did not stop to talk with him then, for I expected the conversation would be a long one, and I had my lecture to prepare for. It was necessary for me to save my time and also to keep my mind free from other exciting matters. Dr. Parkman agreed to call on me, as I proposed. He came, accordingly, between 1:30 and 2. He came in at the lecture room door. I was engaged in removing some glasses from my lecture room table into the room in the rear, called the upper laboratory. He came rapidly down the steps and followed me into the laboratory. He immediately addressed me with great energy. "Are you ready for me, sir? Have you got the money?" I replied, "No, Dr. Parkman," and was then beginning to state my condition and make my appeal to him. He would not listen to me, but interrupted me with much vehemence. He called me scoundrel and liar, and went on heaping upon me the most bitter taunts and opprobrious epithets. While he was talking, he drew a handful of papers from his pocket, and took from among them my 2 notes, and also an old letter from Dr. Hoag, written many years ago, in congratulating him, Dr. P., on his success in getting me appointed professor of chemistry. "You see," he said, "I got you into your office, and now I will get you out of it." He put back into his pocket all the papers, except the letter and the notes. I cannot tell how long the torrent of threats and invective continued, and I can now recall to memory but a small portion of what he said. At first I kept interposing, trying to pacify him, so that I might obtain the object for which I had sought the interview. But I could not stop him, and soon my own temper was up. I forgot everything. I felt nothing but the sting of his words. I was excited to the highest degree of passion, and while he was speaking and gesticulating in the violent and menacing manner, thrusting this letter and his fist into my face, in my fury I seized whatever was the handiest. It was a stick of wood, and dealt him an instantaneous blow with all the force that passion could give it. I did not know, nor think nor care where I should hit him, nor how hard, nor what the effect would be. It was on the side of his head, and there was nothing to break the force of the blow. He fell instantly upon the pavement. There was no second blow. He did not move. I stooped down over him, and he seemed to be lifeless. Blood flowed from his mouth, and I got a sponge and wiped it away. I got some ammonia and applied it to his nose, but without effect. Perhaps I spent 10 minutes in attempts to resuscitate him, but I found that he was absolutely dead. In my horror and consternation, I ran instinctively to the doors and bolted them, the doors of the lecture room and of the laboratory below. And then, what was I to do? It never occurred to me to go out and declare what had been done and obtain assistance. I saw nothing but the alternative of a successful removal and concealment of the body, on the one hand, and of infamy and destruction on the other. The first thing I did, as soon as I could do anything, was to drag the body into the private room adjoining. Then I took off the clothes and began putting them into the fire, which was burning in the upper laboratory. They were all consumed there that afternoon, with papers, pocketbook, or whatever else they may have contained. I did not examine the pockets nor remove anything except the watch. I saw that, on the chain of it hanging out, and I took it and threw it over the bridge as I went to Cambridge. My next move was to get the body into the sink which stands in the small private room. By setting the body partially erect against the corner and getting up into the sink myself, I succeeded in drawing it up. There it was entirely dismembered. It was quickly done, as a work of terrible and desperate necessity. The only instrument used was the knife found by the officers in the tea chest, and which I kept for cutting corks. I made no use of the Turkish knife, as it was called at the trial. That had long been kept on my parlor mantelpiece in Cambridge, as a curious ornament. My daughters frequently cleaned it, hence the marks of oil and whiting found on it. I had lately brought it into Boston to get the silver sheath repaired. While dismembering the body, a stream of catechuate was running through the sink, carrying off the blood in a pipe that passed down through the lower laboratory. There must have been a leak in the pipe, but the ceiling below was stained immediately round it. There was a fire burning in the furnace of the lower laboratory. Littlefield was mistaken in thinking there had never been a fire there. He had probably never kindled one, but I had done it myself several times. I had done it that day for the purpose of making oxygen gas. The head and viscera were put into that furnace that day, and the fuel heaped on. I did not examine at night to see to what degree they were consumed. Some of the extremities, I believe, were put in there on that day. The pelvis and some of the limbs, perhaps all, were put under the lid of the lecture room table in what is called the well, a deep sink lined with lead. A stream of catechuate was turned into it and kept running through it all Friday night. The thorax was put into a similar well in the lower laboratory, which I filled with water, and threw in a quantity of potash, which I found there. This disposition of the remains was not changed till after the visit of the officers on Monday. When the body had been thus all disposed of, I cleared away all traces of what had been done. I took up the stick with which the fatal blow had been struck. It proved to be the stump of a large grapevine, say 2 inches in diameter and 2 feet long. It was one of 2 or more pieces which I had carried in from Cambridge long before, for the purpose of showing the effect of certain chemical fluids in coloring wood, by being absorbed into the pores. The grapevine, being a very porous wood, was well suited to this purpose. Another longer stick had been used as intended, and exhibited to the students. This one had not been used. I put it into the fire. I took up the 2 notes, either from the table or the floor, I think the table, close by where Dr. P. had fallen. I seized an old metallic pen lying on the table, dashed it across the face and through the signatures, and put them in my pocket. I do not know why I did this rather than put them into the fire. for I had not considered for a moment what effect either mode of disposing of them would have on the mortgage or my indebtedness to Dr. P. and the other persons interested, and I had not yet given a single thought to the question as to what account I should give of the objects or results of my interview with Dr. Parkman. I never saw the sledgehammer spoken of by Littlefield, and never knew of its existence. At least, I have no recollection of it. I left the college to go home as late as 6 o'clock. I collected myself as well as I could, that I might meet my family and others with composure. On Saturday, I visited my rooms at the college, but made no change in the disposition of the remains, and laid no plans as to my future course. On Saturday evening, I read the notice in the transcript respecting the disappearance. I was then deeply impressed with the necessity of immediately taking some ground as to the character of my interview with Dr. P., for I saw that it must become known that I had such an interview, as I had appointed it first, by an unsealed note on Tuesday, and on Friday had myself called at his house in open day and ratified the arrangement, and had they been seen and probably overheard by the manservant, and I knew not by how many persons Dr. P. might have been seen entering my rooms, or how many persons he might have told by the way where he was going. The interview would, in all probability, be known, and I must be ready to explain it. The question exercised me much, but on Sunday my course was taken. I would go into Boston, and be the first to declare myself the person as yet unknown with whom Dr. P. had made the appointment. I would take the ground that I had invited him to the college to pay him money, and that I had paid him accordingly. I fixed upon the sum by taking the small note and adding interest, which it appears I cast erroneously. If I had thought of this course earlier, I should not have deposited Petit's check for $90 in the Charles River Bank on Saturday, but should have suppressed it as going so far towards making up the sum which I was to profess to have paid the day before, and which Petit knew I had by me at the hour of the interview. It had not occurred to me that I should ever show the notes cancelled in proof of the payment. If it had, I should have destroyed the large note, and let it be inferred that it was gone with the missing man, and I should only have kept the small one, which was all that I could pretend to have paid. My single thought was concealment and safety. Everything else was incidental to that. I was in no state to consider my ulterior pecuniary interests. Money, though I needed it so much, was of no account with me in that condition of mind. If I had designed and premeditated the homicide of Dr. P. in order to get possession of the notes and cancel my debt, I not only should not have deposited Petit's check the next day, but I should have made some show of getting and having the money the morning before. I should have drawn my money from the bank and taken occasion to mention to the cashier that I had some to take out that day for Dr. P., and the same to Henchman when I borrowed the $10. I should have remarked that I was so much short of a large sum that I was to pay to Dr. Parkman. I borrowed the money of Henchman as mere pocket money for the day. If I had intended the homicide of Dr. P., I should not have made the appointment with him twice, and each time in so open a manner that other persons would almost certainly know of it. And I should not have invited him to my room at an hour when the college would have been full of students and others, and an hour when I was most likely to receive calls from others, for that was an hour just after the lecture, at which persons having business with me or in my rooms were always directed to call. I looked into my rooms on Sunday afternoon, but did nothing. After the first visit of the officers, I took the pelvis and some of the limbs from the upper well and threw them into the vault under the privy. I took the thorax from the well below and packed it in the tea chest as found. My own impression has been that this was not done till after the second visit of the officers, which was on Tuesday, but Kingsley's testimony shows that it must have been done sooner. The perforation of the thorax had been made by the knife at the time of removing the viscera. On Wednesday, I put on kindling and made a fire in the furnace below, having first poked down the ashes. Some of the limbs, I cannot remember what ones or how many, were consumed at that time. This was the last I had to do with the remains. The tin box was designed to receive the thorax, though I had not concluded where I should finally put the box. The fishhooks, tied up as grapples, were to be used for drawing up the parts in the vault, whenever I should determine how to dispose of them. And yet, strange enough, I had a confused double object in ordering the box and making the grapples. I had before intended to get such things to send to Fayal, the box to hold plants and other articles, which I wished to protect from salt water and the sea air, and the hooks to be used there in obtaining coralline plants from the sea. It was this previously intended use of them that suggested and mixed itself up with the idea of the other application. I doubt, even now, to which use they would have been applied. I had not used the hooks at the time of the discovery. The tan put into the tea chest was taken from a barrel of it that had been in the laboratory some time. The bag of tan brought in on Monday was not used, nor intended to be used. It belonged to a quantity obtained by me a long time ago for experiments in tanning, and was sent in by the family to get it out of the way. It being sent just at the time was accidental. I was not aware that I had put the knife into the tea chest. The stick found in the saucer of ink was for making coarse diagrams on cloth. The bunch of filed keys had been long ago picked up by me in Fruit Street and thrown carelessly into a drawer. I never examined them, and do not know whether they would fit any of the locks of the college or not. If there were other keys fitting doors with which I had nothing to do, I suppose they must have been duplicates, or keys of former locks, left there by the mechanics or janitor. I know nothing about them, and should never be likely to notice them amongst the multitude of articles, large and small, and of all kinds, collected in my rooms. The janitor had furnished me a key to the dissecting room for the admission of medical friends visiting the college, but I had never used it. The nitric acid on the stairs was not used to remove the spots of blood, but dropped by accident. When the officers called for me on Friday, 30th, I was in doubt whether I was under arrest or whether a more strict search of my rooms was to be had, the latter hypothesis being hardly less appalling than the former. When I found that we went over Craigie's Bridge, I thought the arrest most probable. When I found the carriage was stopping at the jail, I was sure of my fate, and before leaving the carriage, I took a dose of strychnine from my pocket and swallowed it. I had prepared it in the shape of a pill before I left my laboratory on the 23rd. I thought I could not bear to survive detection. I thought it was a large dose. The state of my nervous system probably defeated its action, partially. The effects of the poison were terrible beyond description. It was in operation at the college and before I went there, but more severely afterwards. I wrote but one of the anonymous letters produced at the trial, the one mailed at East Cambridge. The little bundle referred to in the letter detained by the jailer contained only a bottle of citric acid for domestic use. I had seen it, stated in the newspaper, that I had purchased a quantity of oxalic acid, which it was presumed was to be used in removing blood stains. I wished the parcel to be kept untouched, that it might be shown, if there should be occasion, what it really was that I had purchased. On July 18th, the council reported to the governor, refusing to recommend a commutation of the sentence, and on July 19th, Governor Briggs ordered the execution to take place on Friday, August 30th. Footnote: Briggs, George Nixon, 1796 to 1861. Born Adams, Massachusetts. Member of Congress, 1831 to 1843. Governor of Massachusetts, 1844 to 1851. Member State Constitutional Convention, 1853. Judge Common Pleas, 1853 to 1859. trustee of Williams College. End of footnote. The execution, August 30th. The scaffold was not erected until after daylight this morning. It was placed in the center of the yard, visible from the rear of Lowell Street and the houses on the west side of Leverett Street. A change had been made in its construction, a spring having been substituted to cause the falling of the drop upon which the condemned stands, instead of the cutting of the rope. At an early hour this morning, those persons who had been furnished with passes began to assemble in the jail yard. They numbered about 150, of whom some 15 or 20 were representatives of the press. The constables, police officers, and other city officers, to the number of about 125, kept order within and without the walls of the jail. The prisoner partook of a slight breakfast, and at 8:15 was visited by Dr. Putnam and the jailer. The arrangements for the execution had all been explained at a previous interview. Dr. Putnam, having spent an hour or more with him in religious conversation and devotional exercises, at Dr. Webster's request, Sheriff Eveleth and the officers of the jail were then sent for. When they entered, he thanked them in warm terms for their many kind attentions and for their considerate conduct during his long confinement. At 9:15, the legal witnesses of the execution, headed by the sheriff and his deputies, and followed by the spectators generally, then entered the archway of the jail to the prisoner's cell, where a short but fervent prayer was offered by Reverend Dr. Putnam. He prayed for a brother now about to pass from this life of sin, to be removed from this world to another. He invoked for him the aids of the Holy Spirit, and prayed that his repentance might be accepted, and be accounted to him as such in the sight of the Searcher of all hearts. He prayed that the humble hope of forgiveness that the prisoner had been permitted to entertain might be realized in a blissful fruition. He also prayed for those who had been bereaved by the transgressions of the condemned man, for the ministers of the law, who, while they performed their bounden duty, did it with mercy and tenderness, that the memories and admonishments of this hour might be sanctified to all who stood before God, mortal and soon to die. We commit, he said, thy child to thee, and while he bows himself to the law, behold him, a humble suppliant at the throne of him who tempereth justice with mercy, and receiveth the contrite heart. Open the doors of thy mansion, that he may enter. Do more and better for him than we can ask or think. At the conclusion of this prayer, the spectators retired from the arch. The arms of the condemned were pinioned to his side, and the procession marched to the scaffold. By the side of the condemned was his faithful religious counselor and adviser, who had promised to accompany him and be present at the parting scene. No sign of faltering could be observed as he ascended the steps. He appeared subdued, as one conscious of having committed a great sin, for which he was about to suffer. As he stepped upon the drop, he looked around for his faithful friend Dr. Putnam, who was by his side, and entered into apparently earnest conversation with him. At almost every word, Dr. Webster bowed his head, as if what he was saying was emphatically the outpouring of his heart. Deputy Sheriff Coburn called the attention of the witnesses to the reading of the executive death warrant, which was next done in an audible manner by the sheriff, who, with his officers and the assembly, generally remained with uncovered heads during the reading, with the exception of the prisoner. At the conclusion of the reading of the warrant, Dr. Webster shook hands with Dr. Putnam, who took of him a final farewell. He was then placed in a chair to have his legs pinioned. After this was done, he again stood up. The touch of the rope upon his neck caused his face, which had been before of a deadly pallor, to flush, and there were evident signs of subdued but still powerful agitation. He then shook hands with the sheriff and spoke a few words to him. The black cap was then placed over his face, and the light of day thus shut up from him in this world forever. The sheriff then turned to the assembled spectators and in a loud voice proclaimed that in the name and by the command of the Commonwealth of Massachusetts, he should now proceed to do execution upon the body of John W. Webster. At this knell of death, there was no motion of the body of the condemned, the features of the face being entirely hid from view, but he stood perfectly still, awaiting the fatal plunge. After concluding his proclamation, the sheriff turned around, and pressing a spring, the drop fell, and the prisoner's mortal career was at an end. This took place at 25 minutes before 10 o'clock. The body swayed slightly to and fro, and in a few seconds after the fall, there was a spasmodic drawing up of the legs, once or twice. Beyond this, there was no observable struggle. After hanging 30 minutes, the body was examined by Dr. Henry G. Clark, city physician, and by Dr. Charles H. Stedman of the Lunatic Hospital, South Boston, and they informed the sheriff that life was extinct. End of section 46.
Section 47 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Larry Wilson. American State Trials, Volume 4 by John D. Lawson. The trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 37. The Execution, August 30th. The scaffold was not erected until after daylight this morning. It was placed in the center of the yard, visible from the rear of Lowell Street, and the houses on the west side of Leverett Street. A change had been made in its construction, a spring having been substituted to cause the falling of the drop upon which the condemned stands, instead of the cutting of a rope. At an early hour this morning, those persons who had been furnished with passes began to assemble in the jail yard. They numbered about 150, of whom some 15 or 20 were representatives of the press. The constables, police officers, and other city officers, to the number of about 125, kept order within and without the walls of the jail. The prisoner partook of a slight breakfast, and at 8:15 was visited by Dr. Putnam and the jailer. The arrangements for the execution had all been explained at a previous interview, Dr. Putnam having spent an hour or more with him in religious conversation and devotional exercises, at Dr. Webster's request. Sheriff Eveleth and the officers of the jail were then sent for. When they entered, he thanked them in warm terms for the many kind attentions, and for their considerate conduct during his long confinement. At 9:15, the legal witnesses of the execution, headed by the sheriff and his deputies, and followed by the spectators generally, then entered the archway of the jail, to the prisoner's cell, where short but fervent prayer was offered by Rev. Dr. Putnam. He prayed for a brother now about to pass from this life of sin to be removed from this world to another. He invoked for him the aids of the Holy Spirit, and prayed that his repentance might be accepted, and be accounted to him as such in the sight of the Searcher of all hearts. He prayed that the humble hope of forgiveness that the prisoner had been permitted to entertain might be realized in a blissful fruition. He also prayed for those who had been bereaved by the transgressions of the condemned man, for the ministers of the law, who, while they performed their bounden duty, did it with mercy and tenderness, that the memories and admonishments of this hour might be sanctified to all who stood before God, mortal and soon to die. "We commit," he said, "thy child to thee." And while he bows himself to the law, behold him, an humble suppliant, at the throne of him who tempereth justice with mercy, and receiveth the contrite heart. Open the doors of thy mansion, that he may enter. Do more and better for him than we can ask or think. At the conclusion of this prayer, the spectators retired from the arch. The arms of the condemned were pinioned to his side, and the procession marched to the scaffold. By the side of the condemned was his faithful religious counselor and adviser, who had promised to accompany him, and be present at the parting scene. No sign of faltering could be observed as he ascended the steps. He appeared subdued, as one conscious of having committed a great sin for which he was about to suffer. As he stepped upon the drop, he looked around for his faithful friend, Dr. Putnam, who was by his side, and entered into apparently earnest conversation with him. At almost every word, Dr. Webster bowed his head, as if what he was saying was emphatically the outpouring of his heart. Deputy Sheriff Coburn called the attention of the witnesses to the reading of the executive death warrant, which was next done in an audible manner by the sheriff, who with his officers and the assembly generally remained with uncovered heads during the reading, with the exception of the prisoner. At the conclusion of the reading of the warrant, Dr. Webster shook hands with Dr. Putnam, who took of him a final farewell. He was then placed in a chair to have his legs pinioned. After this was done, he again stood up. The touch of the rope upon his neck caused his face, which had been before of a deadly pallor, to flush, and there were evident signs of a subdued but still powerful agitation. He then shook hands with the sheriff and spoke a few words to him. The black cap was then placed over his face, and the light of day thus shut out from him in this world forever. The sheriff then turned to the assembled spectators, and in a loud voice proclaimed that in the name and by the command of the Commonwealth of Massachusetts he should now proceed to do execution upon the body of John W. Webster. At this knell of death there was no motion of the body of the condemned, the features of the face being entirely hid from view, but he stood perfectly still, awaiting the fatal plunge. After concluding his proclamation, the sheriff turned around, and pressing a spring, the drop fell, and the prisoner's mortal career was at an end. This took place at 25 minutes before 10 o'clock. The body swayed slightly to and fro, and in a few seconds after the fall there was a spasmodic drawing up of the legs once or twice. Beyond this there was no observable struggle. After hanging 30 minutes, the body was examined by Dr. Henry G. Clark, city physician, and by Dr. Charles H. Stedman of the Lunatic Hospital, South Boston, and they informed the sheriff that life was extinct. End of section 47.
Section 48 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. The Trial of Thomas Hoag for Bigamy, New York City, 1804. The Narrative. It was not Thomas Hoag that was on trial for bigamy one day in the opening years of the 19th century. Yet Catherine Conklin swore that a man of that name had married her 2 years before in a small town in the country, and that he was the same individual that was sitting in the dock before her. The prisoner denied this, said he had never seen or heard of her before, and that on the Christmas day, which Catherine said was their wedding day, he was many miles away in the city of New York, attending to his duties as a policeman, and that his name was Joseph Parker. His captain said the same thing. The records of the police office confirmed his statement, and a number of his acquaintances swore that they had known him for years, and that he was Joseph Parker. But Catherine's story was supported by several of her neighbors, who said that they had seen him often in her company, and that Hoag had a scar on the forehead and lisped a little. The prisoner, strange to say, had both of these peculiarities. But the witnesses further swore that Hoag had a bad scar on the sole of his foot, which was very plain, and which he told them was occasioned by his stepping on the upturned blade of a knife. In this state of difference of opinions, the counsel on both sides agreed that they would not call any more witnesses or make any speeches. but would ask the prisoner to expose his feet to the jury. He did so. No trace of the scar was found. The jury, without leaving the box, returned a verdict of not guilty, and Joseph Parker, who had entered the courtroom as Thomas Hoag, left it a free man. The trial. In the Court of Oyer and Terminer, New York City, June 1804. Honorable Henry Brockholst Livingston, Judge. June 22nd. Thomas Hoag was indicted for bigamy at the last term of this court for the county of Rockland. The indictment, which was removed by consent so that the trial should take place in this city, alleged that Thomas Hoag, late of Haverstraw in the county of Rockland, laborer, now of New York, cartman, on the 8th day of May 1789 at that city, was lawfully married to Susan Faish, and afterwards, on the 25th day of December 1800, in the county of Rockland, his said wife being then alive, feloniously did marry Catherine Secor. The prisoner pleaded not guilty. Richard Riker, District Attorney for the People. Washington Morton, for the prisoner. Witnesses for the people. The prisoner's counsel admitted that he was married in May 1789 as charged, and that his wife was still living. Benjamin Coe, am one of the judges of the Court of Common Pleas in the county of Rockland, am well acquainted with defendant. He came to Rockland in the beginning of September 1800, where he passed by the name of Thomas Hoag. There was a person with him who passed for his brother, but between them there was no resemblance. Defendant worked for me about a month, during which time he ate daily at my table, and of course I saw him daily. On 25th December I married him to one Catherine Secor. Am confident of the time because on that day one of my own children was christened. During all the time he remained in Rockland County, I saw him continually, and am therefore as much satisfied that he is Thomas Hoag as that I am Benjamin Coe. John Knapp, new defendant in 1800 and 1801. He was then in Rockland County and passed by the name of Thomas Hoag. Saw him constantly 5 months while he was there. Was at his wedding. He had a scar under his foot. Know it from this circumstance. Defendant and myself were leaping together, and upon my out-leaping him, he remarked that he could not leap then so well as formerly, and before he received a wound on his foot by treading on a drawing knife. He therefore pulled off his shoe and showed me a scar under his foot, occasioned, as he said, by that wound. The scar is very perceptible. I am confident that the defendant at the bar is Thomas Hoag. Catherine Conklin. My maiden name was Catherine Secor. Am now married to one Conklin. Became acquainted with defendant in September 1800 when he came to Rockland. He passed by the name of Thomas Hoag. Saw him constantly, and shortly after our acquaintance he paid his addresses to me, and on 25th December married me. He lived with me till the end of March 1801, when he left me. Did not see him again for 2 years. On the morning of his leaving me, he appeared desirous of communicating something of importance to me, but was dissuaded from it by the person who passed for his brother. Before Hoag left me he was a kind, attentive, and affectionate husband. I am as well convinced as I can possibly be of anything in the world that the defendant, now here, is the person who married me by the name of Thomas Hoag, then thought him, and still think him, the handsomest man I ever saw. How often, addressing herself to defendant and looking at his hair, have I combed those dear locks. Witnesses for the defense. Joseph Chadwick. I live in this city and am a rigger by trade. I have been acquainted with defendant Joseph Parker a number of years. He has worked in my employ as a rigger a considerable time. He began to work for me in September 1799 and continued to work for me until the spring of 1801. During that time, saw him constantly. It appears from my books that he received money from me for work performed on the following days: 6th October, 6th and 13th December 1800, 9th, 16th and 28th February, 11th March 1801. He lived from May 1800 till some time in April 1801 in a house in this city belonging to Captain Pelor, and during that time and since have been well acquainted with him. Isaac Rickman. Live in this city and am well acquainted with Parker. Have known him a number of years. In latter end of year 1800, he was jointly engaged with me in loading a vessel for Captain Treadwell of this place. We began to work 20th December 1800 and were employed the greater part of January 1801 in loading the vessel. During that time we worked together daily. Recollect that we worked together on 25th day of December 1800. Remember it because I never worked on Christmas before nor since. Know that it was in the year 1800 because I know that Parker that year lived in Captain Pelor's house. Remember our borrowing a screw for the purpose of packing cotton into the hold of the vessel we were loading. We borrowed the screw from Mrs. Mitchell, who lived next door to Parker's, was one of the city watch at that time, and Parker was then on the watch. From that time to the present have served with him upon the watch, and do not recollect missing him at any time during that period from this city. Aspinwall, Cornwall. Live in Rutgers Street. Have lived there a number of years. Keep a grocery. Knew Parker, the defendant, in 1800 and 1801, who lived in Captain Pelor's house 1 year, and during that time traded with me. Recollect once missing him for a week, and on inquiry found he had been at Staten Island at work on board one of the United States frigates. Excepting that time, never knew him to be absent from his family, and I saw him constantly. Elizabeth Mitchell. I know Parker well. In 1800 and 1801 he lived in a house belonging to Captain Pelor, adjoining that in which I lived. Was intimate in Parker's family and visited there constantly. He was one of the city watch. Used to hear him rap with his stick at the door to waken his family upon his return from the watch in the morning. Perfectly well remember his borrowing a screw from me on Christmas Day, 1800. Offered him some spirits to drink, but he preferred a glass of wine, which I gave him. Am the more positive of the circumstance of lending the screw to Parker because he broke it in using it. He never lived but 1 year in Pelor's house, and from that time to the present I have been on the same terms of intimacy with his family. Think it impossible that he could have been absent from town any time without my knowing it. Never knew him to be absent more than a week while he lived at Pelor's house. James Redding. Have lived in this city a number of years and have known Parker from his infancy. He was born at Rowe in Westchester County. In the year 1800 he lived in Captain Pelor's house. Saw him then continually, and never during that year knew him to be absent any length of time. Particularly remember that while he lived at Pelor's house, sometime in the beginning of January 1801, I assisted him in killing a hog. Louis Osborne. Have been acquainted with Parker, the defendant, for the last 4 years. Have been one of the city watch, and from June 1800 until May 1801 he served on the watch with me. At first he served as a substitute, that is, one who, in case of the absence of a regular watchman, supplies his place. Remember that a few days after Christmas in 1800 he was placed on the roll of the regular watch in the room of one Ransom. Am certain as to the period, because that is the only time I ever served on the watch, and he was stationed while on the watch with me at the same post. Am certain that the defendant is the person with whom I served on the watch. During that time he was never absent from the watch more than a week at a time. In rebuttal, Moses Anderson. Have lived at Haverstraw in Rockland County since the year 1791. Know defendant well. He came to my house in the beginning of September 1800. He then passed by the name of Thomas Hoag, worked for me 8 or 10 days, and from that time until the 25th December following, passed almost every Sunday at my house. During his stay in our country, I saw him constantly. If he is Thomas Hoag, he has a scar on his forehead, which he told me was occasioned by the kick of a horse. He also had a small mark on his neck. He also had a scar under his foot, between his heel and the ball of his foot, occasioned, as he said, by treading on a drawing knife. That scar is easy to be seen. His speech is remarkable, his voice is effeminate, and he speaks quick and lisps a little. He supped at my house the night of his marriage in December 1800. Have not seen him until this day, since he left Rockland. This is between 3 and 4 years ago. Am perfectly satisfied that he is Thomas Hoag. On examination, it appeared that he had the marks on his forehead and neck, and also the peculiarities in his speech. Lavinia Anderson. Corroborate the testimony of last witness, my husband, in relation to the identity of defendant Thomas Hoag. I washed for him, and there was no mark on his linen. During his stay at my husband's house, the person who passed for the defendant's brother, having cut himself severely with a scythe, complained much of the pain. When Thomas Hoag told me he had been much worse wounded, and showed the scar under his foot, about a year ago, after a suit in which the identity of defendant's person came in question, had been brought in the justice's court in this city, I was here, and having heard much said on the subject, was determined to see him and judge for myself. Accordingly, went to his house, but he was not at home. Then went to the place where I was informed he stood with his cart, and there saw him lying in it with his head on his hand. In that situation I instantly knew him, and spoke to him when he answered me, and I immediately recognized his voice. It was very singular. It was shrill, thick, hurried, and something of a lisp. Hoag had also a habit of shrugging up his shoulders when he spoke, and this I also observed in defendant. He then said he had been told I was coming to see him, that it was surprising people could be so deceived, and he asked me if I thought he was the man. I said I thought he was, but would be more certain if I looked at his forehead. I then lifted up his hat and saw the scar on his forehead, which I had often seen before, and he then told me it had been occasioned by the kick of a horse. It is impossible I could be mistaken. The defendant is Thomas Hoag. Margaret Secor. About 4 years ago lived in Rockland with my father, Moses Anderson. Defendant. Hoag came to our house in September 1800 and remained in Rockland 5 or 6 months. He had a scar on his forehead. He used to come every Saturday night to my father's to pass Sunday with us. Used to comb and tie his hair every Sunday, and thus saw the scar. About 2 years ago I married, and came immediately in this city to live. After I had been here a fortnight, was one day standing at our door, and heard a cartman speaking to his horse, and immediately recognized the voice to be that of Thomas Hoag, and, upon looking at him, saw defendant and instantly knew him. As he passed me he smiled and said, "How d'ye do, cousin? How d'ye do, cousin?" Next day he came to our house and asked me how I knew he was the man. I replied that I could tell better if he would let me look at his head. Accordingly, I looked and saw a scar upon his forehead, which I have often remarked on that of Hoag. After I had seen in the street, mentioned it to my husband, who told defendant of it, and my husband brought him to the house. Am confident he is the person who passed at Rockland as Thomas Hoag. James C. Core. Have been married about 2 years and a half, and brought my wife to town about a week after our marriage. Knew Hoag in Rockland, and have repeatedly seen him there. And when I saw him at our house in town, I thought him to be the same person. My wife had mentioned to me that Hoag had a remarkable scar on his forehead, and when he was at my house, I saw the scar which she had described on his head. Nicholas W. Conklin. Live in Rockland County and know the defendant. His name is Thomas Hoag. Cannot be mistaken in the person. He worked a considerable time for me, and during that time ate at my table. He was a stranger, and understanding that he was paying his addresses to Catherine Secor, I took a good deal of notice of him. Thought him a clever fellow. He lived in a house belonging to me. When I saw him at this place, I knew him instantly. His gait, his smile, which is very peculiar, and his very look is that of Thomas Hoag. Have endeavored, but in vain, to find some difference in appearance between the defendant and Hoag. Am satisfied in my own mind that he is the same person. I think he is about 25 or 30 years old, and had a small scar on his neck. Michael Burke lived in Catherine Street and formerly lived in Haverstraw. I saw the defendant there several times before and after his marriage in December 1800. Am as well satisfied as I can be of anything that he is the same person I saw at that place. About 2 years ago, and at the time of the Harlem races, I met him in the Bowery, when he spoke to me and said, "Am I not a relation of yours?" I replied that I did not know. He said, "I am. I married Katie Secor." Cross-examined. Admit I had a quarrel with defendant by reason of having called him Tom Hoag, that the above conversation was after the trial in the Justice's court. Abraham Wendell, in the latter end of the year 1800, knew Thomas Hoag at Haverstraw, was intimate with him, and knew him as well as any man, have worked with him, breakfasted, dined, and supped with him, and often have been at frolics with him. Defendant is the same man. Have no doubt whatever about it. About a year ago was in this city, and was told by some persons that Hoag had beaten the Haverstraw folks in a suit wherein his identity was in question. Told him I could know with certainty, and they said they would send him down. Was on board my sloop, saw him 100 yards off, coming down the street, and instantly knew him. He came up to me and said, "Mr. Wendell, I am told you will say you will know me." I replied, "So I do. You are Thomas Hoag." Am as confident he is the person as I am of my own existence. Sarah Conklin, live in Haverstraw. In December 1800, a person calling himself Thomas Hoag was intimate at my house and called me aunt. Am sure the defendant is the same person, and never can believe that two persons can look so much alike. He talks, laughs, and looks like Hoag, whom I would know among 100 people by his voice. The defendant must be Hoag. Gabriel Conklin. Thomas Hoag was at my house at Haverstraw often in September 1800. Defendant must be Thomas Hoag. He had a scar on his forehead and a small scar just above his lip. The defense again. James Jure. Have known Joseph Parker, the defendant, 7 years, and have been intimate with him all that time. We worked together as riggers until he became a cartman. Knew him when he lived at Peller's house, and never knew him absent from the city during that time for a day, except when working on board a frigate about a week at Staten Island. In 1799, he hurt himself on board the Adams frigate, and then went to his father's in Westchester County and stayed near a month. He was very ill when he left town. Went with him and brought him back. He was not quite recovered. Recollect perfectly of Parker and others passing Christmas Eve at my house in the year 1800, when he lived at Peller's house. Susanna Wendell. Have known defendant 6 years. He married my daughter. When he lived in Peller's house, his wife was ill, and I visited her often, and saw him there almost daily. He had never been absent from this city more than a week since his marriage, excepting the time when he went to his father's at Westchester. Magnus Beekman. am captain of the city watch of the 2nd District, and am well acquainted with defendant Joseph Parker. He has been for many years a watchman, and, as such, has constantly done his duty. Upon recurring to my books, where I keep a register of the watchmen and of their times of service, I find that he was regularly upon duty as a watchman during October, November, and December 1800, and in January and February 1801, and particularly he was upon duty 26th December 1800. It was agreed by the respective counsel that the prisoner should exhibit his feet to the jury, that they might ascertain whether there was that scar which had been mentioned by several of the witnesses for the prosecution. Upon exhibiting his feet, no mark or scar could be seen upon either of them. The jury, without retiring, found a verdict of not guilty. End of section 48.